Yes, hand over the slips.
But may I have Malus kindly leave to mention a matter, Malus? I'm praying for leave to file this writ petition with leave to short serve. The urgency is the tender has been floated for inviting bids for.
If granted tomorrow.
I'm great.
Lordship,
Upgrade.
Lordship, for requisition for transmission the file from the circuit bench to the principal bench, your Lordship. This is a principal bench matter which is mistakenly taken up by the circuit bench, and the interim orders stand till 30th.
Hand over.
Lordship only prayed that
Hand over the slips. Slips hand over.
item 30.
Mr. Bhattacharya, hand over the slip.
Yes, matter is in the list, my lord.
Upgradation.
My lord, if you lordship be kind to take this matter on tomorrow because the person is in deathbed.
Right, upgradation, hand it over. It will appear as an upgraded matter tomorrow.
Lordship, my matter is
Can only
appearing as an upgraded matter today as item 32. Lordship, the sale is tomorrow. In case it is not called up today, may I pray that it be taken up as a top matter tomorrow? The sale is tomorrow.
remind me before I rise and give a notice to the other
Lordship.
side. If so necessary, then
I'm
we'll
great.
please hand over. Mr.
My lord, availability of service is also ready. Matter is appearing in the list.
Very well.
Your Lordship, this is for upgradation item number 119.
Right, upgradation handover.
It's very urgent, Your Lordship, because on the 50th, it's for appointment
Only
of a
appearing the
special-
upgraded matters list, no further.
It is, it's extremely urgent because
Follow the list.
yes, it's for appointment of a special public prosecutor, Your
I hope
Lordship.
you
The
get
matter
my
will be taken
point.
up on the 15th in the lower court, Your Lordship.
Whatever I said, yes. Next, call on this. Call on.
We mention item number
No further
one.
mention.
To
I've given enough time for mentioning. No. Yes.
we mention item number one for non-prosecution.
My lord, I am for the petitioner. My lord,
Don't want to
for
proceed.
information. Non-prosecution.
Learned counsel for the petitioner submits that the petitioner does not want to proceed further with the writ. Accordingly, WPA 19560 of 2023 is dismissed for non-prosecution without any orders to cost. Interim
lord,
order, if any,
communication
stands.
may be kept on record.
Interim order, if any, stands automatically vacated. Written instructions filed today be kept on record.
My lord, I am for the state respondent.
Deeply obliged, my lord.
We mentioned at the time.
Item two.
Yes,
Well,
Mr.
I am
Court.
for the respondent, my lord. My lord, all on a sudden I found that it is.
It is
I am for the state respondents.
কে mention করে?
Who is the
Petitioner নেই।
Instance,
God instance এ
God
মামলা
instance?
Who is Srikumar Chakraborty?
Kumar Chakraborty is the petitioner, I find. Learned advocate of
এটা
the
দাও ওনাকে।
শ্রীকুমার চক্রবর্তী ও আচ্ছা আচ্ছা রীনা দত্ত petition.
advocate on record.
Who's as advocate under?
I do
Well,
not
this
know.
is for the
I am the
petitioner's
respondent.
advocate on record.
I am the respondent, 5 and 6.
Although the petitioner mentioned the matter for inclusion as to be mentioned, comma, when the matter is called on for hearing, none appears for the petitioner, although the respondents are represented through counsel, full-stop, let the matter go out of the list.
I love Lester, my lord. I love Lester.
Next.
Item three for release.
What is the matter about?
Your lordship,
Of the state.
learned counsel Sukanta Chakraborty is appearing in this matter.
Released on personal account with liberty to the parties to mention for assignment before a coordinate bench.
Much obliged.
Item four for non-prosecution.
Lordship, item number 2. Just I
Four, who is appearing?
I appear on behalf of the CSC in this matter.
Who is for the petition?
Item number 4, non-possible.
Learned counsel for the petitioner submits that the petitioner does not want to proceed further with the writ petition. Accordingly, WPA 24359 of 2023 is dismissed for non-prosecution without any orders to cost.
Item number 5 also.
5 same one.
I also appear.
WPA number
Item
will
five.
be different. 24361.
I'm grateful. My lord, item number 2.
No, 2 has been called on already. Whatever.
Just a minimum.
No going
Item,
back.
item six
Yes.
for non-prosecution.
My lord, I am for the respondents in this matter.
Don't want to proceed. Oh, same order. Learned counsel for the petitioner submits that the petitioner does not want to proceed further. This is for non-prosecution without an order to cost. Interim order, if any, stands vacated. Written instruction filed today be kept on record. 6 also same. Oh, this was 6. Right.
Top matter, item 7 and 8.
Yes.
But 7 I appear for the.
Yes, Mr. God.
I am for the respondent
in this matter, my lord.
Kindly see my lord's order.
8 I appear.
Yes.
Kindly see my lord's order of 17th of October.
কিছু নেই, just doing without prejudice. বলে দিতে চাও, বলে দিতে।
Well, the direction was on us to, my lord, communicate the survey report and the addendum before the closure of the, before the beginning of the vacations. We have done that, my lord. And
But
thereafter, my lord,
survey report has been communicated. We just, my lord, want to bring this survey report on record for my lord's kind record. My lord, if your lordship kindly sees in the surveyor's report dated 30th September, which is starts at page 5. Please come to page 21. Your lordships will find that the surveyor had recommended 69 lakhs, 48,931. And Lord, they have prepared an addendum to this report, which is starts at page 25 and Lord, at 27. Lord, this is reduced to 34 lakh 36,000. Now, Lord, without prejudice to our rights and contentions, Lord, we don't mind if this money is released to us. And Lord, we will seek, Lord, appropriate remedy before the appropriate forum for the difference. Because 2 crore 75.
Your grievance in the writ petition was that the insurance money was not being
not being processed.
Not processed.
And disbursed. And they are not giving the surveyor's report.
They can be directed to disburse this amount to you with liberty to you to take up the matter if you have any dispute before the appropriate forum.
Appropriate forum.
In both the matters.
But may I only submit this, my lord? Here, the principal grievance was that, my lord, despite prolonged period of time, my lord, the IRDA guideline sets a timeline within which the survey report is required to be, my lord, communicated to the insured. And that despite that timeline having elapsed, the report was not being communicated to them. Lordship was accordingly pleased to direct, my lord, that the report be communicated to them before the vacation begins. And that, my lord, there is a period of 30 days within which the insurer is required to consider and make an offer of settlement. So, my lord, lordship directed that on the 16th of November, the consideration should be completed. So, we have accordingly, my lord, made an offer of settlement. We have complied with your lordship's order in toto by furnishing them a copy of the survey.
Admittedly, you offer this amount, 34 lakh and odd.
Lordship, there are, for the JW Marriott unit, my lord, 2 crore 17 lakh 25,504. There are 2 petitions before your lordship. One is with regard to the residential unit, which is in the JW Marriott compound, and one is with regard to the hotel facade. So, my lord, we have
for item number 7, 34 lakh and odd is the admitted amount.
Now, my lord, the agreement, the insurance agreement has an arbitration clause. Says that if they are not happy with the settlement that is offered, my lord, they may go in arbitration and challenge that. Now, my lord, if they give us a no-claim voucher or that they are accepting this in full and final satisfaction, we will disburse this.
So, this will not be in full and final satisfaction. This will be directed to be paid by you because you admit this amount. Obviously, they admit this much.
Yes.
So, if they have any grievance regarding the other the amount being enhanced or some other grievance, they will.
My lord, perhaps your lordship's order is not necessary for that, my lord. If they write saying that they are accepting the offer,
necessary in view of the stand taken by you.
My lord,
because you say that full and final settlement, you will claim that.
That is, my lord,
for that an order of court is required.
Very well, my lord. We have made this offer. If they accept, it's no difficult.
When it counts, what is the amount in the in item number 8?
Kindly have a look at that offer, my lord. After, my lord, this report which my learned friend has given, my lord. My lord, there's a similar report apropos, my lord, the hotel.
Right.
That, my lord, these are, my lord, my learned friends appearing for Vivara residence, which is 34 lakh 36,000. Similar, my lord, addendum, my lord, given in our case, where it's 2 crore 17 lakhs 25,504. That addendum has been accepted by them, and they have said, now please give your in full and final settlement, kindly give this and give a discharge voucher. My lord, this is, my lord.
I didn't have this document.
That is the procedure, my lord. The discharge voucher.
Yes, now, my lord, I want to show, my lord, the stand which my learned friend is taking.
So, approved amount is same for both.
May I only say?
No, my lord,
different.
My lord, my lord, 2 crore 17.
Yes.
Your lordship will find, my lord, the first.
Oh, that's right.
And in item 7 is 34 lakhs.
Now, my lord, my learned friend says, my lord, our thing is, you have to give this to us. Whatever balance is now, we'll go in the appropriate forum. There's an arbitration clause, we'll go on. My learned friend says, no, there's no need for that. My lord, that's exactly what the insurance regulatory authority said can't be done. Because they want a discharge voucher, then they'll say, now you can't claim anything. My lord, the insurance regulatory, my lord, authority, my lord, kindly has said. Now, kindly see, my lord, this is the circular of 2015. discharge voucher in settlement of claim. Insurance companies are using discharge voucher for settlement intimation or somehow so that claim is closed and does not remain outstanding. Our authority has been receiving complaints from aggrieved policyholders. Instrument of day is being used by insurers in judicial fora with a plea that full and final extinguish their rights. The notes that insurers need to keep them in order. It is also necessary to note that insurers shall not use the instrument as a means of
Yes, yes. Seen it, Mr.
So, my lord,
So I'll keep this on record and that
Yes.
will be easy. You have got a
I was only saying, my lord, order may not be necessary. If they write saying that they are accepting this without prejudice to their rights, then also the disbursement will be made. For the
Have you
discharge,
got a copy of this, Mr.
yes,
Shah?
I have been handed up a copy, my lord. If
Read the
I have
ordering
read.
portion of this.
I have read, my lord. I'm not trying to use this as an arm twisting mechanism, of course. I'm just saying order
No,
may
you
not
are
be
not. You are
necessary.
not.
my lord.
Definitely you are not, but your client may. Learned counsel for the learned senior counsel appearing for the petitioners in both the matters, comma, which arise out of allegations regarding non-disbursal of insurance dues by the respondent company, comma, submit that in the meantime the insurance company has served copies of a survey report and an addendum disclosing that certain amounts have been admitted as insurance claims by the respondent. Puts up, it is contended by learned senior counsel for the petitioners in both the matters that the said admitted amount be disbursed to the petitioner with liberty to the petitioners to challenge for enhancement of the sum, comma, if the petitioners so deem fit and are entitled to before the appropriate forum. Push of learned counsel for the insurance company submits that an order of court may not be necessary in that regard. Push up next para. However, comma, learned senior counsel placed reliance on a circular dated September 24, 2015 of the Insurance Regulatory and Development Authority of India, which mentions that similar circumstances has arisen in which the insurance companies, comma, taking advantage of the settlement intimation voucher, comma, have been taking the plea that the payment was in full and final settlement of the dues. Accordingly, the said regulatory authority has advised by the said circular that where the liability and quantum of claim under a policy is established, comma, the insurers shall not withhold claim amounts, semicolon. However, comma, it should be clearly understood that execution of such vouchers does not foreclose the rights of policyholder to seek higher compensation before any judicial fora or any other fora established by law. Full stop, next para. Hence, comma, in consonance with the said circular, comma, WPA 10322 of 2023 and WPA 10325 of 2023 are disposed of by directing the respondent insurance company to disburse the admitted amounts respectively of rupees 34, 36, 345 and rupees 2, 17, 25, 504 in terms of the report filed by the insurance company to the respective petitioner at the earliest, comma, positively within a fortnight from date, pushed up, next para, upon such payment being made, comma, the petitioners shall issue receipts regarding such amount, pushed up, however, comma, it is made clear that such payment or the issuance of such receipts by the petitioners shall not preclude the petitioners from seeking further enhancement of the amount of insurance claim over and above that paid by the insurer before the appropriate
My
forum.
lord, may I make one submission?
Yes.
I didn't want to interrupt your lordship while lordship
No, no,
was
please.
dictating the order. Only two things, my lord. The regulation that my learned senior friends have handed up also says that, my lord, the discharge voucher is required to be signed and submitted.
They'll
my
give a
lord.
receipt.
And that will not, my lord, preclude them from raising further claims in arbitration if necessary. So, my lord, the discharge voucher is required to be submitted. That is one thing, my lord.
I've
And
said receipt.
if I was only,
receipt যেখানে বলেছি receipt stroke discharge voucher.
if your lordship,
To
my
the
lord, since-
extent of the money paid.
Yes, obvious.
if I may, my lord, instead of direction, like I was saying, my lord, maybe direction is not required. If your lordship will allow us 1 day, I may take instruction. Perhaps we can, my lord, consent to disbursing this amount.
Not as to cost urgency. No, much.
May I also put my supplementary affidavit?
আচ্ছা, very well. প্রথম লাইন একটা দিয়ে দেবেন, supplementary affidavits filed by the petitioners in both the matters today be kept on record. আচ্ছা, great.
Item 9,
What?
Please,
I passed an order in open court. No,
please, my lord,
no, no,
actually, I'm just one.
no,
Just one.
no. Call on the list, please. Please disturb the court.
Item
This is
9.
called on. What is happening? No, I say it. Not like this. Yes.
All right, item 9, appeal for the respondent number 1.
My lord,
My
in
lordship
this
will
matter,
Lordship will excuse me on the last occasion, my lord, HON'BLE was not appealed to appear before your lordship.
So what?
So I was not there.
my lord, in item 9, before my
Allows
learned,
me to make. I have gone through the order passed by your lordship.
Lordship,
What did he say?
that matter pertaining to section 71 of the RERA Act.
my lord,
But
that matter,
I'm ready, lordship. Will
my lord,
appear.
before my lord, my senior friends start, my lord, I must admit a default on my part, my lord. The argument that I had made, my lord, it turns out, my lord, was also made before the Honorable Supreme Court, and the Supreme Court has negated my argument.
And not only, I'm sorry to say,
My
not
lord,
only that,
I'm,
not only that, your
I
lordship-
apologize, my lord.
Lordship, if your lordship goes to your lordship's order, the entire scheme of the act is different. But he must have made a mistake. The entire section 71 does not apply here at all.
Because
লর্ডশিপ পড়েনি, ও কি বলে আজকে কি তাহলে কি বলবো?
আমি অন্য একটা অল্টারনেট আর্গিউ করেছিলাম আগে, ওটাই জাস্ট
এটা কোনটা?
section
না আমি 24 তে রুল 24 করেছি।
রুল না সেকশন? রুল 24?
রুল 24। ঠিক আছে।
Yes. So what do you propose to do?
My lord, here, my lord, I ran, my lord, 2 cases, my lord. Number 1 was section 71 violation. That, my lord, has been decided by the Honorable Supreme Court. I'm carrying that decision as well, that section 71 will not apply in respect of an amount of refund that is ordered by the authority. The authority has the jurisdiction. It's settled, my lord. I am not pressing that point, my lord. My lord, I'm sorry, I should have done that research beforehand, my lord. I apologize on that. My lord, the other ground that I had raised, my lord, is the order, my lord, itself could not have been passed on account of violation of Rule 24 of the rules. I had cited that rule, my lord, that the Evidence Act, this is not similar to, let's say, my lord, an arbitration proceeding, or even the appellate tribunal is exempted from application of the Evidence Act. Here, my lord, the Evidence Act has been specifically made
Are
applicable.
affidavits required in this matter, or most of the documents are annexed?
My lord, affidavits will be required. দরকার নেই। Because I tell you, Lord, I tell you, sorry, I tell you, Lordship, my lord,
Documents annexed are
no,
sufficient.
I'll tell you, Lordship, I have today come prepared on the basis of the submissions made by him. Section 71 and
So
everything.
I was thinking about this. I mean, come ready with your short written notes of arguments
Very
and
well.
keep it on a date.
No, in
Make
that
your short
case,
arguments.
in that case, let him out, my lord, delineate his argument so
yes.
that we can.
Yes.
I am ready with the other point of the argument which my learned friend
It's
has
the only point
taken,
which remains.
Please.
Lordship, he has shown regulation.
That is actually the other point, whatever it is not.
No,
in
what
the
she say, let her
Not
complete.
in the read petition.
Let her complete.
এটা বইটা
Yes.
The other point.
The other point হচ্ছে যে other point is whether Evidence Act is applicable.
Yes.
Now and that whether on the basis of the only the complaint because another order of penalty has been passed because of non-registration of the agreement. So that power for penalty, Lordship will find in section
So, Ms. Lahire, we'll hear the arguments in a nutshell. I want to expedite these matters. Come ready with a short written note
Yes,
of
yes.
argument both sides.
My lord,
Indicate what you will argue. Just indicate
Yes.
what.
my lord, I can serve a copy of my written notes as well.
Do
if
that.
you-
Do
I'll
that.
do
No,
that.
no, the
And
point
when should I
about-
keep it? When should I keep it?
My lord, any day, my lord.
How
next-
soon can you serve the copy of written notes on them?
My lord, gives me till Wednesday, my lord, Thursday next week, my lord, can it be on Friday? If it commences to, my lord, I'll serve by Thursday.
By Thursday, you'll serve your copy,
Yes, my lord.
and you can come prepared with that on
Whenever your lordship says.
by next
Friday.
Oh, that is too early.
Tell me a date.
by next Tuesday.
আরে না না না
Very
ওরকম করিস না তো
Thursday,
তুই খুব
Tuesday.
fast।
Tuesday.
আজকে কত তারিখ?
Maybe on Tuesday week, Lord.
Very well, very well। আচ্ছা তুই তো পয়েন্টটা বল নেক্সট আর্গুমেন্ট দেবো
আমি বলে দিই। উনি দিয়ে দেবেন।
আমার পুরো আলোচনা
Oh, very
Yes, sir.
Upon hearing learned counsel for the parties prima facie, it transpires that the relevant documents have been annexed to the writ petition and exchange of affidavits is not necessary. Full stop. Accordingly, affidavits are not directed, and it is deemed that none of the allegations made in the writ petition are admitted by any of the respondents. Full stop. Learned counsel for the parties are requested to come prepared with their written notes of arguments on November 30, 2023, when the matters shall be listed under the heading upgraded matters for final hearing. Push up, learned counsel for the parties are also requested to exchange their notes of arguments in the meantime. Push up, preferably, the written notes of arguments proposed by the petitioners shall be served on the learned advocates for the respondents by. Oh, I'm sorry, that cannot be 30th. It will be returnable date 30th না করে December 5 করে দিন। যে সেন্টেন্সে কন্টিনিউ করছিলাম, preferably by November 30, 2023. He will give his written notes of arguments by November 30 to all of you. You will file a written notes on the next date. Both of you will file. It has been fixed on December 5th, upgraded matters.
Deep level. Lord, I apologize for not having that.
For? No,
For
no.
not having
I'm
that.
deeply
Put that in your written notes also. Not the apology, I mean the argument.
I'm deeply obliged.
Deeply obliged.
Mr. Bihani, you must use a filter to your voice from
Filter.
to Hede.
May I make one submission?
No.
Very
Next
good.
Item 10,
Yes.
Item 10.
Yes, please.
Leave was granted. I have served the notice to the GP as well as to
My lord,
email
my
to all the respondents.
my lord, I am with the instruction, lordship.
Yes.
Instruction পেয়ে গেছে?
Lordship.
Before opening, going to the records of this case, you shall just bear. Goes on. There is a scheme for Jal Jeevan Mission of the central government, and the state government has converted at Jal Sapna. Now, my lord, there is a work order issued by the assistant engineer, executive engineer, public health, my lord, the department, that for installation of mini pipe scheme, so that all the people of the area can get the household tap connection. My lord, that is on 5th April 2020.
Mini pump.
5th April 2023. That is a
Mini
work.
pump.
No,
Yes, mini pipe pump.
Pipe to water.
Yes, under the Jal Jeevan Mission, and the state government has said a Jal Sapna. However, now, my lord, work order has been issued. Now, the petitioner has been requested for donating, my lord, some land for installation of the said, my lord, the scheme.
Who are you? You are an application under the scheme. You are an
No, no,
applicant
no,
under
no.
the scheme.
I am not the applicant under the
You are the
scheme. I am
contractor.
the donor.
He donated
I-
the land
yes.
on which, my lord,
The-
we were supposed to lay the pipes.
That is under the scheme. There is a provision.
Yes. But your lordship kindly come straight away, page 27 first. A type copy, your lordship kindly come. Yes, 27A. My lord, I am reading.
Yes.
My lord, a request for registration. You may aware that the following parcel of land has been identified by the block administration for implementation of the newly sanctioned pipe water supply scheme. Landowner is willing to donate the land of the executive engineer subdivision by way of deed of gift. As directed by the executive engineer Tabluk division, the undersigned on behalf of the state government is willing to make a deed of gift willing owner immediately in connection with Jal Jeevan Mission. My lord, your lordship kindly see name of the owner is.
So you donate the land and you get that,
Yes.
and you get that water connection.
No, not only I am myself,
Others,
all the others. Now, my lord, your lordship kindly come. This letter was on 4th September 2023.
Right.
Next date, my lord, I have donated the land. Thereafter, the boring for the installation of the my lord, the line scheme started. Thereafter, your lordship kindly come page 41. One photograph I have. Yes.
Yes.
Mooring has started. Thereafter, on 19th, my lord, during the vacation, 19th, when the second time boring work will be started, at the instance of the executive engineer, they have said that all the work will not be there and all the materials which has been stacked, it will be transferred. Immediately, I objected to the police authority as well as all the authorities, including the DM, executive engineer, assistant engineer.
They did not want it to be done on your land.
But now, my lord, they want to shift it. They
Shift
want
it to where? To somebody else's land. How
My-
are you benefited by the gift? Are you benefited by the gift, or it's just a donation actually?
No, your lordship kindly see.
Under the scheme, do you benefit in any manner?
Because my lord, if in my land, I
If it is
shall be,
done.
yes, I shall be able to get the water, including all the adjacent people, they will be benefited. Now, my lord, I have donated the land. Now,
They
my
want
lord,
to shift it now.
no reason, nothing of the sort. They have stopped it, and thereafter they want to shift the materials which has been my lord, stacked here.
Shift to some other land.
Yes, ma'am.
Shift it to some other land. They want to do it on some other land.
That has not been disclosed.
So what is
Not-
your cause of action? If
Cause
they
of
don't
action.
want to use your land, they have to return the gift then. They gift it back to you.
Well, that it is not known to us. It is not known
What
to
is
me.
the relief you are seeking?
Well, what I am seeking, my prayer is very innocuous. Let my lord for in which land I have donated the land. Let my lord the scheme be materialized there, because work has been started there.
Yes, what do you say?
My lord, the like, scheme is, my lord, to, my lord, provide, my lord, the piped water supply, my lord, to every household, my lord.
Hmm.
The scheme, my lord, is, my lord, spread, my lord, over different blocks, my lord, of Purbo Midnaf. One of the blocks is the Bhagavanpur 1 block lordship. My lord, yes, we don't have any quarrel, my lord. Petitioner has donated, my lord, a piece of land, my lord, over which this scheme is to be carried on so far as this particular locality is concerned. We started the work, my lord. Now, suddenly there was, my lord, was a mass petition saying that one person named so-and-so was willing to donate his land. You did not use it, did not allow him to donate that. Suddenly you are using this particular person. Executive engineer requested this petitioner, donate your land. He gifted the land. You are working on his land. We will not allow that. There was a mass petition. Because of the mass petition, my lord, the second phase of the work, my lord, got stalled. Since, my lord, the entire scheme is for different blocks. So there is machine. We try to shift it and carry on the, my lord, work, my lord, to other blocks, my lord, because the entire, my lord, work order is for.
Is the water given to the person who donates the land special?
No, entire locality, my lord.
Do they get a special, something special?
No,
if
he
they
does
donate?
not. But we don't have any quarrel with him, my lord. Now there is, my lord, an endeavor.
It has started already. The boring has started. Finish it there.
Already started, my lord. But since because of this local problem, kindly, my lord, they have annexed, my lord, the executive engineer, my lord, has come up with this instruction. There is a local complaint, my lord. Kindly cease of the villagers.
Not to take his land, but take somebody else's land.
Yes, that is.
They don't water in the
so, my lord,
meantime.
they are trying
I
to.
mean, I don't understand this. This is peculiar of our state, probably.
Lordship. So, my
This
lord,
is absolutely peculiar to West Bengal.
Lordship.
Must
So,
be.
because of this,
They don't want water. They say that he has donated land. No, it should not be
Dog in-
planted there. Somebody else's land.
dog in the manger policy.
Not even that. They are the dogs themselves.
Yes. So, my lord,
They don't want water in the meantime. They want this boring to be shifted to some other person. Already he has donated the land. Boring has started.
yes.
What
Lord.
local standard do these people have? And
So, my lord, these people, my lord, they have already they lodged one complaint on the basis of which, my lord, the assistant engineer, video, they
what
are
is the underlying thing, Mr. Galit? What is the politics behind it?
Yes.
I mean, what is the
underlying
difficulty?
thing, my lord. So far, I get from this instruction
Yes.
that a group of person, they want Mr. X land to be taken. He is ready to donate. You accept his. Your executive engineer has asked this petitioner.
How will it make a difference to them?
My lord, it's their village, my lord, rivalry, it may be so whatever, my lord.
Regarding donation of land.
Yes, so that it can take place in my land. This is what I get from the instruction, my lord.
So what do you propose now?
My
Police
lord, here the instruction is very innocuous and my learned friend's prayer is also very innocuous.
I'm afraid of the word innocuous. What is
Yes,
the prayer?
we are not at all willing to shift it, but for the time being,
Yes.
since it's a hue and cry by the local villagers, they have already lodged one complaint, my lord. The local BDO, junior engineers, assistant engineers, they are trying to negotiate. My lord, in the meantime, what my learned friend is telling, that they're shifting all the machines from my place to some other, as because, my lord, the program is for the entire other blocks also. So, my lord, for that purpose, we were, my lord, willing to shift it to some other block so that the work in some other block also be carried on. But he did not allow it. No, you don't remove this machine from here.
Yes, he has donated the land. It has already started. His land has been damaged also for that
So,
boring.
may I kindly see the last paragraph, my lord, of the instruction.
Yes.
First page.
Yes.
Concerned assistant engineer, junior engineer, are in constant touch with BDO to mitigate the local problems so that stopped work can be resumed at an early date. So they are, my lord, in the process of negotiating with this local millers, bottlenecks, my lord.
Acha, what is your cause of action if it is
Well,
shifted
Your
to
Lordship,
somebody
kindly
else?
see. Well, page 27, 27A.
No, what is your difficulty if it is moved to, if it is, the rig is on somebody else's land?
Well,
Let it be done. They'll have to return the
well,
land.
Your
they'll
Lordship,
pay.
kindly see, just, Your Lordship, allow me to,
My lord, one
utter
thing,
one sentence.
in the representation,
Well, it has been identified by the block administration for implementation.
Suppose it is not done. What is your cause of action for that? How are you affected at all?
Well, I have donated the land. I shall be benefited along with the
You have
adjacent
donated,
place.
you have executed a deed of gift.
Yes, by registered deed.
yes, it has
By
been.
registered deed. But this letter, 4th September 2023, this is a request made by the assistant engineer. Your Lordship, kindly see. Requested the ADSR for registration. And it has been said that it has been identified by the block administration for implementation of my land. It is not the case that I have, it is the decision of the block administration.
We have accepted his.
Yes. Then,
But Miller, the war of attrition, Miller, kindly sees the complaint. He is from a different village. He is a different villager from a different village. Why his land will be accepted? Kindly sees
Right.
the language of the complaint, Miller, the first paragraph, second page, Miller.
yes.
The villager named Gopal Das agreed to give.
Well, Your Lordship,
Chief.
kindly see on
So the
instruction.
villagers could not feel the problem of drinking water.
He also, my lord, the
Back minute. But somehow we noticed that without
How long
information,
should you wait for your junior engineer to resolve the issue?
may wait for a fortnight or so that I can talk to the BDO also. Because since it is a leave matter, Millard, I could talk to the executive engineer. So he has sent me an instruction. So since the executive engineer says, Millard, that the negotiation is going at the video level. So if your lordship kindly gives me some time so that, Millard.
The problem arisen in the present case is peculiar. Full-stop.
Well, this is
The petitioner donated a land under a scheme initially floated by the center and then by the state, comma, under which piped supply of water is to be given to villagers.
household tap connection. Your Lordship,
Full stop. Next para, such supply is to be given via household tap connection.
connection.
Full stop. Next para.
Rural people.
The petitioner, comma, under the said scheme, comma, donated his land duly to the respondent authorities, after which the respondent authorities started boring work on the land for the purpose of the scheme. Full stop. However, comma, subsequently the petitioner alleges that the respondent authorities stopped the work and are seeking to shift the apparatus and the materials from the petitioner's land to somewhere else. Push up. Next para, learned counsel appearing for the respondent authorities files a report issued by the executive engineer, Tomluk Division, PHE department, which presents a peculiar scenario. Full stop. The local people in the vicinity, comma, allegedly, comma, are adamant that they shall not take the water supply from the petitioner's land, comma, since the petitioner is apparently from a different area, but a local villager is agreeable to donate his land on which the boring work should be done. Full stop. As per the report, comma, the concerned assistant engineer, comma, junior engineer, etc. are in constant touch with the block development officer, Bhagwanpur 1, and the SDO EGRA to mitigate the local problems so that the stopped work can be resumed at an early date. Full stop. The problem is rather peculiar and reminds one of Kalidas, the poet of lore, comma, who was cutting the branch on which he was sitting. Full stop. The local villagers, comma, it is not understandable as to why, comma, are insisting that even at the cost of their getting water supply, comma, the land of the petitioner should not be used, but some other local person of their choice ought to be utilized. Full stop. In any event, comma, forcing matters would not help at this juncture. Full stop. Ultimately, in the event the petitioner's land is deserted, comma, obviously the respondents have to compensate the petitioner by executing a counter gift deed and restoring the land to its original position. That too upon giving sufficient explanation for doing so. Full stop. However, the problem may be resolved if in the meantime the concerned officers of the respondent authorities are able to resolve the issue. Full stop. Accordingly, the respondent number 5, that is the district magistrate Purbo Medinipur, is directed to interfere in the matter and make an attempt by involving all concerned, to resolve the issue at the earliest. Full stop. The respondent number 5 shall file a report in that regard on the next returnable date. Full stop. The matter shall be listed next under the heading upgraded matters on December 7, 2023. Full stop. An advance copy of the report shall be handed over to the learned advocate for the petitioner to comment on the same.
May this report be kept on record, Lordship.
My lord, one prayer I will make to add, my lord. There is a, my lord, the mass petition that they want that this scheme may be materialized in the self-same place.
Let the district magistrate resolve.
My lord, liberty may be given to file supplementary affidavit annexing this.
On the prayer of the petitioner, the report filed today by the respondents be kept on record. Full stop. Liberty is given to the petitioner, on the prayer of learned advocate for the petitioner to file a supplementary affidavit annexing a purported mass petition supporting the installation of the boring rig on the petitioner's property.
And one prayer to add the local Gram Panchayat also.
No.
I have, my lord, in the meantime, they will not shift the materials and all this.
The respondents are restrained by an order of injunction from shifting the apparatus already installed on the land of the petitioner till December 22, 2023 or until further order, whichever is early.
Deep law. I want to donate the land.
11.
But affidavit of service kept on record.
Yes.
11, my lord, I am for the petition led by Mr.
Before
Anand.
my learned friend starts, my lord, we are the answering respondents, but we have received the brief just few moments back.
Nothing doing. When did you serve?
Yesterday.
My lord, yesterday we have taken leave, my lord. My lord, Mr. Haldar is in
Can be taken
lakes,
up
my lord.
tomorrow, my lord. We will take up instructions, my lord.
Mr. Haldar? Which Mr. Haldar?
Anindo Haldar, my lord. My
Yes.
lord, only short passover, my lord.
Upgraded matter, no passover. Then it goes down.
But let it be done kept tomorrow, my lord. Then.
Move it then, right now. Upgraded matter, no time.
My lord,
Other matters are, I cannot add other matters as upgraded matters
only short
because of
passover,
these
my lord.
matters.
Only-
No. Either you start now or it goes down.
I am not carrying the brief right now. my
An
lord.
adjournment is sought by the petitioner when the matter is called on for hearing. Full stop. Since the matter is appearing under the heading upgraded matters, it is unfortunate that the petitioner himself prays for time. Let the matter be listed tomorrow under the usual heading and not under the heading upgraded matter.
My lord,
Next
my
matter.
work order has been cancelled, my lord. My lord.
Next matter.
Item 12.
Yes.
আগেরটা
আপগ্রেডেড ম্যাটার যেটা বললাম না, আপগ্রেড গুলো টপ করে দিন, টপ হিসেবে ছিল। আপগ্রেড ম্যাটার যেখানে বলছি ওখানে টপ ম্যাটার, ইট ওয়াজ অ্যাপিয়ারিং এজ আ টপ ম্যাটার। ইয়েস,
my supplementary report on affidavit.
ইয়েস। ইউ হ্যাভ ফর রেসপন্ড নাম্বার?
I am, my lord, the added
FCI.
respondent, FCI, my lord. My lord, desire to know the various reasons behind my lord, the curtailment of certain amount.
I've forgotten the matter. What is the matter?
The matter was, my lord, actually the matter is a dispute between the petitioner and CWC,
You
Central
are for the petitioner? Yes, what is the matter?
Central Warehousing Corporation.
The dispute is regarding the payment, your lordship. Initially, we have
For the liability between the FCI and the central.
we have done the work for the CWC, your lordship. After we came before this, your lordship, the CWC took a stand that as the FCI has hold the payment to a certain extent, that's why they're not being able to pay us that amount.
So you are filing that
The exact amount, disclosing the exact amount that we have curtailed, my lord, from the bill of CWC on account of height. There were certain anomalies.
This is the second
on
report they're filing, your lordship. Initially, they filed a report.
Yes, yes, I understand. What is
So,
the amount? Where is the
the
amount?
13 lakhs and odd, my lord, 13 lakh
Where do I get it?
83,000.
Where do I get it?
My lord, in the report, my lord, you have mentioned. Report is at running page number 5, my lord.
It starts from running page number
Where
5.
do I get the amount?
My lord, the amount is on running page number 6, my lord.
Right.
The first paragraph, my lord, the fourth line from the bottom, my lord. First paragraph on page number 6, my lord. 13,
Also the last paragraph, last bullet.
yes, my lord, also the last, yes. One was the last paragraph. This is the amount, my lord, we have cartel from CWC. We have only concern with CWC, my lord. So we have certain issues regarding height, and that we have disclosed in our running page number 7 as well in the bill, my lord. And we have also sought clarification from them why what was the reason behind this anomaly and whether you can correct it or not. So far, they have not come up with, my lord, any clarification or explanation so far. It is regarding, my lord, the stacking of food grains, the stacking
Yes,
of
yes.
food grain.
The
my lord,
rest of
correct.
the amount, Mr. Chaudhary, you have to pay then.
My lord, I have
Deducting these 13
I
lakh.
have just received the report, my lord. May I go through it at least once?
When did you give a copy?
I just received it now.
Now it is given.
But there were disputes with regard to few heads. That was that we were
Learned
not
counsel for the FCI files a report today. As per previous direction, footstep. It was expected that a copy thereof would have been served on the other parties sufficiently in advance to enable the court to decide the matter today. Footstep. However, the same having not been done, comma, on the prayer of learned counsel for the CWC to enable him to get prepared on the report and take instructions, the matter is adjourned till
My lord,
week, 1 week. The matter is adjourned till December 23rd till December 1, 2023, when it will be listed under the same heading. Footstep. In the event the CWC or the petitioner seek to use a rejoinder to the report filed today, they will be at liberty to do so on the next returnable date with an advance copy to the learned advocate for the other parties, including the FCI.
Lord, may I make one request to your lordship, Lord?
Yes.
Lord, earlier this matter was appearing under the heading top motion.
No, update. Next.
I'm grateful to your lordship. Chalo.
13. 13, yes. Yes. Samanna, what is the matter?
I appear for the rest.
Lord, before taking to the brief, Lord, I intend to refer the scheme for a moment. One line from the scheme I like to show, my lord. Your lordship kindly allow me to see. Lord, your lordship kindly see the introduction part.
Yes.
Lord, during the 25th anniversary, that is Silver Jubilee year of independence, a central scheme for grant of pension to the freedom fighters and their families. I am stressing here, and their families from central revenue was introduced by the government of India. My lord, in that scheme, Lord, paragraph 3 defines who are the family members. I am drawing my lord's attention for the purpose of grant of Samman pension. Family includes, if the freedom fighter is not alive, mother, father, widower, and the unmarried daughters. Then, if the freedom fighter dies, the pension will go to the unmarried daughters. Here, my mother predeceased my father. My father was a freedom fighter. He, after commencement of the act, he applied for the freedom fighter pension. Pension was sanctioned. Just after sanction, before disbursement and receiving
You are an unmarried daughter. You are an unmarried daughter.
Yes, I am unmarried. Just before receiving, after sanction of the order,
it has been sanctioned.
Yes. Sanctioned in favor of the father. My father died.
No, in your favor, he's saying.
Yes.
Your favor also it has been
sanctioned in your favor.
I am coming, Milord. I am coming. He has sanctioned from 15.
You're coming, but coming where?
I am coming to the facts of the case. Your colleague, I'm not sure why he has in my learned field. Then I applied for the pension in terms of the scheme.
Yes.
There was nothing was done. I had to move a writ application in 2007, whereupon the writ application was disposed of by directing the concerned authorities to treat the copy of that writ application as a representation and proceed in accordance with the law. After that, they Lord, advised me to, as the, to approach before the dispersal bank and to file documents and there.
Your father was receiving previously.
No, he has before receiving
Before receiving the pension.
Your father never
I-
received the
No. Then, my lord, they issued a document that, if your lordship kindly come to page 26 for a moment, the relevant paragraph 3 and 4. Well, as per the ministry record, on the basis of the recommendation of the state government, sanction pension to C. Hare Krishna, my father, with effect from 1880, file letter number Atu. Well, unfortunately, my father died. The next page it had been mentioned, my father expired on 31st March 1980 before he could receive the Samman pension. So I have already directed to contact and file the affidavit to the authorities concerned. Not your next paragraph. Accordingly, I made representation. Nothing was done. I come to the writ application, writ court, and wherein writ court passed an order to, but I have forgot. After that order, they sought for the report as to the status of my. It starts from 2007. Ultimately, they sought for the report in 2015. In 2015, district magistrate forwarded the report. Yes, he is an unmarried, unemployed. Then, I had to come before this court. In spite of that, the same, nothing was done. This court, in the other writ application, directed them to grant the pension with effect from the date of the report of the district magistrate. On the basis of the same, they, sanctioned the pension with effect from 2015. Though I am entitled to have the same in terms of the scheme from 1980. In they returned the documents for the reasons that there was some anomaly, spelling mistake, that is in the name proper Aloka. Somewhere it has been named in ALAKA, somewhere it has been written as ALOKA. In ID documents, mainly all the ID documents, it has been meant as ALA.
Ultimately, what happened, Mr. Manna?
Ultimately, they have sanctioned that. They have returned the documents and sanctioned with effect from the 2015.
Which was according to the court's order.
Court's order. I say, that cannot be done.
Court's order is that binds you.
I am entitled to.
Show me the court's order which says it has to be from 2015.
Page 40, your can have it. Which is page 40, relevant portion is page 40. Government of India to dispose of the petitioner's entitlement to the pension upon treating the report of the district magistrate. Upon treating the report, that does not mean upon treating the report as an application. Here I am hunting.
As per the scheme, you are entitled from the date of the application.
From the date of the application, because my father did not get. In fact, from the date preceding the next date of the death of the father, I am entitled.
What you had applied when for the first time?
In 81, my father applied. I need not apply. I can't apply. There was a cut-off date. From my father's application, they have taken a plea. They have taken a plea that in the meantime, 2014 guideline has come, which has been deprecated by the division bench on this court in respect of the application of 1981. The scheme of 2014.
Please show me the relevant portion of the scheme, Mr. Manna. That the date is the date of the application. From this scheme.
I have. But that is in introduction, your lordship can come.
Your lordship kindly ask my learned friend to produce it when the application has been filed.
Yes, when was the application?
Application of my father.
First
It was
application.
81.
Not father, claimant, dependent.
Lord, my father applied under the 72 scheme.
Let us see from the scheme.
Scheme, I
Is
have
the date
handed
from
over.
which the
Lord, now the 78 scheme has been 72 scheme has been renamed as 80 scheme. The scheme says that the central interest, the scheme commenced from 15th August.
did you apply before
Your lordship.
no, did you before the district magistrate? Did prior to that did you apply?
Yes.
When did you first apply? You, not your father.
When intimating the death of my husband, my father, I applied to the authority in 2007.
Where is that? You must have annexed that.
If your lordship will find, the order of the earlier writ at page, 25. 25, And in the constitution, it has been also mentioned the application, the representation that is such and such, and order is there. At least, if for argument's sake, if I take that I have not applied, but this court says, let the writ application be treated as a representation. So at least I have applied on.
At least from 2008 it should be.
No, order is 2008. Yes, it should be. But I am on the other point. Whether that can be treated.
As
Yeah,
per the
from the
scheme,
date of the
as per the
application,
scheme,
where
what is the
can we
date? As per the scheme, Mr. Manna, what is the date
Date
from which it is? Show me from the scheme.
as per the scheme.
My lord,
is
lordship,
not-
kindly,
Yes, Mr. Bhattacharya, what does the
lordship,
scheme
kindly
provide?
come to my opposition.
But I am coming. That is
No, you are not coming there. You are
Page
coming
11,
eternally.
on page
So I
11.
am asking you a specific question, Mr. Manna. Let us not waste time. Show me from the scheme
No, I
from
have
when you are
shown the
entitled.
Scheme paragraph.
Page
introduction
11.
And the paragraph 3.
Let him finish. Yes. Paragraph.
Introduction and paragraph 3.
From the paragraph, let us see when you from when you are entitled.
From introduction, your lordship will find if the freedom fighter dies.
Read it out. Read out the relevant portion.
Yes.
What is the date of commencement of the scheme?
Grant of pension to the freedom fighters and their families from the central revenue was introduced by the government of India. The scheme such and such. The family freedom fighters and their families, if they are not alive, here sanction was made before disbursement of the amount. He died. So from the date of the sanction.
You have failed to show, Mr. Manna. You have palpably failed to answer my question. Please come to their opposition, page 11.
Page 11. It is a scheme.
Please come to their opposition, page 11.
I have come. Your lordship can
5.2.2 read out.
Yes.
Please read out.
Yes, Lord. The dependent pension shall be paid from the date of the application by the spouse and daughter,
And not from the date of the pensioner.
not from the date of the pension. That has not been said. But
Did you ever apply?
I applied in 2007.
Representation and application, as you are rightly saying, are different things. Justice Piraki Ghosh directed that writ petition to be considered as a representation.
Yes, sir.
Justice Bhattacharya also directed your whatever to be considered as a representation. But what was the date of the application?
Date of the application is how 7 date has not been mentioned. I could not develop.
Show me your application copy. I'll see from that. When did you apply? Just show me your application. Must be annexed to the writ petition.
It has only been mentioned in paragraph 22 of the writ application.
Your application you have not annexed. That is the basis of your case.
Sorry, it is a lost piece. When my father died, I was only of 13 years. Then that representation has perhaps been lost.
After you attained majority, you must have applied at any point
I
of time.
have applied in 2007.
Show me that application.
Copy is not with me. The
Then
client
I
has
cannot
not paid.
rely on that.
But the order says
No.
that to treat the writ application as an application. So at least, the 2008 should be the date of the application. That April 23rd.
Not treat it as an application. The direction was writ petition as a representation and to dispose of the same. That representation is only for the purpose of bringing to their notice. That representation was never treated as an application by them and it was not acceded to, which required you to take out further writ petitions. Ultimately, your right crystallized by Justice Mousumi Bhattacharya's order, which says it should be disbursed by treating the district magistrate that representation. That should be the cutoff date.
Yes.
Child, can you allow me to come page 25 for a moment?
Yes.
The order is that to consider the case of the petitioner by treating the writ application as a representation. So,
It was treated as a representation. It was rejected.
no, not rejected.
What was done to that?
That was not said that can we come to page 26.
Yes.
In 2009. What they have stated after that order?
What they have stated? Tell me.
Page 28. Page 28. Page 28.
No, let me.
Last paragraph.
Page 27, last paragraph. In view of the functional, it has been tentatively we decided to treat your representation as finally disposed of as mentioned above. That is in paragraph 5. It has been mentioned. And submit the affidavit to the disbursing authority. I was directed to submit the affidavit. In paragraph 5, I was directed.
Yes, Mr. Bhattacharya, what do you say to this? Why not the Justice Ghosh's order should be treated as, I mean,
Your Lordship, kindly once come to page 28 of writ application.
28, yes, I've seen
No,
28.
He has not taken any steps.
No,
No reply has been received.
maybe.
And the rule is, my lord, date of application. He has never, nowhere has made when he has filed the application. But on sympathetic ground, my lord, this has been allowed. Here, may I place the entire opposition, my lord, your lordship will find, and or the, my lord, impugned order passed, which has been challenged before your lordship.
No, your scheme says it has to be date of the
The
application.
date of the he has never, nowhere it has been when he has applied for
No, Justice Ghosh said that the
representation.
Yes, representation, on the basis of the representation, you have been processing that as an application.
But
And you asked for details also.
No, asked for details. He has not provided anything. Thereafter, my lord, he's again filed a fresh writ application in the year 2017 and he has got the order. Considering that if your lordship goes through the order in entirety, your lordship will find, my lord, it has been granted, my lord, practically on the, my lord, sympathetic ground. My lord. May I place that on page 45?
55 of?
Writ petition.
Writ petition. Mr. Manna, take your seat. I'm with you. Up to now, regarding that date of that writ petition should be the representation. Subject to what Mr. Bhattacharya says. Yes.
Your
45.
lordship, kindly page 45 it starts, my lord.
Yes.
The case pertains to the petition of Mr. Aloka Bera, who is the daughter of late such and such, and I am skipping over the relevant portion. And that this one. I have heard the learned advocate. Need not. Your lordship, kindly come to paragraph 3. The means to examine the claim of the petitioner on 26 February 2009 in compliance with the order dated 23rd April 2008 and requested the petitioner to make submission. The petitioner neither submitted her stand nor appeared before the Deputy Secretary FFR Division, and accordingly the claim of the petitioner finally rejected. On 18/8/2009, the petitioner has filed another writ petition in 2017. Then the Honorable Court passed an order. The order has been quoted. Subsequently, an order has been passed by the Honorable Court on 1st August 2022 in WP number Hato by Aloka Bera, Union of India. Your Lordship, kindly come to paragraph 7. In compliance of the order dated 1st August 2022, it is stated that there is neither any willful delay on the part of the Union of India nor any provision to grant any interest in SSSS Jojana. Accordingly, I am directed to convey the sanction of the President for grant of Swatantra Soinik Shanman dependent pension under the Swatantra Soinik Shanman Jojana at the rate, this has been quoted. The pension will be for the lifetime until he remarries and would be in addition to the state freedom fighters pension, if any, that is there. The next page 47. The sanction will be liable to me. This is the cancel. And on the basis, this is the order that has been passed on the basis of the second writ petition, and that has been granted because
Mr. Bhattacharya, it is a continuation of the same exercise. I mean, they did not furnish documents. I can appreciate that fully. But thereafter, the same exercise was revived.
Now your lordship kindly take to my affidavit in opposition.
Yes.
Just a minute. Just a minute. And paragraph 6, that the issue involved in the present writ petition is squarely covered by the above mentioned clause 5.2 and 5.22 of the revised policy guideline. Clause 5.22 of the guidelines provide that the dependent pension shall be paid from the date of application by the spouse daughter and not from the date of the death of the petitioner. The petitioner herein has also been sanctioned triple pension from the date of her representation dated 14/12/2015. It is, my lord, that is there, as directed by the Honorable High Court in order number such and such. As such, the petitioner is wrongly contending that she is entitled to for the dependent pension from the date of death of her husband, for which she is not at all entitled in terms of 5.2 or 5.22. Let me complete. Now, your lordship, kindly come to paragraph 7. That all the contents and allegations and averments as made by the petition in the writ petition under para 1 to 26 are not admitted and vehemently denied except those which are matters of record. Thereafter, the middle portion, the answering respondent placing reliance upon the judgment passed by the Honorable Division Bench, Delhi High Court, titled Bhagwani versus Union of India, which clearly held that dependent pension has to be paid from the date of application by the spouse daughter and not from the date of death. Keep over that portion. Your lordship, kindly come to paragraph 13. Paragraph 13, he further draws our attention to paragraph 5.2 revised policy dated 6 August 2014 in respect of the scheme of which pension is payable to the spouse of the deceased freedom fighter. In paragraph 5.22 of the said policy, it is clearly provided that dependent pension has to be paid from the date of application by the spouse. Therefore, the respondents have rightly paid the pension of the petitioner from the date of receipt of the application of the petitioner. That is 3rd July 2017. It may be noted herein that this is not a pension linked to service rendered by the deceased husband in the petitioner, but pension in terms of the policy framed by the government of India. Therefore, the action of the respondent herein for the grant of pension from the date of application is just, proper, and in accordance with it. It is also humbly submitted the terms pension associated with the SSS Yojana is not intended to be considered as a pension scheme akin to the pension scheme for armed forces pensioner, personal or retired central state government employees. A token of respect, honor is specific to the person on whom it is bestowed, and therefore the honor and award is not non-transferable or to be paid continuously. With regard to the laid down provisions and guidelines of SSS Yojana, the answering respondent also relying upon the judgment dated 11th February 2020, wherein the Honorable Supreme Court in civil case number such and such titled Government of India versus such and such, when a benefit is granted to the relaxation of scheme, it is open up for the government to put conditions for eligibility. Hence, the policy for grant of SSS pension, which is framed by the government of India under its discretion, is fully empowered to do, is sufficiently required to be fulfilled by the claimant's SSS Yojana. Hence, the claim of the petitioner are untenable and cannot be accepted beyond the laid down policy. Apart from this, my lord, the 2014 guidelines have come into subsequently. My lord, there is a judgment of your lordship's court where it is stated that if it is the previous is not applicable, my lord, to the subsequent, but your lordship kindly produce this judgment. Judgment copy Your lordship kindly come to paragraph 5 of the judgment, only relevant for this disposal. Mr. Ghosh, this is an appeal filed by the Union of India. Mr. Ghosh, learned advocate appearing for the appellant, argues that learned single judge while disposing of the writ petition did not take into consideration the revised policy guideline for the disbursement of central Shonman pension dated 6th August 2014. That was the point taken there. Such contention is not acceptable to this court since the revised policy guide can have no manner of application in respect of the claim pension submitted on previous. So, my lord, previous is not applicable to the subsequent, and subsequent, this is not retrospective. So,
how does this help you? What happened after the 2014 guidance? They have been curtailed in some manner.
No, after
2014 guidelines.
2014 guidelines, they, according to the authority, his application is on or after 2014 guidelines. So,
Yes.
my lord,
Then
he cannot make any claim on the basis of the previous anything, my lord. So, in that view of the matter, his application was treated on the basis of the 15th December 2015, and on that date, my lord, it has been sanctioned. He cannot get benefit from the date of his father, which maybe, my lord, existed at the earlier point of time.
that is all. But I'll go against you.
Well, shall I point it to
No
one
need not.
thing?
I'll pass my order.
My lord is of the
Justice Ghosh's order.
Justice Ghosh, on that date at least she should be given.
That is the date. Not before that.
No,
she
not
cannot.
before that.
There is no question of before that.
That I am, as your lord.
But I am sorry to disturb my learned.
Don't disturb.
Your Lordship, my learned friend has pointed out the date of the application.
I'll grant family that pension from the date of Justice Ghosh's order.
From the date of Justice Ghosh's order. No, I have, your Lordship, they taken the date.
Impress upon your
They
learned.
have referred 2 pages. Page 28.
Have a
for
short conference with him.
Have a look to page 28. 28 for a moment of the writ application. They asked me to
And
make
my
some
lord, the
repair.
correction of the name that he is not providing. Unless it is provided, man, it will be held up in the ultimate stage. He has to clarify and rectify that.
I'm saying that you will get pension from 2008 and you are relying on something 2009.
No. What they have said, I have not replied. I would like to show that I replied.
Otherwise, you would not be entitled. You are a lady, you are asking for freedom fighters pension. That's why only you are getting it.
Well, whatever is there.
Lord Learned Counsel for the parties, the grievance of the petitioner is that she is an unmarried daughter of a freedom fighter and is entitled to pension under the Swatantrata Soinik Samman Pension Scheme 1972, subsequently 1980, within bracket SSS scheme, double inverted close, full stop. Next para. The petitioner contends that she had applied for such pension in the year 2007 but cannot produce a copy of such application, submitting that it has been misplaced. Full stop. Next para. In any event, the petitioner had taken out a writ petition which was disposed of with the order dated April 23, 2008 by a coordinate bench, where it was observed that the respondent authorities were to consider the case of the petitioner by treating the said writ petition bearing WP number 16737 within bracket W of 2007 as a representation and to dispose of the same by passing a reasoned order after giving an opportunity of being heard to the petitioner. Full stop. Subsequently, it transpires from the correspondence annexed to the writ petition and the opposition that the respondent authorities sought certain documents from the petitioner which the petitioner failed to produce. Push up. Next para. The government, accordingly, rejected the application, the representation of the petitioner on such count. Push up. Next para. Subsequently, however, the exercise was renewed by the petitioner, which culminated in a further order passed by another learned single judge on August 1, 2022 in WPA 12374 of 2017, pushed up by the said order, the learned single judge directed that the Union of India being the Secretary, Ministry of Home Affairs, Government of India was to dispose of the petitioner apostrophe's entitlement to the pension upon treating the report of the district magistrate, comma, Purbo Medinipur as a representation reflecting the stand taken by the state respondent. Full stop. Next para. The respondents contend that as per the scheme, comma, the petitioner is entitled to get pension only from the date of her application and not from the demise of the freedom fighter. Push up next para. There cannot be any doubt in that regard, comma, since the respondents have correctly relied on clause 5.2.2 of the relevant scheme, which, comma, in no uncertain term, comma, stipulates that the dependent pension shall be paid from the date of application by the spouse stroke daughter and not from the date of death of the pensioner. Push up. The dispute which arises here is what is the date of the application of the petitioner. Full the original purported application of the petitioner of 2007 cannot be produced by the petitioner and comma thus comma cannot be relied upon. Full the respondent's stand is that the first order dated April 23, 2008 in WP 16737 within bracket W of 2007 had culminated in a rejection of the petitioner's representation due to the laches of the petitioner in not producing any documents. Full stop. Hence, comma, the said representation cannot, comma, according to the respondents, comma, be treated as the application of the petitioner for the purpose of disbursal of pension. Full stop. The plinth and strength of the petitioner's claim now is the order dated August 1, 2022, which directed the representation, which directed the report of the district magistrate of the year 2015 to be considered as the representation, comma, which has been taken as the date of the application while sanctioning pension to the petitioner by the respondents. Full stop. On the contrary, comma, the petitioner contends that the original date of application of the petitioner should be taken as the date of the order dated April 23, 2008, when the first writ petition was directed to be treated by the learned single judge as a representation. Push up next para. Upon a careful consideration of the respective contentions of the parties, comma, the arguments of the petitioner seems to be more acceptable. Push up next para. The genesis of the present exercise was the order dated April 23, 2008, passed in WP 16737 within bracket W of 2007, and not the order dated August 1, 2022, passed in WPA 12374 of 2017. Full stop. For the first time in the order dated April 23, 2008, comma, the petitioner's then writ petition was directed to be taken as a representation, and thereby the respondents were directed to process the petitioner's claim for pension. Full stop. Thus, comma, for all practical purposes, comma, the application of the petitioner should be treated as the said representation and the date of the application to be treated to be April 23, 2008. That is the first order of the learned single judge. Full stop. Next para. The subsequent exercise was a mere continuation and reopening of the said application. Full stop. Although the first representation was rejected by the respondent authorities, comma, the entire exercise was reopened, comma, thereby granting a fresh lease of life to the first application dated April 23, 2008. Full stop. The order dated August 1, 2022 merely referred to the report of the district magistrate Purbo Medinipur as a representation reflecting the stand taken by the state respondent and not the application of the petitioner. Full stop. Since the entire exercise took its beginning on the date of the first order dated, had its beginning in the first order dated April 23, 2008, comma, the respondents are required to disburse pension to the petitioner under the SSS scheme from the said date by treating the same to be the date of the application for all practical purposes. First up, in such view of the matter, comma, WPA 7071 of 2023 is partially allowed, comma, directing the respondent authorities to disburse pension to the petitioner under the SSS scheme as referred to above by treating the date of the application to be April 23, 2008, that is the order passed in WP 16737 within bracket W of 2007. Pushed up, the necessary calculations shall be made at the earliest and the disbursal shall be positively made in favor of the petitioner within 1 month from this date. Mr. Bhattacharya will get 1 month's time to.
He has to clarify, rectify the mistake, and the document has to be submitted.
In
What
Bengali,
document is
I have signed.
What document?
In Bengali, I have signed Oloka. In some document of the government,
comma subject যা বললাম সেখানে comma subject to the petitioner rectifying the defect as pointed out by the respondents regarding the spelling of the name of the petitioner within 1 week from date.
what I am saying, ALAK should be treated as ALOKA also. Now,
In the sanction, it has been
same
written ALOKA. But
somewhere it has been
PAN card and Aadhaar card is ALAKA.
in some government document it is
Rectify the defect within a week and then they'll disburse within.
And your lordship kindly make that observation.
I've made the observation that subject to their rectifying the defect within 1 week regarding the name, you will disburse within a month.
within a week, the identification document cannot be done. DM will take more time.
What is the time required?
কতদিন লাগবে? Ready করা আছে? But I'm sorry. Well, it has been made ready.
Ready করা আছে.
Ready because the direction was there. But it has been filed also.
Yes.
14.
Thank you, Mr. Bhattacharya. Yes. Thank you, Mr. Manna. Again, another?
No.
Yes. What is the one?
My lord, I'm appearing for the petitioner.
I am appearing for the state, my lord.
Right.
My lord, my
State is the main respondent.
Yes, my lord.
medical college is the
Medical
main-
college, my lord.
Medical college has been served properly.
Yes, my lord. I have given my affidavit of service.
Yes. What is the grievance?
My lord, the petitioner, this is an RTI matter, my lord, and it is connected to a medical negligence case, my lord. The petitioner's wife died. She was treated for cancer when she was not suffering from cancer by the doctor. And eventually that led to her death. And the petitioner had filed a medical negligence case before the State Consumer Forum, my lord. The petitioner made a RTI application before the West Bengal Medical Council. And there the West Bengal Medical Council has stated, my lord, which is in page number 21. Medical Council has stated that the doctor who was treating the petitioner's wife at that time only had an MBBS degree and he was not an oncologist, nor did he have an MS degree, which was registered with the authority. My lord, but the
He gave a representation that he had that degree, the
my
specialization.
lord,
You knew he was an MBBS.
yes, he said he had an MS degree, but yes, but
Then-
that was not there.
Then what happened?
Then, my lord, we went before the medical college because in his portfolio in the website, in his website, it's showing that he has a MS degree. Went before the medical college to confirm if he had taken the degree from that authority.
Yes.
And the SPI of medical college has not responded to me. I have gone before the first appellate authority. They have also not responded. I've gone before the second appellate authority. They have also not responded. I'm before your lordship's court
The report of
for reply.
ASPIO, principal come ASPIO Medical College, Kolkata. my
What does
lord.
it say?
My lord,
Give a copy to them. Why
I
don't
have
you keep
not
extra
received
copies?
any copy, my lord.
Always keep extra copies. 3 copies are always necessary.
my lord. My lord, this is my lord.
He has a copy, you have a copy, I don't. Read out for me.
Yes, my lord. My lord, in medical college, my lord, the said Sanjay Boksi, my lord, completed MBBS, my lord. But MBBS, but master
Give a copy
degree.
of the report that will
My lord,
satisfy
I
her.
have given, my lord.
My lord, I have received the answer.
My lord, master degree, my lord, there is no course of master degree in medical college. That's why they are not able to, my lord, give the said information, my lord. Second page, my lord.
So your problem is resolved. Learned counsel for the petition. Learned counsel for the petitioner contends that the petitioner has been running from pillar to post with her allegation regarding medical negligence against a particular medical practitioner and sought relevant information regarding the degree of the said doctor. Push up, however, having failed before all forums, including the SPIO, the first appellate authority, and the second appellate authority, the petitioner has moved the present writ petition. Pushed up, upon query of court, learned counsel for the respondent authorities hands over a written instruction with a copy to learned counsel for the petitioner, which indicates the answer to the petitioner's query. And it says that the said medical practitioner completed his MBBS degree within bracket Calcutta University in the year 1982 as per available office record and did not ever receive any degree in Master of Surgery within bracket MS from Medical College, Kolkata. Since the petitioner's grievance is thus redressed, there is no further need of continuing with the writ petition. Accordingly, by keeping the above report on record, WPA 14645 of 2023 is disposed of as infructuous with liberty to the petitioner to take appropriate steps with the information thus received.
I'm deeply grateful, my lord.
একটা প্রথম লাইনে দিয়ে affidavit of service filed to be given. Thank you very much.
My lord, matter be disposed of infructuous, my lord.
Dismissed. Dismissed will help you.
My lord, dismissed.
My lord, maybe disposed of, my lord. Infructuous, my lord.
একটা কাগজ পেন্সিল ওনাকে দিয়ে দাও. You write the order, I'll sign. Write the order, I'll sign.
My lord.
But there should not be any spelling mistake.
As your lord.
I'm grateful, my lord.
15. My lord, I appear for the petitioner, my lord. This is my affidavit of service, my lord. Here, my lord, the petitioner participated in the tender process, my lord, for the purpose of construction of a road, my lord. My petitioner completed the work, my lord. But the state had taken a policy decision to pay compensation to all the contractors, my lord, due to unusual price rise of bitumen. My lord, thereafter
was there in the contract.
My lord, the state had taken a policy decision. My lord, the amount was calculated, compensation amount, my lord. Since the amount was not being paid, we moved the writ application before this honorable court. This honorable court directed the authorities to consider our grievances. Accordingly, my lord, hearing was held, my lord. My lord, during the course of hearing, my lord, the entire amount that is calculated, the 27,46,102, that was we have claimed that amount, my lord. But we could not provide the my lord. That is, which includes the cost of bitumen, my lord. Thereafter, my lord, the impugned order has been passed, my lord. Only, my lord, the compensation amount which has been calculated, that they have calculated
Compensation you have got.
They have admitted,
But the main amount you have not.
Not the cost of bitumen, my lord. They have not disbursed, my lord.
The breakup details.
I have, my lord, I have subsequently, my lord, I have made again, my lord, I have made a
Bitumen portion goes.
Representation to the authorities for revisiting our issues, my lord. That has not been considered, my lord. And on the, my lord, arising out of the same, my lord, the notice inviting tender, my lord, has been pleased to direct the authorities to revisit the issue, my lord. My lord,
so now what do you want?
My lord, similar order, my lord, maybe passed,
To
my lord,
revisit the issue.
to revisit the issue, my lord.
Show me the impugned order first.
My lord, the prayer is something else, what my learned friend is making his submission.
My
I
page
mean, the
61
submission
is the
different from
recent
the
order.
prayer made in the writ petition.
Let us see your decision.
But page 61 is the impugned order, my lord. May I read for lordship?
You need not read the entire thing. Compensation has been given.
My lord,
He has come for the compensation, my lord, which he has received the compensation.
my page 62, my lord, second paragraph, my lord.
Yes.
No, second paragraph, my lord, second line, my lord. No breakup was furnished by the petitioner either during the course of hearing or later in his representation submission on.
No, I don't get it. Page 62, second paragraph.
Second paragraph.
Same paragraph, the petitioner video is representation. Oh, no breakup.
Middle of it. Thereafter, on 28 June, my lord, page 70, my lord, I have raised our grievances that the amount of the cost of bitumen price has not been disbursed, my lord. And further requested to
Your only ground was no breakup was given. Now they've given a breakup.
No, no.
Have you given a breakup?
Kindly come to the
Yes,
order
my
of
lord.
Honorable Justice Moshe Bhattacharya.
That was prayer for
page 57.
57 years.
That was the grievance. This is the second round of litigation.
Hmm.
Now,
That was regarding compensation.
Compensation.
regarding compensation, Honorable Justice Moshe Bhattacharya said that you consider the representation.
You have given the compensation.
We have considered the representation. We have come to the amount that this is the amount which you are entitled to.
That was
Now-
only regarding compensation, not
That
the
was
main
it.
amount.
But that is not the prayer in the writ petition, my lord, with regard to the main what the submission he has been making. The prayer is, my lord, for only for compensation.
No.
Kindly come to the prayer portion. The issue regarding payment of compensation to the petitioners due to increase in the price of bitumen in respect of construction of
Yes.
tunnel. That is the prayer, my lord.
But prayer A, my lord, to revisit the issue, my lord.
According to them, my lord, they are entitled to a compensation of rupees 21,26,122. Now, after the hearing, it has come. It has
Yes,
been found
he's
that,
right.
that
He's right.
But
The entire prayer is regarding compensation.
but
Not a single line regarding this other.
no, what the paragraph 10, my lord, I have stated, my lord, and the prayer A is to revisit the issue, my lord. But admittedly, that amount has not been disbursed, my lord.
Instead of relegating him to another writ petition, why delegate him to
my
another?
lord, unless the prayer is made, my lord, I cannot. I
I'll
cannot
give him
make the
liberty to
submission.
add the prayer.
But let him amend the.
Right now, today, and I'll dispose of it.
But then I have to come back again, my lord.
Come back with what?
Further instruction, my lord, because with that.
No instruction. I'm not directing you to make any particular payment.
My lord.
What instruction?
But I have to take the instruction whether he's entitled for that payment or not, my lord.
Learned counsel for the petitioner contends that the petitioner did some work for the respondent authorities. First of it was a policy decision of the authorities to give compensation to the contractors due to enhanced prices. First up, such compensation initially not being given, a writ petition was preferred, upon which a direction was given to the respondent authorities to consider such demand of the petitioner. Subsequently, the respondents have disbursed compensation but have not paid the main amount for the work done by the petitioner in its entirety, as apparently no breakup was given by the petitioner, who it is submitted that the due breakup has now been given in the writ petition, for which the said amount is to be paid by the respondents. Next para. Learned counsel for the respondent authorities controverts such allegations and submits that the previous writ petition was restricted to compensation, which has since been given by the petitioner. It is pointed out by learned counsel for the respondent authorities that none of the prayers in the writ petition pertain to the arguments now made and are entirely confined to prayers regarding disbursal of compensation and compensation alone. As such, it is argued that the prayers now being made from the bar on behalf of the petitioner ought not to be allowed. Next para, it transpires from the impugned rejection.
But page 61, my lord.
Dated, yes, impugned rejection by way of a reasoned order dated June 12, 2023, annexed at pages 61 and 62 of the writ petition, that compensation was duly given to the petitioner. Hence, as rightly contended by learned counsel for the respondents, there cannot be any further grievance in that regard. However, in the same reasoned order, the chief engineer PWD roads within bracket HQ bracket closed DTE observed that the petitioner vide his representation dated January 3, 2023 had claimed for compensation for an amount of rupees 27,46,102, of which no breakup was furnished by the petitioner either during the course of hearing or later in his written submission. Next para, on such count, the said demand was refused. Since the petitioner is now prepared to give the relevant breakup, unnecessary relegation of the petitioner to a fresh writ petition with another prayer is unnecessary and a killer of time. Push up next para. In any event, comma, since the sole ground of rejection of the petitioner's demand regarding the main claim with regard to the work done by the petitioner was refused only on the ground that no breakup was furnished by the petitioner, comma, it is always open to the petitioner to approach the respondent authorities with a proper breakup. Full stop. Hence, comma, even without incorporating any prayer in the present petition, comma, WPA 16486 of 2023 is disposed of with liberty to the petitioner to approach the respondent authorities with a full breakup of the work actually done by the petitioner. Full stop. If so approached, comma, the respondent authorities shall, comma, irrespective of the previous refusal dated June 12, 2023, on the ground of non-availability of breakup, comma, shall revisit the issue and disburse the amount which is due to the petitioner according to the respondent authorities. Full stop. Next para, it is made clear that nothing in this order shall be construed to mean that the respondents have any further liability regarding the payment of compensation on enhanced costs, but shall only be restricted to a reconsideration of the breakup, comma, if produced by the petitioner before the respondent authorities within a fortnight from date in writing. Full stop. It is further made clear that this court has not gone into the merits of such prospective claim of the petitioner with due breakup, and it will be open to the respondent authorities to consider the same upon giving opportunity of hearing to the petitioner if the respondents so consider necessary, comma, which exercise shall be concluded by the respondents preferably within 4 weeks from the date of such breakups being furnished by the petitioner. No address to
My lord,
cause.
only one thing, my lord, the representation which he has been harping upon, that I have made a for the main claim, my lord, about the disbursal of the amount, my lord. Nowhere it talks about, it speaks about the main claim. It's all along speaks about the compensation amount.
Compensation amount, and you have also
No,
dealt with the compensation.
it's not there in the representation, my lord. Kindly.
That's why I've given them the liberty to give the fresh breakup and make a fresh application within a fortnight.
So this representation is
I have not relied
not
on
the
the
basis of the representation. He has to make a fresh representation.
fresh breakup has to be given by them, and that breakup we will consider consider immediately, and within if necessary by hearing him, and within 4 weeks from that date you will disburse the
Issue
amount.
of compensation is no more there.
No,
The
but
issue
the
of
amount
compensation
failed to follow my order.
But the compensation, my lord, has sanction not yet disbursed, my lord. That has
I
been
made it very clear in my order.
My lord.
In right, I mean specifically that this nothing in this order shall be construed to mean that you have any further liability
No, my lord.
regarding
But the
compensation on enhanced
my
price.
lord has rejected that it has disbursed, not yet disbursed, my lord. Sanctioned.
এখন তো বললি করে দিয়েছি।
একটা জায়গায় বলেছি
Compensation amount disbursed.
compensation which has already been disbursed. Disbursed sanctioned হবে। Disburse দেখুন লাস্টে ডিসবার্স যেটা লাস্টে বলেছি একটা ডিসবার্স করবে উইদিন 4 উইকস, সেটা না, তার আগেরটা হচ্ছে ডিসবার্স না স্যাংশন হবে।
Grateful.
I'll take up the next matter after 10 minutes.
16.
My lord, I appear for the petition.
Yes, please. What is the matter?
May I file the affidavit of service, my lord?
All served.
My lord, that I have not. May I, my lord? I believe, my lord, IOC is being represented, my lord. My writ is against IOC.
Yes.
But the petitioner, my lord, before my lord, is my lord in an unsuccessful tenderer, my lord. Now, my lord, before my lord, I take your lordship through my lord the writ petition and my lord the annexures thereto, my lord. That I would, my lord, beseech your lordship, my lord, that lordship may, my lord, allow me to briefly state the facts of this case, my lord. The reason being, my lord, it's a bit complicated, my lord, a bit complicated. Now, my lord, IOCL, my lord, in its usual course, in the year 2018, had floated a tender for, my lord, supply of TTs, which is, my lord, tank trucks, my lord, for its Haldia port. The requirement in 2018, my lord, was 60 tank trucks. My lord, it had, my lord, some specific stipulations, my lord. Inter alia, my lord. One, my lord, there would be a reserved category, my lord. Reservation for SC/STs, MSCs, my lord, MSMEs, my lord. Lord, if the reserved quota is not fulfilled, my lord, then, my lord, it would be carry forward to the next tender, my lord. That's what, my lord, the tender of 2018 said, my lord. Then, my lord, for the same subject, my lord, a tender was floated in 2022, my lord, November 2022. Surprising, my lord, in 2018, my lord, the requirement was for 60 trucks, my lord. In 2022, my lord, the requirement, my lord, reduces to 30, my lord. And it's actually not surprising, my lord. There's a reason behind, my lord. There's a reason behind it, my lord. I shall come to it, my lord. My lord, the terms and conditions, my lord, were similar, my lord. Again, my lord, there, my lord, some reservation for the reserved category, my lord. And, my lord, same, my lord, carry forward procedure, my lord. Here in this case, my lord, my calculation says, my lord, that there was carry forward, my lord, but not to its entire limit, my lord. The carry forward should have been for 5 tank trucks, my lord. Only 3 were allowed, my lord. Had there been 2 extra, my lord, I would have, my lord, been able, my lord, to be I would have also been able to supply the tank trucks, my lord. Now, had the carry forward been, my lord, my lord, in its entirety, or, my lord, rather, my lord, had, my lord, the requirements been of 60, which actually it is, then, my lord, the carry forward would have been 7, which is, my lord, which means, my lord, 5 extra. So I would have, my lord, fit into that category, my lord. Now, my lord, I participate in this tender of
You belong to the reserved category.
I belong to the reserved category,
Yes.
my lord, SC category, my lord. Now, I participate in the tender, my lord. I pass the technical, my lord, standards, my lord, the financial standards, my lord. But however, my lord, ultimately I get rejected, my lord.
In 22.
In 2022, I get rejected, my lord. My lord, after filing of the writ petition, my lord, I get my rejection email, my lord. My lord, it's beyond my comprehension, my lord. I could not understand, my lord. Then, my lord, be that as it may, my lord. Now, in August, my lord, they take out a notification where they say that, my lord, IOCL requires more tank trucks, but it has to be supplied by those participants, my lord, who've already been successful.
In 22.
In 2022, my lord. So, my lord, with the reason, my lord,
Yes,
to give
that might
backdoor,
be because that was the next tranche of the requirement.
then it should have been by way of auction. If the first was by way of an auction, the second should have been by way of an auction, my lord. They can't, my lord, state authorities, my lord, cannot act on their whims and fancies, my lord.
All right.
So, my lord, even in 2022, when they took out this subject tender, my lord, they were aware that the requirement is actually of tank trucks more than 30. Because in 2018, it was more than 30. So they were aware of it, my lord. And every time they take these tank trucks, my lord, these are new tank trucks, new TTs. So they were aware, my lord, that even this time, in fact, my lord, the requirement should have increased in 2023, my lord. But it's reduced to 30 to give, my lord, backdoor entry to those successful, my lord, or, my lord, their favored participant, my lord. Now, my lord, in this background, my lord, may I take your lordship, my lord, through the documents, my lord. First, my lord, the tender of 2018, my lord, may I hand over, my lord? I have
annexed.
No, I have already, my lord, referred to it, and my lord, I've craved leave, my lord. These are voluminous documents, my lord. Lordship will kindly see, my lord, page 3. Page 3, my lord, speaks of the requirement, my lord, which is 60. Now, lordship will kindly turn to, my lord, page 29 of this tender. Yes.
Yes.
Page 29, my lord, may I place, my lord? H, reservation. The provision of reservation shall be 15% and 7.5% for scheduled caste and scheduled tribes, respectively, on all India basis. 2. Save as otherwise provided, the SCST members should fulfill all tender conditions and shall not be eligible for any price preference or relaxation. I'm not asking for any price preference, any relaxation. 3. This is important, my lord. If adequate number of SCST tenderers are not available in any particular year, the unfilled quota may be allocated to the unreserved categories in that year. However, the unfilled quota may be carried forward to the next year tenderer and also offered to SCST candidates. If the quota of the previous tender is not filled in the next tender, the unfilled quota of the previous tender may be de-reserved, and that's it. So, my lord, it speaks of, my lord, reservation, it speaks of, my lord, carry forward, my lord. In case, my lord, the reserved category remains unfulfilled, my lord.
So they had an option of fulfilling the quota by the general category or to carry forward to the next year.
Yes.
If adequate number of
yes. If not fulfilled by general category,
but they
then carry
chose
forward.
to opt for the latter. They carried it forward.
They've carried forward, my lord. They've carried forward. That's
right. Then
now, my lord, will kindly take, my lord, my writ petition, my lord. The tender, my lord, starts at page 18.
Yes.
Lordship will kindly note, my lord, the location. Name of location, Haldia Refinery. Same as 2018. Address of location, same, my lord. Capacity, I'm sorry, my lord, tank trunk requirement, my lord, which says 30. Now, lordship will kindly turn to page 21. My lord, clause 3.
Yes.
These are, my lord, the total number of tank trucks that one of the participants, one of the bidders can supply, my lord. For general, my lord, it's 5, 3, 2. I'll come to, my lord, the next one, my lord, which is my category. SCST, MSc, SCST. I am not MSc, SCST, my lord. I am general SCST. So it's, my lord, total tank trucks that can be supplied is 5, out of which, my lord, 3 has to be owned by the one bidding. And 2, my lord, can be, my lord.
So there is no sub-classification between SCST, general SCST and MSc, SCST. It is within the same block.
It is within, my lord, but, my lord, the reservations, my lord, it's given. The numbers are given, my lord, as to what would be the figure of reservation, my lord.
Yes.
Then your lordship turns to, my lord, page 23. Clause 14, my lord. Minimum TT criteria as explained above. Then, my lord, allocation of TT. How would a TT be allocated? My lord, lordship will kindly come to, my lord. It starts, the sentence that starts with, in case more than one party has quoted same rate. But in this case, my lord, lordship takes it from me, my lord, all the parties had quoted the same rate.
Same rate?
Yes. It's, my lord, because the difference has to be plus minus 5. So everyone did not take a chance, my lord. Everyone quoted the same rate. Seniority shall be decided in the following criteria. Now, my lord, comes the criteria. 1. Maximum number of own TTs offered. Lordship, I had shown, lordship, my lord. So, my lord, who offers the maximum number of own TTs, my lord, gets the preference. In this case, my lord, lordship takes it from me, my lord. All the bidders had own TTs, my lord. All of them. So it's, my lord, we are in the same level, my lord. Next, average age of fleet. Preference will be given to the fleet with less average with less average age. Same in case of all the bidders, because all the TTs were new, brand new, all of them. Next, maximum number of TTs offered. So, my lord, 5 is the maximum, my lord. In this case, my lord, all the bidders, my lord, offered for 5 TTs, my lord. Next category, my lord, where, my lord, they can exercise their discretion, my lord. Total carrying capacities in MT of all individuals, my lord. So, my lord, depending on the carrying capacity, although, my lord, should be same, but, my lord, in different registration offices all over India, my lord, the measurement, my lord, can be different, my lord. Because, my lord, say, for example, my lord, an Alto 800, my lord, will have the same capacity all over India, but because of, my lord, in case of registration offices, my lord, the RTOs, my lord, they have their own methodology, my lord. So there's, my lord, some minuscule difference. So, my lord, I believe, though, my lord, I'll hand over, my lord, the rejection letter, my lord. I believe, my lord, I could not succeed, maybe because of 4. Maybe because of 4. That, my lord, they'll be able to explain, my lord. Then, Lordship will kindly turn to 26. Clause 9, my lord. Reservation, my lord, I have already read, my lord. It's the same, my lord. 15%, 7.5% for SC, 7.5% for ST. Now 27, my lord. Same, my lord. My lord, Lordship will kindly take, my lord, clause C, my lord, somewhere in the middle, my lord. TTs for different categories are as follows. So for SC, it is 5. Had they not carried forward, my lord, it would have been 2. I'll show the calculation, my lord. It would have been 2, but since they carried forward, my lord, it's 5. But it should actually, if they had carried forward the entirety of the 2018, my lord, then it should have been 7. I shall show the calculations, my lord. I shall come to it, my lord. Then, my lord, my lord, this being the tender, my lord, these being the conditions, my lord, I bid for it, my lord. Now, Lordship will kindly come directly to page 138. This is, my lord, the list of candidates who had, my lord, who were successful in the technical evaluation, my lord. My name, my lord, is there at serial number 5. Jagannath. Then, my lord, comes, my lord, the financial evaluation. At page 140, my lord, my name appears at page 141, serial number 19. Jagannath Oil Carriers admitted finance. So I, my lord, passed the finance evaluation as well, my lord. While, my lord, I was waiting for the outcome, for the result, my lord, but there was no communication, my lord. Then, my lord, I filed this writ petition, my lord. After filing of the writ petition, my lord,
So the writ petition, what was the cause of action for the writ petition then?
I shall come to it, my lord. My lord, the notification. The notification is the cause of it. Because I was silent till then. Yes. Tomorrow rejection. It says, my lord, this is my rejection. It says you are informed that your bid for the above tender has been rejected during financial evaluation. Although, my lord, my name appears in the financial evaluation as serial number 19 by the duly constituted committee for the reason technically qualified L1 bidder as per BOQ number TT could not allocated.
No TT could be allocated.
No TT could be allocated. No TT could be should have been, my lord, no TT could be allocated against the bidder as per tender terms and conditions. What were the tender terms and conditions? I do not know. Perhaps my learned friend would be able to explain that. Now, my lord.
What did you challenge in the writ petition?
Yes, my lord. Lordship will kindly come to page 144. This is the document that I have challenged, my lord. It's a notice inviting expression of interest. Page 144, my lord.
Yes.
This says, my lord, expression of interest, induction of tank trucks with capacity of 16 metric tons and above up to 25 metric tons for black oil transportation contract ex Haldia refinery for fuel transportation. So, my lord, same, Haldia. Next, Indian Oil Corporation, Marketing Division, West Bengal State Finance invites expression of interest from the interested existing transporters. This is my problem, my lord. From the interested existing transporters in PT number so and so for provision of ready-built tank trucks, my lord. This, my lord, is the tender number, my lord, of 2022. So, my lord, they are inviting, my lord, expression of interest from those, my lord, who are the existing transporters, my lord. So, my lord, my challenge is twofold, my lord. Had they carried forward the actual numbers.
These existing transporters are the existing transporters from the 2018 successful
No,
ones.
2020. 2018 is gone, my lord. 2022 again come with new trucks. That's the situation, my lord.
So, but you are successful in the technical stage there in 2022.
Even in financial, my lord.
Even financial.
Even financial, my lord. So I do not know, my lord, why have I been rejected, my lord? In fact, my lord, I could not comprehend, my lord.
I don't get this. Who are the existing transporters then? All of you were selected.
I shall give the list, my lord. The existing transporters, my lord. This is the list, my lord, that I have. These are the existing transporters, my lord. Those who were successful in the 2022 tender. Or rather, those who did not get this rejection letter, which I got.
But you got it subsequently.
Subsequent to the filing of the writ petition. No, my lord.
So before that, why did you prefer the writ petition? As on the date of filing of the writ petition, this rejection was not there. So you were also an existing transporter.
So I was not an existing transporter.
Why not? What is
existing? Are those, my lord, who have received, my lord, the LOI from IOCL. I did not. My bid got rejected.
All right. Great. So you are challenging this as well as your rejection. No?
Yes.
Rejection you have.
Rejection, but I could not have challenged because I did not get it then.
Right.
I'm challenging this, my lord, and I'm asking this and I'm asking, my lord, for reopening of the 2022 tender. Because in 2022, they were well aware that the requirement cannot be 30. It has to be more than
that. You participated there.
I'm sorry?
You participated in that.
I participated.
After that, how can you challenge the tender clauses?
No, because of 144.
You knew it was 30.
Everyone knew it was 30.
Yes,
except
you
IOCL.
Participated, but you were only challenging.
Except IOCL. IOCL knew it was more than 30.
Maybe.
Because of 144. Now, what IOCL wanted is...
You cannot be permitted to challenge the tender itself, the terms of the tender at this stage after turning out.
No, I have not challenged the terms of
so
the
is the question of reopening the tender.
I have not challenged because of 144, my lord. Either reopen or this has to be the notice at 144, my lord, has to be set aside, my lord. You can come up with an auction. I'll participate once again in the auction. Now, my lord, may I show the calculations, my lord? There are, my lord, two calculations, lord. One, my lord, in 2018, my lord, the number was 60. The requirements for 60. 7.5% reservation for SC candidates, my lord. Which comes to, my lord, 5 tank trucks.
All right.
5 tank, but it's 4.5 side, my lord. 5 tank trucks. So, Lordship will kindly note, my lord, the carry forward left for 2018, 5. Next, my lord. In 2023, my lord, the requirement was for 30 tank trucks. If I take it as 30, then, my lord, SC reserved, my lord, is 7.5%. So, it comes to 2.2. I take it as 2.
Yes.
Therefore, my lord, 2018 plus 2023 is 5 plus, sorry, 2022 is 5 plus 2, 7. So, my lord, when they took out this tender, accepting that the requirement was for 30, then, my lord, 7 tank trucks should have been...
7 and 1% in 2018 was 5 tank trucks.
Yes.
But are you sure that none of these were fulfilled? I mean,
none of these were fulfilled.
There were no SC candidates.
None of these.
Right.
That is why carry forward, my lord.
That is why the entire has to be carried forward. Then
entirety in it has to be carried forward. My lord. They did carry forward, my lord. Next, my lord. So it has to be, my lord, 5 plus 2, 7. 7 tank trucks for, my lord, SC/ST candidates, my lord. But, my lord, Lordship will kindly see, my lord, which I have handed over, my lord. The my lord, allocation was 5 tank trucks. So the carry forward was 3. Deficit was 2. So I could have fit into 2. Now, my lord, the other calculation, in view of the notice at page 144, my lord. And, my lord, very, my lord, surprisingly, my lord, the notice at 144, my lord, also does not speak of the requirement. It does not. Next, my lord, had the, my lord, in 2022, this 2022 tender, my lord, had the requirement been 60, which actually it is because of 144, 60, then, my lord, the total, my lord, the SC/ST would have been, my lord, 5 earlier, my lord, and 5 of this year, 10. They have allocated 5. So deficit again would have been 5.
I don't get this point.
Okay,
Sorry.
well, I'll shall repeat, my
Yes.
lord.
This is not a fresh tender. This expression of interest.
No, it's not a tender at all.
No. So then why do you bring in that another 5?
Oh, I shall explain, my lord. So far as, my lord, 2018 is concerned, my lord,
5?
5. Yes, 5. In 2022, I'm saying their requirement as per the tender is 30. As per the tender. But had the requirement been 60, 60, which actually it is, which they will actually take in, my lord, then, my lord, 60 again. So, my lord, the reserved category would have been 5, 7.5%, 5.
But we don't know how many slots were filled in.
Yes, we know, my lord. I have handed over the paper, my lord. 5. Lordship will see, my lord. 5.
No, in 2018, in the 2018 tender.
None, my lord. 0.
Achha.
0.
All right, very good.
So, my lord, 5 of 2018, 5 of 2022, 10. How much have they allocated? 5. So, my lord, deficit again, my lord, is 5.
More, yes.
5. So, I could have fit in into this 5, my lord. And, my lord, this, my lord, this system of, my lord, carrying forward is not an alien concept. They do it, my lord. Example, my lord, is this, my lord, which I have stated in my, my lord, writ petition also, my lord, is this tender, my lord, of Paradeep, my lord.
By IOCL.
By IOCL, my lord. And in fact, my lord, the tendering authority of 2018, 2022.
What was not there?
2018, it's there, my lord. Carry forward. Lordship will kindly take, my lord.
Why are you citing this? I don't get it.
My lord, just to show that carry forward, my lord, is a normal procedure, is a normal practice, my lord, which they actually do and always do.
That has been resorted to here also.
Yes. No, I just wanted to show one more example. That's it.
Unnecessary. Yes. So this is your argument. Yes.
This is my argument, my lord.
Let us hear them then. Yes, Mr. Nag.
Normally, the first argument was with regard to tender conditions. That the quota for the ST were not actually carried forward, or it was not appropriately carried forward as per the requirement. Now, the tender conditions are very clear. Accepting the tender conditions, accepting the total number of requirements as specified in the tender conditions, the petitioner duly participated. Now, if your lordship kindly sees that, he says that now when the writ application was filed, it was filed on 14th of August. If your lordship kindly sees the financial, when the financial bid was open, like declared, kindly sees page, my lord, 141. It starts from page, kindly see page 141, the right hand side last column.
Yes.
1st February, the financial bids were declared on 1st of February. And on 1st of February, the evaluation is closed. The tender was closed. Subsequently, work orders were issued in favor of the successful transporters. Successful transporter in the sense, because your losses have seen, the newer vehicles will get preference. It's not about the transporters, the bidders. It's the trucks. So the newer trucks will get the preference, and till the time the any allocation could be made to the trucks offered by the writ petitioners to the total number of requirements as specified in the tender.
Newer trucks as on the date of the submission of the bids, obviously.
Yes. There was a cutoff date given.
Date
There was the cutoff date given.
Right.
And accordingly, the petitioner could not, the trucks offered by the petitioners could not be allotted because of the age. Not only petitioners, there are several other bidders also, who were also technically qualified, as well as their financial bids were accepted. Now, this is done on the 1st of February. The petitioner, as on 1st of February, petitioner knows whether he will get any truck or not. Petitioner did not find it necessary to challenge that. Even thereafter. Now, if you just kindly see some of the tender conditions, my lord, kindly see page 16 of
Primary
the
challenge is apparently to page 144.
Yes, yes, yes. Now, kindly see page number 16 once. Page number 16, the first page of the NIT. The reasons for showing this is for to know the number of the tender.
Yes.
Top left, my lord. This is the tender number.
Right.
This was floated sometimes in October 2022.
The same has been quoted in 144.
Right. Right.
There's a deja vu in this argument.
Yes. Now I kindly see page 18 once. It was also shown by my learned friend. The number of requirement at page 18. Number of trucks at 30. Just below that. The estimated tank trucks requirement is indicative and subject to change. Now the most important clause, my lord, which is at page 44, clause number 10.
Yes.
Please, my lord. The estimated number of tank trucks shown in the tender notice is indicative and is subject to change. IOCL reserves the right to contract additional tank trucks. So during the tenure of the contract, if there is a further requirement for more trucks, then IOCL has a right to induct more trucks. Now, if you just kindly sees the expression of interest, the impugned expression of interest, which is at page 144. This refers to the same the same tender. It also refers to the conditions also, the tender conditions also. Now, these were existing transporters, means the transporter in whose favor contracts were executed, work orders were awarded. The successful transporter in respect of this tender, in whose favor work orders were issued, and thereafter subsequently contracts were executed, and they have been working. And this is not a new mechanism which has been followed. It was there. It happened from in the 2018 also. In 2018, the petitioner was not successful. So in 2018 also the same thing happened. There was an expression of interest subsequently because of the new requirement, and additional trucks were allotted to the existing transporters in whose favor the work orders were already been issued. Now, Ulysses kindly sees, Ulysses has on an earlier occasion, Ulysses has considered the same issue.
That's why I said deja vu.
This is that order manner. We'll give up. And the same expression of interest, my lord. Can this is the what is the impugned challenge? Para 2, 5th August 2023. The same one.
Yes.
The same one. Now the findings of your losses starts from paragraph 11, man. Internal page 4.
Same tender, another set of petitioners. Another petition.
Yes, yes.
And what about this 5 tank trucks, 60-30, this argument?
The carry forward one.
Carry forward thing.
That calculation I have to bring because that is not a subject matter of challenge, my lord. Because the petitioners, whatever may have been the calculations, those were all accepted by the petitioner, and thereafter he participated in tender. Because under the tender, there is a policy for carry forward. There is a tender conditions for carry forward, even in this tender also, and that must have been done.
Yes, the primary challenge is to this expression of interest.
Expression of interest. And the tender is closed in February. My lord, this writ application has been filed on 14th of August. Only after this expression of interest was issued.
Right. So let me hear. Yes. Any reply? Short reply, Mr.
Very short, my lord. Page 140, my lord. 141, my lord. Learned friend showed, my lord.
141, right.
It says, my lord, 1st of February 2023, my lord, what made me wait so long, my lord? Lordship will kindly come to page 140, my lord. May have been, my lord, updated in their, my lord, internal communications, my lord. The date is, my lord, 9th of August 2023, my lord. That's what my instructions are, my lord. Second, my lord.
That is the date of printing, my lord. That is the date of printing.
My lord, I shall. Then, my lord.
This is the date when it was printed out. Because these are all available on the portal. Whenever someone takes out a printout, the date will appear there.
Right, Mr. Hodder.
Yes, my lord, because if your lordship sees, my lord, at the bottom also, my lord, the date is 9th of August 2023. So perhaps Mr. Nag is right, my lord, in that case, my lord. But my lord,
they
so
would
far
not
as
have waited till 9th of August to upload it if the status was uploaded on 1st of February.
When it was uploaded, it is there at page 143. Well, can you see the summary?
Yes.
Updated on 1st of February 2023 at 6:46 p.m.
Even the name of the uploader strikes a chord.
It's there. It's there.
Strikes a chord.
It's there. It does, my lord. But in any event, my lord, even then, my lord, I'm not barred by limitation as such, my lord.
No, not at all.
Yes,
Where
my
is the
lord.
question of limitation?
Yes, my lord. That is it, my lord. Next, my lord. He says, my lord, new trucks were to get preference, my lord. I did not have a new truck, my lord, so I did not get preference, my lord. May I, my lord? The trucks were to yes. Lordship will come to page 127, my lord. One 27 till 136, my lord. These are my trucks, my lord. Smart card, my lord. Lordship will kindly see, my lord, date of registration 21st November 2022. But as I said, my lord, not just me, my lord. Everyone had new trucks. So this is an incorrect submission that my trucks were not new. Everyone had new trucks, my lord. But so far as, my lord, 2018 tender is concerned, my lord, and I'm told that, my lord, I did not participate, my lord. And in fact, my lord, if there was any expression of interest, my lord, in case of 2018 tender also, my lord, my learned friend, my lord, should be able to put in, my lord, that, my lord, by way of an affidavit, my lord. My instructions, my lord, in 2018, my lord, with respect to the 2018 tender, my lord, there were no subsequent expressions of interest, my lord. These are my instructions, my lord. Now, my lord, so far as, my lord, the calculation with regard to, my lord, carry forward is concerned, my lord, my learned friend, my lord, still does not have an answer, my lord. So had I been, my lord, and so far as, my lord, this order is concerned, my lord, this does not take into consideration, my lord, the carry forward. The reason being, my lord, must have been, my lord, that the writ petitioner, my lord, may not have been of the reserved category. I am of the reserved category. So I was entitled to, my lord, the benefit of carry forward. And it's not that, my lord, they have not carried forward. They did. But not in its entirety.
That you participated knowing fully well the numbers.
I'm sorry?
You participated knowing fully well the numbers.
Yes, I am not speaking out of context. I am also saying that you should specifically perform the contract. The contract says that there has to be carry forward. I saw the terms and conditions of the tender which also spoke of carry forward. So I was happy. I knew in 2018 the reserve categories were not fulfilled. So I was happy. I'm also depending, my lord. I'm also stressing, my lord. I'm also relying on the terms of the tender.
The tender document clearly says the requirement is 30. You participated. You were allowed in the technical stage.
So 30, yes, 30.
So the basis
seven-
has to be 30. It cannot
Yes.
be, the basis cannot be 60 and your 7.5% comes to 5. That argument cannot be accepted.
Even then,
2 remain.
2 remains.
Then that is dependent on page 144 challenge.
144?
Page 144 challenge. If they take from the same persons, then you don't come in. If 144 goes, page 144
Not-
goes, then you come in.
Yes, my lord. Had they taken or had they carried forward, either me or someone else would have got it. Then either me or that someone else would also have been the existing tenderer, my lord, the existing supplier. So why should I not get the benefit of it? Right.
The petitioner participated in a tender floated by the IOCL in the year 2022, where the requirement of tank trucks shown in the tender document was 30. Push up, next para. Learned counsel for the petitioner contends that the previous similar tender contemplated a requirement of 60 tank trucks within bracket TTs. Pushed up, next para. It is argued that taken in proper perspective, comma, the present requirement should have been more. Pushed up. It is argued that as per both the said tender documents of 2018 and 2022 respectively, comma, the percentage reserved for ST/MSE was 7.5%, which comes to 5 TTs if the total number is 60, and TO2, 2 TTs, numeral 2, 2 TTs if the total number is taken to be 30. Push up, seen from such perspective, comma, the petitioner apostrophe trucks ought to have been issued work orders, comma, it is argued. Push up, next para. The primary challenge, comma, however, comma, preferred in the writ petition is to the document dated August 5, 2023, annexed at page 144 in the writ petition, comma, which is depicted as an within double inverted expression of interest, double inverted clause. Push up, learned counsel for the petitioner challenges the very basis of such expression of interest being issued, comma, since the same, comma, it is argued, comma, contemplates further trucks being absorbed from the interested within double inverted existing double inverted quote transporters. Pushed up, it is submitted that the said expression of interest was dehors the contemplation of the tender of 2022 itself and ought to be struck down. Pushed up, alternatively, comma, it is argued, comma, the tender itself ought to be reopened from the technical stage. Push up, next para. Learned counsel for the respondent IOCL places reliance on an unreported judgment dated October 4, 2023, passed in WPA 19421 of 2023, where another bidder in connection with the same tender had challenged the expression of the same expression of interest which had been turned down on the ratio laid down therein. Push up, it is submitted by placing reliance on clause 10 of the tender document that the same specifically provided
Well, only one information, my lord.
Yes.
Work orders in respect of this expression of interest were all issued on 30th of September 2023.
22.
23, my lord.
23, sir.
In respect of the expression of the impugned expression of
Right. কি বললাম? Of the tender document কেটে দাও, of the tender terms and conditions, comma, which are part of the tender document, comma, that the estimated number of tank trucks shown in tender notice is indicative and is subject to change. Push up IOCL, comma, it was mentioned, comma, reserves the right to contract additional tank trucks. Push up next para. Learned Council submits that the financial bid was declared as long back as on February 1, 2023, which is evident from the annexures to the writ petition. But the present challenge was preferred on or about August 14, 2023, only after issuance of the impugned expression of interest. Push up, it is further argued that in terms of the expression of interest, comma, further TTs have been granted work orders on September 30, 2023.
Among whom there are many candidates also, SC candidates. 5. I have handed over the table. 5.
Push up next para. It is not disputed between parties that out of the said persons who were issued work orders, comma, there were at least 5 SC candidates. Push up next para. The plinth of the arguments of the petitioner pertains to the expression of interest dated August 5, 2023. Pushed up. Next para. The issue was settled in the cited judgment where it was observed, comma, inter alia that clause 10 of the terms and conditions contained the provision that the estimated number of tank trucks shown therein were indicative and subject to change, and that the IOCL reserved the right to contract additional tank trucks. Pushed up, it was observed that in terms of the said tender, the IOCL had full liberty to grant further work orders in respect of recruitment of additional tank trucks, comma, however, comma, for the period as stipulated in the parent contract, that is for 2 years with option of extension up to 1 more year. Pushed up, the same time period, comma, in the it must be mentioned, comma, has been adhered to in the present case as well. Pushed up. Next para, the impugned expression of interest, comma, as held in the earlier judgment was published on August 5, 2023, which is within the stipulated outer limit of the contract period. Pushed up, thus, comma, the expression of interest falls within the purview of the parent tender and its provisions, and the specifications stipulated in the expression of interest tally exactly with those of the parent NIT. Pushed up, next para, hence, comma, the argument advanced by the petitioner with regard to the expression of interest dated August 5, 2023 cannot be accepted, comma, since the same was utterly within the contemplation of the parent tender document. Pushed up, next para, in fact, comma, the expression of interest impugned herein was not a fresh contract to interdict with the operation of the previous NIT of 2022, and as such, there is no irregularity in issuing the same within the conspectus of the NIT. Push up next para. As regards the challenge of the number of TTs carried forward is concerned, comma, the petitioner having participated in the tender of 2022 and having succeeded in the technical stage, you did not succeed in the technical stage. You did having succeeded
And financial as well, my lord.
in the technical stage, comma, cannot be permitted to resile from such position and challenge the number of trucks carried forward. Full stop. In fact, comma, the present challenge has been preferred long after the publication of the financial bid on February 1, 2023, comma, only after the expression of interest was issued on August 5, 2023, full stop. Hence, comma, such delay on the part of the petitioner cannot be permitted. Full stop. Next para, having participated in the tender and having succeeded in the initial stages, comma, merely because the petitioner is apparently affected by the expression of interest issued subsequently within the periphery of the original contract, comma, the petitioner cannot be allowed to take such a chance at a belated stage. Full stop. The petitioner, while participating in the present contract, was fully aware of the number of tank truck requirements and that the estimated tank truck requirements were indicative and subject to change, and was also aware of the tender terms and conditions, including clause 10 as indicated above. Full stop. The numbers concerned were well within the knowledge of the petitioner, but the petitioner chose, still then, to participate in the tender. Full stop. Hence, the argument as to the nitty-gritties of the numbers of tank trucks which were required to be carried forward cannot be, does not now lie in the mouth of the petitioner insofar as the present challenge is concerned. Full stop. In such view of the matter, there is no scope of interference in the writ petition. Accordingly, WPA 19818 of 2023 is dismissed on contest without any order as to cost.
Great one. This word dismiss hurts the most, my lord.
No, doesn't matter, Mr.
It's, my lord,
You're doing so many matters.
it's really difficult, my lord, to fight the system specifically when, my lord, the bargaining powers, my lord, are not the same, my lord. They are tenderers, my lord. I am, my lord, trying for a tender. It's tough, my lord. Clause 10, my lord. Of course, my lord, they can come up with, my lord, several such notifications, my lord.
You took the advantage of the entire tender process. While you succeeded, you did not have any qualms. So this bargaining power argument does not lie in your client's mouth. Definitely not. And not in these tenders which are totally commercial. You own a line of trucks probably. You are not a wee villager, I mean,
No, my lord, for
a
this, my lord,
naive person who knows nothing about the
because-
matters of the world.
because
And
one of, my lord, one of the conditions being,
you
my
also
lord,
have your own bargaining power.
the age of the trucks, my lord. Everyone, my lord, but I am told that everyone purchased new trucks, my lord.
Age of the truck I
Everyone.
have not gone into because
No, no,
that
no,
would
no.
be a
Since-
fact-finding thing.
No. Since that was one of the criteria, my lord. So I'm told, my lord, that everyone, my lord, purchased new trucks, my lord, to be successful in that tender.
You
my
took
lord.
a commercial chance.
Everyone. Obliged.
17.
Yes.
Lordship, I appear on behalf of the petitioner. Lordship, due to an inadvertent mistake in the prayer portion, I am praying for withdrawing the application with liberty to file afresh.
What is the error in the prayer portion?
Lordship, it has come as a prayer for restoration, but my grievance is for new fresh connection.
Very well. On the prayer of the petitioner due to certain technical errors in the writ petition, WPA 21120 of 2023 is dismissed as not pressed with liberty to the petitioner to file a fresh writ petition on the self-same cause of action by effecting necessary corrections to the prayer portion of the writ petition and the particulars thereof, if so necessary. No other
Grateful,
cause
Your
that is.
Grateful, Your Lordship.
Lordship, I am for the petition.
Yes.
Lordship, I have served on the
Good service on all. Yes.
Well, I appear for the state.
Lordship. In this matter, Lordship, I am praying, I am challenging Lordship inaction of the.
Can you please come a bit closer?
Lordship, I am challenging inaction of the respondent authority. Lordship, petitioner is a senior citizen who has been thrown out from her residential house by her son and daughter-in-law, Lordship. Petitioner made complaint to the district magistrate under the Senior Citizen Act and requested the district magistrate to take action under section 22, but did not take action. Lordship, petitioner husband purchased the property and where the petitioner husband and petitioner has been residing, but thereafter, after the
So have you taken resort to the Senior Citizens Act?
Lordship.
What is your application?
Lordship, kindly see page number 30.
What happened to that?
Lordship, PD's son and daughter-in-law are unlawfully entered into the
What happened to that application?
respondent authority silent on this point. Lordship, did not take any action.
So I'll direct them to decide the matter
Lordship,
quickly.
kindly direct them within the specific time because Lordship petitioner
Out of your
remain,
home.
here and there, Lordship, like a beggar, Lordship. Kindly.
Yes, I'll direct that, Mr.
Well, it has already been done. This is my instruction. Your Lordship will kindly have a look. Well, there are two cases. Well, one filed by the petitioner, which has culminated in a charge sheet. There, the provisions of the Senior Citizens Act is my lord, it has been incorporated. And the second case, my lord, there is a counter case by the daughter-in-law that has also culminated in
This is not under the Senior Citizen Act.
my lord, possibly is there.
You did not file any application under
So
page,
I have,
page 30 is an FIR.
Lordship, previously I have made application, the police
Yes.
authority take
Well,
action,
kindly-
but police authority file FIR, but DM
Second
district
page.
magistrate, district
But
magistrate under the
kindly have a look, second page, last but one paragraph. My lord, in course of inquiry, it also reveals, your lordship has found the paragraph, my lord, that the petitioner submitted complaint against her son, daughter-in-law, respondent number 6 and 7 over the complaint, Shipur PS case number such and such under section such and such of IPC and 24 of Maintenance and Welfare of Parents and Senior Citizens Act 2007 was registered, and after investigation, the case ended in charge sheet, White Shipur case number such and such.
only FIR has been lodged, Lordship, but did not
No,
take
charge
action
sheet.
to
Charge
protect
sheet
right,
has been-
property
Charge
and
sheet
life.
is on a criminal footing.
Criminal
This
footing.
Senior Citizen Act is not exactly,
Lordship.
it's not a criminal proceeding as such. You can ask for several reliefs,
I
including cancellation of the.
Lordship, I have asked for several.
Where is that application? I don't see that application of yours.
Kindly see, Lordship.
Show me, which page?
Page number 30, Lordship.
30 is an FIR.
No, Lordship, 30.
Page 30 is FIR, Annexure P3.
Kindly.
I don't find out that application at all.
31, kindly see, Lordship, 31. Lordship. Mistaken.
That has to be filed before the SDO.
SDO, DM, Lordship, district magistrate, I have filed, Lordship. I have annexed, Lordship. District magistrate is a proper.
Page 32 is, it has to be in a particular format.
Lordship.
Not like this.
Lordship,
You assist your client,
Lordship,
you ascertain the format and apply properly.
Lordship made complaint because the respondent did not give any proper form regarding this procedure.
Proper
but-
form is applicable in the office. I'll give her liberty to take the assistance of an advocate, which right she has before this forum.
But Lordship, this complaint also can
This
be
this is the only a correspondence.
kindly, if you- Lordship,
File
kindly
a
see
proper
prayer,
application.
Prayer, kindly sees the prayer. I have made the.
There is no
also-
prayer in this at all. Where is the prayer portion in that? Page 32 in my
Yes.
copy. An application under provisions of Senior Citizen Act. Which provision? What is the prayer? Nothing. In the circumstance, I request you to inquire into the matter and take lawful action.
So that I can decide, Lordship.
If you could write such a representation in English, I mean, you can very well file an application in proper format. She did not write it herself, obviously. Some learned advocate helped her.
Lordship.
The petitioner contends that she is a senior citizen and has been turned out by her son and daughter-in-law and is running here and there, ousted from her house. Full stop, next para. Complaints being lodged by her in that regard, no steps, it is alleged, are being taken by the subdivisional officer, that is respondent number 3. Full stop, next para. And counsel for the state hands over a written instruction where it is indicated that there were complaints and counter complaints by the son and daughter-in-law as well as the petitioner, which have been taken care of. Upon undertaking investigation, charge sheet has also been filed. Full stop, next para. It transpires from the annexures to the writ petition that although the petitioner wrote a representation to the district magistrate Howrah capturing the same as an application under the provision of the Senior Citizen Act, 2007, no specific provision has been quoted, nor is the petition in proper format, or any specific prayer has been made therein. Full stop. Next para. Accordingly, WPA 21445 of 2022 is disposed of by granting liberty to the petitioner to apply in proper format before the concerned authority under the Senior Citizen Act. Full নামটা একটু দেখে বসিয়ে দিতে হবে. Senior Citizen Act. Full stop, if such an application is made, it is expected that the concerned authority, that is the SDO,
Lordship, district magistrate.
that is the concerned authority under the Act, shall decide such application on merits as expeditiously as possible, preferably within 3 months from the date of such application being made. Full stop. Insofar as the charge sheets having been filed, it is expected that the criminal trial in that regard shall be taken up expeditiously. No less to cause urgency.
But the instruction may be kept on that.
Instructions filed today by learned counsel for the state be kept on record.
On grid.
Lordship, may I pray, Lordship, kindly give 2 month time, Lordship, instead of 3 months.
2 months, it's not possible for the SDU to complete the, because you have to be heard, evidence has to be taken, these things have to be done. 3 months is also a short period. You help your client, ascertain from your friends what is the correct format. Even I don't know the proper format, but ascertain from your friends, you definitely get help.
19. Lordship, I am for the applicant. Lordship, it's a changed brief. Lordship, the matter was filed in the year 2022. But Lordship, in that time, the prayer was to restructure of the loan amount. My client is a rice mill owner.
How can the REIT code grant it? Can I compel the bank to restructure the loan amount? Under which provision?
Lordship, it's a changed brief that I've been telling Lordship, the point is now, the property is sold already. And it is not confirmed, Lordship, it is not registered. Lordship, I can rely upon on Supreme Court order. I'm showing it afterwards. But Lordship, the client, the applicant is trying to pay the money within 2 days, 25%, and rest would be paid by 15 days, the amount asked by the bank. Actually, Lordship, the 50 workers are working in there.
The sale has not been finalized.
Sale finalized, Lordship, but it is not
Sale
registered.
certificate has been issued.
Sale certificate, I don't know.
If sale certificate has been issued, Supreme Court is against you.
Yes. No, Lordship, it's not
Specific direction of the
it's not registered till date, Lordship. It's not registered till date.
No need, not.
No need.
Sale certificate is conclusive sale.
Lordship,
that is the Supreme Court judgment.
Lordship. Lordship, in this situation, 50 workers are working in there, Lordship.
I appreciate, but nothing can be done at this point of time. I mean, you have lost your chance.
Lordship, it's my prayer, Lordship, if it can possible, because 50
not possible
workers-
for the court as per the Supreme Court's own verdict. And once the sale certificate is issued, you cannot then, redeem the mortgage. You are the borrower.
I'm the borrower.
You cannot now come back.
Even a Lordship, many fact has been suppressed. SABYASACHI application is still pending for adjudication. They have filed an application for redemption. That redemption opportunity was given.
Oh.
They undertake to file within 7 days. They did not turn up with money. Thereafter, the sale confirmation was affirmed by the learned tribunal below. Preferred an appeal. DRAT directed to pre-deposit, default. Everything has been suppressed.
Now sale certificate has been issued.
Everything has been done.
The present challenge has been preferred against the action of the bank taken under the SABYASACHI Act. Under section 13(4) of the SABYASACHI Act, full-stop learned counsel for the petitioner contends that the bank may be directed to consider restructuring of loan, comma, in the alternative, the petitioner is agreeable to pay 25% of the debts due within 2 days and the balance amount within 15 days thereafter. Full stop. It is submitted that insofar as the instruction of the petitioners go, comma, the sale has not been registered as yet, and as such, an opportunity of redemption be given to the petitioner, comma, particularly since the petitioner number 1 is a rice mill where about 50 workers are working, comma, whose livelihoods are dependent on the outcome of the writ petition. Full stop. Next para. Learned counsel for the bank controverts the arguments of the petitioner and submits that several facts have been suppressed. Full stop. It is submitted that there is a pending application before the Debts Recovery Tribunal in connection with an opportunity of redemption was given to the petitioner within 7 days, comma, which the petitioner failed to honor. Full stop. A subsequent challenge was also preferred, in connection with which the petitioner again failed to pay the amount. Full stop. Subsequently, the sale was confirmed and ultimately a sale certificate has been issued, thereby concluding the process of sale. Full stop. Next para. Upon hearing learned counsel for the parties, it transpires that although the petitioners seek to show their bona fides, comma, it is a bit too late in the day to do so, comma, since the sale certificate has already been issued and the process of sale has been finalized. Full stop. The petitioners, having previously failed to honor the commitment of payment of debt, even after being given opportunities to redeem, comma, cannot now be permitted to reopen the entire process of sale at this belated juncture. Full stop. Accordingly, WPA 21752 of 2022 is dismissed without an order to cost. Sorry, it was well argued, but nothing to it. Yes, Mr. Yes. For the Hajj.
Report has been done that criminal case is pending. And my lord, there is a provision of the Passport Act that even if there is a pending, if it is specific purpose, that he might be allowed. The process is going to be initiated on 29th. So, Your Lordship, kindly enough to take up orders, my lord. This chance I will not avail.
Very well. If I can't reach today, tomorrow at the top. Inform your other side.
I'm great.
ওটা বরঞ্চ tomorrow at the top করে রাখো 45 টা tomorrow at the top.
I'm great.
Take your lordship.
Thank you.
Item 20.
My lord, I beg to appear on behalf of the petition in this matter, my lord.
20 my lord, I am for the respondent.
Right.
Yes.
Sorry.
My lord, this matter.
Probably, my lord, matter is infractuous that already.
May I just
my lord,
place
the
my case?
Position of the hall station, my lord, that has
May I
been
just
handed
place my
over.
case, my lord?
Yes.
My lord, the petitioner is an halt agent engaged in selling tickets, railway tickets, for the passengers. My lord, he has been doing this work for since long through this tender and agreement extension. My lord, the last extension was up to 20th of November 2023, just 2 days back, my lord. Now, my lord, meanwhile, in July 2023, a tender was floated for that same halt station, that those who are interested who can participate in the tender process for selling the tickets. Now, my lord, I participated in that rightfully, since it is getting over on 20th. I participated. My lord, there are two essential conditions of the tender. First being that the person has to be from the locality. First essential condition, he has to be from the locality. And secondly, if there are more than one suitable candidates, then only the lottery system will be resorted to. Now, my lord, I participated. I am the only person from the locality, since I am the only person for last 20 years I am rendering this service at the hall station. I was the only local person who participated in the process. But my lord, when I was called for this interview round, there is a sort of interview taking the documents and all. Over there, directly the matter was resorted to the lottery system. And other contenders, those who are not from the locality, were considered for that lottery system, and subsequently, my lord, possibly they have chosen someone for that. My lord, then and there I made a representation before the authority, and the writ petition was filed since there was no action on the part of the authority. My lord, I draw your lordship's kind.
Unless the first condition was fulfilled of the locality.
Exactly.
Could not have participated in the.
Absolutely, I'm grateful. Now it says, I'm showing to your lordship, page 20 for once. Kindly take, my lord, page 20 for once. My lord, this is the 3rd July 2023 notice inviting tender. My lord, I directly draw your lordship's attention to the eligibility qualification criteria written in the box below. First condition, residential certificate. Certificate from district commissioner, sub-district officer, circle officer, block development officer, Gram Pradhan, to verify whether the applicant is a permanent residence in the local same district in which the proposed station is located. My lord, kindly take into consideration the last line of this page itself. No application is entertained in the absence of above 5 certificates, documents along with prescribed application form. So this is the essential condition. The first, I'm relying upon the first.
What are the 5 certificate documents?
My lord, this educational certificate is there. Age, date.
2 has been repeated twice.
Yes, I'm not on that, my lord. That is not my cause of action.
Very well. Yes.
My lord, kindly take the next page. The first condition, A, terms and conditions. A selection committee of senior scale officers from commercial, finance, and operating departments shall scrutinize and shortlist the eligible offers. Selection will be by a draw of lots drawn by any child if there is more than one suitable candidate. All the eligible candidates should be advised the date, time, and all. So, my lord, these two things are very important. More than one suitable candidates. There has to be plural, number has to be plural, and they have to be suitable. Now, in my humble submission, my lord, I say I am the only person of the local residence. Therefore, the question of subsequent more than one suitable candidates do not arise at all. And subsequently, my lord, I show to your lordship that my tenure is getting over on 20th of November. Before that, I filed this writ application. That
20th of November, that tenure is on the basis of your previous selection.
Previous, that is getting over on 20th.
So that does not make this infractuous.
No, absolutely. That's why, since my learned friend has submitted, because previously I made this representation and this writ petition as well. My lord, my certificate is annexed in page 45 and 46. These are my residential certificate.
But the successful candidate is not a party here. That's
we do not know who is the successful, because in that verification.
So that is your point in this writ.
These 2 points, my lord.
What is the second point? First point.
First point is I am from the locality. Second point is they cannot resort to lottery system. Or it is only the precondition of lottery is that there has to be more.
It is the same point.
Yes, my lord.
You are the only eligible candidate
and
since you are the.
And my lord, what something happened since 20th is over. I have been coerced and pressurized to hand over all the tickets and to put signature in the document. My lord, I intimated, my learned friend had intimated them that the matter is pending before the honorable court. I had to put a signature somewhere, a page, and I had to, because I cannot breach the law for that, my lord. That is
Yes,
my
what is your?
Yes, my lord.
Why has it become infectious, you are saying?
Well, already, my lord, they have, my lord, the
handed over the charge of their halt station, my lord.
That is regarding the previous
Yes,
effort.
my lord. Anyhow, my lord, 2 point is this, my lord. One is locality, and second point is that the only he was the only single person for this reason. No draw of lots not necessary. But my instruction is, my lord, that there is the 5 candidates after the shortlisting, and all are within the same district. And in the draw of lots, the petitioner was also participated.
Yes, yes. Participate.
All are, my lord, within the district of Purbo Medinipur, my lord.
Yep.
My lord, total 5%, and all are from the Purbo Medinipur. And kindly come this page, my lord. The petitioner was also participated in the draw of lots in presence of the other officials of the railway. And my lord, the
If that be so, then your
I do not have any case. If that is the situation, my lord, only one thing. May I just come back and ensure that whether this is the situation? Only 1 day time may be given to me, my lord.
Learned counsel for the petitioner argues that as per the tender conditions, comma, which is impugned here in comma, the candidates had to be permanent resident of the locality stroke same district. Pushed up next para, it is submitted that although the petitioner was the sole candidate who participated in the interview process belonging to the said locality, comma, lots were drawn, comma, which is the next stage only if there are more than one eligible and suitable candidates. Pushed up, it is submitted that such action on the part of the tender issuing authorities was dehorse the notification inviting the applications, comma, since the lots could only be resorted to if there were more than one eligible candidates, which is not the present case. Pushed up, next para, learned counsel appearing for the respondent authorities hands over a list of the candidates who participated in the interview. Push up, it transpires therefrom that all the said candidates were residents of the same locality stroke district, comma, which renders the petitioner's allegation toothless. Push up, next para, learned counsel for the petitioner seeks a day apostrophe adjournment, take instructions on the said list. Push up, accordingly let the matter be adjourned for the day and be listed day after tomorrow.
Tomorrow itself, my
Oh,
lord.
very good.
Tomorrow
It's
itself.
listed tomorrow at the top of the list.
If I do not have any case,
Obviously,
yes, I would not linger it, my lord.
with the record that the petitioner is already charges handover.
I had to. I had to.
That does not have any record.
Lord, there is no need. I can submit before your lordship if I'm not.
Very well. Arekta line add করিন, the petitioner, the respondent insists that since the petitioner has already handed over charge to the respondents, comma, the writ petition has become infructuous, full stop. However, comma, the said contention is not tenable, comma, since the charge which was handed over by the petitioner was under compulsion, comma, being having been given to the petitioner by virtue of a previous interview which has no nexus with the present cause of action.
Grateful, your lordship.
21.
Yes, sir.
Service
has been affected. Huh?
That's what I asked first. Yes.
Yes.
You check the Malat. Yes, Malat has been done.
What is the matter, sir?
Malat, here, Malat, the petitioner, Malat has Malat ferroalloy materials, Malat business. So, Malat, they have to, Malat, whatever they manufacture, they get it off at several places, Malat. Sidings, we know them as sidings, Malat. These sidings are, let's say, from the regular stations, they are in some other portion where the train goes and deposits the freight. Now, Malat, the railways has a rate for this entire process. From the starting station till the siding, Malat, they have a rate which is revised from time to time. I'm very in short, I'm telling you, Lordship. So, my lord, from time to time, they revise the rates. And my lord, I have this siding at Jhargram. Specifically for Jhargram, my lord, the Railways Department issues circular revising rates on a periodical manner. And at that rate, my lord, I am raised invoices. I have paid also. Now, my lord, your lordship will appreciate that I have to take this from my end customer also. So I have obviously charged that. So transaction is complete. Now we are talking about a period, my lord, from 2011. Now, my lord, in 2019, a circular is issued, a special circular by one specific railway administration, that is the Southeastern Railways, my lord, saying that the rates are increased.
Retrospectively.
That is my point, my lord.
Please show me that, sir.
Yes, my lord. That is why now, my lord, I'm a complete, my lord, I have been made to pay also, my lord. That's the worst thing. Coercing, telling me that I'm holding on to your materials. My lord, kindly takes page 81. My lord, the type copy is at page 82, my lord. '81 is quite legible if your lordship wants, my lord.
Yes.
My lord, kindly sees on the, this is, my lord, if your lordship sees, it would be Southeastern Railways, my lord. Then, my lord, sees on the basis of information furnished by senior DOM KGP about working of the siding by diesel locomotive, the rate of siding charge was fixed and notified earlier on the basis of average trip time and AIEHC of diesel power after vetting. Now, my lord, this is their admission now. By a traffic accounts branch. The rate is being revised from time to time following the revision in AIEHC. Owing to switchover from diesel to electric locomotive at PSOR since November 2011, the date of inception of electric power, the per trip rate of siding charge has been fixed with the help of average trip time and the all India engine hour cost in respect to electric engine. As vetted by traffic accounts branch, the rate of siding charges are as notified below. Now, my lord, kindly sees they are changing the from 2011, 2012, 2012, 2013.
You are challenging this.
My lord, I am challenging this. And my lord, I am also seeking my refund of the money which they have taken from me on the basis of.
We have already paid.
I have paid, my lord, because, my lord, I'll show the letter, my lord. Your lordship, sorry, my lord.
Page 107.
Page 107, lordship, my lord, I know the tongue twister. If your lordship
But
sees,
Mr. Then we have to maybe affidavits have to be directed. Then there will be some delay.
I know, my lord, that part, your lordship, my lord, let them take no further coercive steps on the basis of this, my lord. Because, my lord, they're coercing me, they're saying that.
You have already paid them.
No, my lord, I do not know, my lord, again they will increase the rates. My lord,
That will
kindly
be a
see.
future cause of action.
No, my lord, why I'm
They
saying
increase
this?
rates in future, we cannot interdict that.
No, my lord, what I'm saying, my lord, on the basis of this, they should not ask for any further money because there is one payment, my lord, I'll point out, my lord. My lord, kindly takes page 106.
That dues might not have been paid.
Yes, my lord, that is what I'm saying.
The limited challenge in the writ petition is that the railway authorities, by the impugned notification dated December 20, 2019, have enhanced the freight charges substantially with retrospective effect since November 2011, although during the interregnum, the petitioner's cargo was duly carried and the petitioner has cleared off all freight charges in full and final settlement of dues between the parties. Push up next para. Learned counsel for the petitioner contends that although some of the charges might have been paid by the petitioner under compulsion, let no coercive action be taken during pendency of the writ petition on the basis of the said claim. Push up, since a strong prima facie case has been made out by the petitioner on the ground as indicated above, the writ petition is required to be heard on merits. Accordingly, the respondents are directed to file their affidavits in opposition within December 14, 2023. Whose reply, if any, shall be filed by December 22, 2023. The matter shall be listed on January 2, 2024 for hearing. Full The respondents shall be restrained during pendency of the writ petition from taking any further coercive action in terms of the impugned claim by way of enhanced rates dated December 20, 2019, annexed at page 81/82 of the writ petition.
But only one thing, my lord. That would be impugned with humility. Impugned circular, my lord. On the basis of
notification-
this, they have raised that claims, my lord.
Notification যেখানে বলেছি সেখানে circular করে দিন। Circular.
My lord, impugned circular, my lord.
Wherever I have said notification, it will become circular.
No, my lord, your lordship has said the impugned claim of 20th December.
Claim
It
will
is
be
not a claim, my lord. It is a circular on the basis of which claims have been raised, my lord.
very well.
I'm sorry, my lord.
Claimটা না করে claimটা circular করে।
I'm so sorry, my lord.
No, no.
I'm very grateful to you, lord.
Thank you.
For this, I'm so grateful to you.
22.
Yes.
My lord, I am for the petitioner.
Right. Service.
I appear for the private responding numbers 4, 5, and 6.
My lord,
Dr. Shari, you are for the rest.
I am for CSC.
Yes.
my lord, I am the owner of a jewelry shop room, my lord. My prayer is I want the new service connection in my shop room as well as the protection from the private respondents as they are continuously trying to.
Who are they, according to you?
The 4 to 6, they are my landlords, and the other private respondents, they are the local people, my lord.
Yes. What is your ground for?
Your Lordship, we admit that he is our tenant. We are the landlord. He's not the owner, as he's stating. He's a tenant.
No, now he's saying he's a tenant.
Yes, he's a tenant. So we have no objection if a new connection is given in the tenanted premises. So far, may I submit? So far, in the tenant, there is an existing service in the name of the petitioner, and the petitioner is deriving electricity from the said meter, Lordship. Now, at this juncture, if another connection service, there will be splitting of load. My admitted position, the petitioner is getting supply, and there is a specific, your Lordship kindly see at page 19. Supply is there in the name of the petitioner.
Not petitioner, him.
No, petitioner. Yes. That's why I'm saying, Lordship. Petitioner has got the supply and he is deriving electricity in the self-same premises.
Yes.
Now, again, he is applying for the another connection. One thing can be done if we need the enhancement of the load, then they can apply for the enhancement of the load. We are very much there to do that. But in the same place, we cannot give another electrical.
Yes, what do you say to this?
My lord, I beg to differ from my learned senior friend because what my learned senior friend is saying, that line is in the 9 Lalji Shah Street. That is a whole another shop room, my lord. That belongs to my son.
This is the same thing.
And
These are not structurally separated.
Yes,
and if
my
your
lord.
lordship kindly see if in paragraph 4, where he admit that he is deriving electricity from that place.
Yes.
So it is not structurally separated and the same premises, and otherwise we could have taken the penal action against them. Since we have not taken any penal action and 8 and 9 are not structurally separated in the same premises, and there is a existing electricity connection in the name of the petitioner, and the petitioner is deriving electricity from the same premises, my lordship, further connection cannot be given at this juncture.
Well,
if he needs, he can enhance the
Let him
load.
answer. Let him answer. Yes.
My lord, the 8 Lalji Shah Street, that is a 1-storied shop room. At the adjacent plot, that is 9 Lalji Shah Street, that is a developed 4-storied G+3 building, my lord. And that is, I was compelled to derive electricity from 9 Lalji Shah Street because before that, there was another line where from I was taking electricity that was cut by the private respondent. I have pleaded so in my writ petition. My lord, I have specifically pleaded that in 8 Lalji Shah Street, in my shop room, I want the new service connection. And the thing about deriving electricity from 9 Lalji Shah Street, that is being cut by the private respondents. They are saying that
9 connection.
That is being cut means that has been cut.
that has been cut, my lord. The MCB thing has been cut down by the private respondents. They are saying that that is a different plot. That is a flat.
Private respondents are residing at 9.
The 7 to 9, my lord, they are the owners of the
residing at premises number 9.
Premises number 9. And my son's store is at premises number 9. Therefrom, I am deriving electricity.
But you have said that they are in the landlords are in 10 or something like that. Para 3.
The landlords, the 4 to 6, private respondents 4 to 6, they resided 10 SP Mukherjee Road.
Factual question, go to the GRO.
Yes, I think
Learned
that
counsel for the petitioner submits that the petitioner sought for an electricity connection for running his jewelry shop at 8 Lalji Shah Street, Damdam Cantonment, Kolkata 7,28,000, full stop, However, due to resistance by the private respondents, it is not being given by the CAC Limited. Whose of it is further argued by the petitioner that the petitioner used to enjoy electricity from the adjacent premises number 9 Lalji Shah Road, where his son is occupying, but the said connection was
in the name of petitioner
severed by the private respondents. Whose of next para, the private respondents through counsel submit that they have no objection to the petitioner taking an electricity connection at premises number 8 Lalji Shah Street. Whose of next para, learned counsel appearing for the CAC Limited submits that the petitioner is enjoying an electricity connection in his own name from premises number 9 Lalji Shah Street, which, although an adjacent premises, is structurally the same building as 8 Lalji Shah Street, for which there will be a splitting of load if a new connection is given to the petitioner. Full stop. Next para. It is further submitted that if the petitioner seeks an enhancement of load, the petitioner may so apply, which the CAC Limited is willing to give. Full stop. Next para. The moot question which arises here is whether the premises number 8 and 9 Lalji Shah Street, although marked as several as different premises, belong structurally to the same construction stroke building. Full stop. If so, there might be some justification in the objection of the CAC Limited, semicolon. Otherwise, there cannot be any restriction to giving electricity connection to the petitioner at a separate premises. Full stop. However, the writ court is not the appropriate forum for adjudicating such issue on facts, which requires factual inquiry and the consideration and appreciation of material evidence. Full stop. Accordingly, WPA 23902 of 2023 is disposed of by granting leave to the petitioner to approach the concerned grievance redressal officer for resolution of the issue raised in the writ petition. If full stop, if so approached, the GRO shall decide the issue upon hearing both sides in accordance with law as expeditiously as possible, positively within 6 weeks from the approach being made by the petition.
Your Lordships, my Lordships, the private respondent denies the allegations which they have made.
Since no affidavits have been directed, it is deemed that none of the allegations made in the writ petition are admitted by any of the respondents.
My lord, may I seek one indulgence, my lord? My lord, if it is found that 8 Lalji Shah Street is a separate shop room,
I've given sufficient hint.
Grateful.
Grateful, Lordship.
23.
Yes.
Yes. Milord, this writ petition, Milord, has been filed, Milord, against the order of suspensions, Milord, issued by the West Bengal State Bar Council's, Milords, of a learned advocate, Milords, of committing his misconduct, alleged misconduct, Milord. Milord, the fact is this, Milord, that the allegations made in the complaint is this, Milord, that the plan that the respondent, private respondent, handed over a check of rupees 1,25,000 for making payment of first installment of the banking loan, Milords, towards the home loan, but the same was not deposited with the concerned bank or the debt recovery tribunal. That was misappropriated by the respondent, and thereby he committed misconduct. And then
so that was connected in any manner with a litigation.
Yes, my lord. Then ultimately, this matter was relegated to the disciplinary committee, and the disciplinary committee passed the final order, my lord. I invite your lordship's attention, my lord, to the order at page 129.
Before my learned friend proceed, is this application is maintained under section 37 of the Advocates Act? If he is aggrieved, he can
challenging the disciplinary committee action.
Yes.
Order dated 26/6.
Yes, my lord. Because this is an my lord, this is a discretionary jurisdiction because there is an appellate forum, my lord. But here there is a state violations of principle of natural justice, my lord. So that is why, my lord, that the jurisdiction.
One of the forums will be usurped by this court.
Yes, my lord. But in view of Whirlpool's case and all others, my lord, these exceptions, my lord, that if there is any violations of the natural justice, my lord,
Both of
yes,
you will
my lord.
lose a forum.
Yeah,
Both of you will lose a forum.
yes,
If
my
I
lord.
entertain this writ petition, suppose I dismiss it, then
Yes.
you lose a forum, otherwise they lose a forum. So why not exhaust that forum? Exhaust that forum and come back.
Section 37 of the Act, absolutely clear.
My lord, this is absolutely violative of principle of natural
So
justice.
let me hear him.
The face of it, my lord.
Yes.
I
Show me that
invite
it
you-
comes within the
yes.
window of 226.
Yes, my lord. My lord, both the parties has agreed to settle the case and the complainants has agreed to withdraw the complaint on payment of rupees 1,25,000 being the amount claimed to have.
Sorry, I missed the page number. What is
Yes,
the
my lord, page 129.
Page
এই ওইটা বার করো, যে ও করতে পারে না। Rule
দুজন
is not
দিয়েছে?
permitted.
page? 129, yes.
129. Both the parties are agreed to settle the case and the complaint has agreed to withdraw the complaint on payment of rupees 1,25,000 being the amount claimed to have been paid to the respondent. The respondent has agreed to pay a sum of rupees 1,25,000.
Tell me what is the palpable violation first before entering into the.
Yes, my lord. Palpable violations, my lords.
You have been given a hearing.
Yes, my lord. Yes, my lord. No, my lord. No no opportunity of hearing was given. What happened, my lord? This order was passed behind the back of the respondent, my lord. Because respondents never agreed, my lord, to any settlement, my lord, because he has committed no wrong, my lord. That would be apparent, my lord, from the documents annexed in the reply to the show cause notice as well as on the comments, my lord. So, my lord, so this order was passed behind the back of the knowledge, and this is also without jurisdictions, because in view of the rule, my lord, state bar council, my lord, cannot drop the proceedings or get the matter settled. That power has not been given by the rules, my lord. I invite your lordship's attention at page 139. At page 139, the chapter 1, rule A clause 4, sub-rule 4, at page 139.
No, this was not an order passed on agreement ultimately. The
No.
first order says both the parties are agreed to settle the case.
Yes, my lord, but this
Ultimately,
firstly-
it's not an
this
agreement.
was passed, my lord, behind the back of the petitioners, my lord.
Behind the
First,
back
and that
means
was not communicated.
without notice to you.
Yes, my lord, that was not communicated. That was present. He disagreed to any settlement because he never committed any wrong, my lord. So that is why he disagreed. This order was passed, my lord. Subsequently, this order was passed, my lord. It was never served. Even the order passed on 26th June 2023, next page. That is the final order suspending the respondent. That was also not communicated. But under the law, he should be communicated. And that should be signed by the registered. Even that was neither signed nor it was communicated.
Yes, let us see page 139.
There's a page
You are
139.
placing that, yes.
Then the sub-rule 4, my lord. No matter taken up by a state bar council show motto or arising on a complaint made under section 35 of the act shall be dropped solely by reason of its having been withdrawn, settled, or
This does not
otherwise.
apply here. That has
So-
not been done.
so-
Why are you
so-
placing this?
So that's right. So therefore, it was my contentions that it should be heard out, my lord.
Yes.
It cannot be settled, my lord. So then, my lord, what happened, my lord? So because, my lord, it was recorded that as if I agreed to the settlement, and this order was recorded on 23rd June. That was not communicated to me. Then the next order at next page, 26 June 2023. The respondent thus failed to appear in terms of assurance given during the course of hearing on 26 June 2023, wherein respondent agreed to pay to the complainant a sum of rupees 1,25,000 by account pay check on Monday, that is on 26 June 2023 at 4:15 hours in presence of disciplinary committee of Bar Council of West Bengal, and the complainant had agreed to settle the matter after receiving the said payment. The respondent has failed to appear today, that is on 26 June 2023, as promised with a check of rupees so and so, raised in favor of the complainant, where telephone calls were made to the advocate so and so by phone number so and so, thrice which was not respondent to. Therefore, the order to be passed in this matter is reserved. As per Bar Council of India rules, the order is to be passed today, that is on 26 June 2023. Under such circumstances, the disciplinary committee of Bar Council of West Bengal cannot wait anymore for the respondent to respond, and thus accordingly the order will be passed accordingly. treating the matter as fully heard and considered, parties may note the order from the office of the Bar Council of West Bengal in due time.
It is said that you are tried to be contacted thrice and you did not respond, and all these allegations are there.
No, Milord, that is your never done, Milord. And firstly, why I should be contacted, Milord, over telephone, Milord? Why not, Milord, through notice, Milord? I invite your lordship's attention to the rule. Take it up. রুলের ইয়েটা কোথায়? রুলটা দাও। ওই যেখানে রেজিস্টার সার্ভিস তো।
No, section 35 of Advocates Act, which they have placed, is also relevant.
Yes.
That also contemplates a notice to be given.
Yes, Milord. That is the first, Milord, that when the complaint was filed, Milord.
That was
notice
given to you.
The notice was given. I filed written statement. I filed comments, Milord, disclosing all the documents, Milords, that how the account settled, Milords. This was appropriated towards fees, Milords, and that account was settled by the respondent himself. Private respondent himself, Milord. So the allegations is absolutely reckless, Milord. That would be apparent if your lordships enter into the merit of the case. Now, Milord, I am on state violations of the acts and rules, Milord. It is the mandatory requirements, Milord, to serve the, Milord, to sign the order by the registered, and, Milord, that should be communicated, Milord, to the parties, Milord. Then, Milord, next order, Milord, at page 131.
Yeah, sir, again, we ordered him. Action 114.
Then, Milord, 114 page number.
Bar Council of India rules.
Of the Bar Council of India rules, Milord. 114, sub-rule 2.
Bar Council of India rules.
এখানে annex করা আছে তো।
Correct.
Yes, Milord. At page 141.
And in the main petition also.
Page 141 of the writ petition.
It's been 141 of the writ petition. Rule 14.
Yes, 14.
The finding of the majority of the members of the disciplinary committee shall be the findings of the committee. The reason given in support of the findings may be given in the form of a judgment, and in the case of a difference of opinion, any member dissenting shall be entitled to record his dissent, giving his own reason. It shall be competent for the disciplinary committee to award such cost as it thinks fit. The registrar of the disciplinary committee shall send free of charge to each of the parties in the proceedings a certified copy of the final order or judgment as set out in Rule 36 in this chapter. So therefore, the petitioners was entitled to have the copy of the proceedings which was passed on 23rd.
If that is not given, that does not vitiate the order passed previously.
No, Milord. Yes, Milord. My respectful submission is this, Milord.
Yes.
That had I been given, Milord, this opportunity, Milords, then I could have attended, Milords, on 26th, Milord. Milord, 26th.
The post-order provision. The registrar of the disciplinary committee shall send free of charge to each of the parties certified copy of the final order. This is after the final order.
Each proceedings, Milord.
Each parties, each of the parties.
Each of the parties.
After the final order is passed, copies will be served on each of the
final
parties.
order of the judgment
that
of
does
the
not vitiate the order, previous order.
এর আগে যেটা 15 সালে আগে মেইন ইয়েতে অর্ডার নাম্বার পেজ নাম্বার 94 এ আপনি রাখবেন না।
Is it your case that no opportunity of hearing, you filed your written statement, no hearing was given to you subsequently?
No, Milord, what happened, Milords, that when the complaint was filed, Milords, that Milords copy of the complaint was given to me, Milord. Then, Milord, I filed a written statement, Milord, and also comments, Milord. Then thereafter, Milords, this hearing, Milord, the date of the hearing was fixed, Milord. I attended, Milords, on 23rd, Milord.
তার আগে 15 তারিখে একটা বলবেন স্যার, বাট ওটাতে ক্লিয়ার হয়ে যাবে, কারণ ওটাতে হচ্ছে গিয়ে দেখে পড়ছে একবার পেজ নাম্বার 90।
Then you better
Milord,
take out an appeal. I don't find any occasion to interfere under 226 because factual questions are required to be gone into. There is nothing palpable here.
This is absolutely violation of natural justice because the final order, Milord.
Which principle of natural
on
justice?
26th, Milord. That is on 26th, which was passed at page 131, Milord.
Yes.
Milord, that the final order dated 26 June 2022. This was passed, Milord, without extending any opportunity.
The Bar Council, they have stated that as per Bar Council of India rules, the order is to be passed by today. Why do they say that? Is there any rule?
No, because one here, yes, Milord, that under the section 36, Milord, of the Advocate Acts, Milord, that the proceedings, Milord, has to be completed, Milords, within 1 year, my lord, that the
So
disciplinary
1 year was
committee-
elapsing on that.
Yes, yes, yes. The disciplinary committee of a state bar council shall dispose of the complaint received by it under section 35 expeditiously. In each case, the proceedings shall be concluded within a period of 1 year from the date of the receipt of the complaint or the date of initiations of the proceedings at the instance of the bar council, as the case may be, failing which the proceedings shall stand transferred to Bar Council of India, which may dispose of the same
So
as
before this date, there was no hearing as such.
Yes, my lord.
Only this consent.
No, my lord, my respectful submissions is this, my lord. What, my lord, that the committee, my lord, came to a findings, my lord. That, my lord, I
am
felt
asking a specific question. Before this order number 13, there was no
yes.
hearing of the matter on merits. Was
No,
there?
No, my lord.
Only this agreement consent, this thing was going on.
Yes, yes, my lord.
Very well. You may have a point in
Yes,
saying
at page, my lord, I invite your lordship attention at page 94, my lord. First at page 94. Order number 11. On call, both the parties are present in persons, heard both sides. Both parties are directed to file affidavit in support of their case 2 days before the next date of hearing. Next date is fixed on 23rd June at 4 p.m. No notice need to be served upon the parties as both parties are present today. So therefore, my lord, to
have
file
you got copies of
affidavit-
the previous orders?
Yes, my lord.
Have you got copies of the previous orders?
94.
It has
Yes,
been
my lord, at
annexed
page
this-
94, order number 11. That is previous order.
What affidavits were directed to be in support of the case, please?
All affidavit was filed, my lords, by the yes, my lord.
After these affidavits were filed.
Yes, my lord.
But there was no date of hearing actually.
Yes, my lord. And my lords, on 23rd, my lord, this date was fixed, my lords, and my lords, and the committees, my lord, tried to get the matter settled, my lord, and this order even passed behind the back of the petitioner. Petitioners never wanted to get the matter settled. And because the question of settlement doesn't arise, because the rules
Settlement failed, they passed an order on merit.
because they cannot, my lord. This, my lord, this
settlement question of settlement has become ocious because settlement did not
Yes, my lord.
materialize.
Yes, my lord. Yes, my
So
lord.
how is it material? You are saying repeatedly that they don't have the jurisdiction to settle the matter.
because-
it was never settled. It was decided on merits.
No, because that
your best point.
No, that is why they proceeded further, my lord. Then once again, I'm reading out this order. That
No,
both
this
the-
I've read twice. I've read
yes,
twice.
yes, my lord.
Yes.
So, my lord, what happened, my lord, on 26th, my lord, no notice was given to me. There was no opportunity of hearing.
That is the precise question I'm asking you from the beginning.
That's right, my lord. That is, my lord, the violation of natural justice. And even after passing the order, that was also not communicated. And this order, even this order was not signed by the members, my lord.
Which order?
The final order.
3 persons
At
have
page
signed.
131.
3 persons have signed, I saw.
That page 137.
This is a copy.
This is a certified copy, my lord.
Yes. So all 3 have signed, apparently. SD
And-
means they have signed in the original.
And this was and this right, that might be, my lord, but this was not communicated, my lord.
Mr. Chatterjee, only one, only one question.
Yes.
Violation of natural justice. Now, as per the Advocates Act also, as you handed over rightly, they have to be given a notice of hearing and a hearing has to be held. You said 1 year is expiring today, so we are closing. But that is not a proper hearing because before that, order number 13, 12 and 13, this conciliation was going on, that failed. So directly you close the arguments and...
No. Your lordship, can you come to page 135? May I place this?
Yes.
In detailed statement, in several paragraphs, the respondent admitted the acceptance of financial transaction but made denial that the said money has been paid to the advocate opposite party for settlement of the loan. In detailed statement also, the advocate opposite party admitted several emails sent by the complainant along with the written statement that several documents were filed, but nowhere the advocate opposite party denied the transaction. In the fourth corner of the written statement, there is a whisper that the advocate opposite party took any positive steps in any DRT or at all took initiative to settle the matter. It is also admitted that the written statement in para 22, the complainant has taken all records of cases of on 16/12/2014 with no objection. It was also admitted that account settlement was also discussed with him. That is, with the complainant, and after consultation with him, the date it finalized, and thereafter the complainant delivered the check of rupees 1,25,000. However, this committee on several sittings called upon the advocate opposite party to appear before the committee and were also asked to show cause why the transaction does not come under the purview of Section 35 of the Act, inasmuch as on the basis of the newspaper publication under the heading notice, the advocate opposite party approached the complainant on the basis of the address given by the bank of the complaint. However, it appears that the advocate opposite party appeared on 23/6/2023 before this committee and agreed to settle the case. Consequently, if the advocate opposite party pays the said amount of rupees 1,25,000, that is the amount claimed to have been paid by the advocate opposite party, the advocate opposite party undertake to give 1,25,000 by account pay check on Monday, that is on 26/6/23, to the complainant before the disciplinary committee of the Bar Council of West Bengal takes up the matter on 26/6/2023. No further notice is required. It was fixed on in his presence. It further appears that in another order dated number 13/26/6/2023, advocate opposite party has failed to appear in terms of the assurance given during the course of hearing on 26/6/2023, wherein the advocate opposite party agreed to pay the complainant the sum of rupees 1,25,000 by 4:15 p.m. on 26/6/2023. It is also pertinent to mention here that advocate opposite party has failed to appear on 26/6/2023 as stated above and failed to pay the amount as committed by the advocate opposite party. Furthermore, the committee members, including the chairman, through register, tried to catch up the advocate opposite party over telephone, being phone number such and such tried, but no response was given by the advocate opposite party. Therefore, Bar Council West Bengal Disciplinary Committee has no other option but to dispose of the matter by 26/6/2023 as per the direction of Bar Council of India within 1 year from the date of sitting of the proceeding of the committee, finally finding no other option but to pass appropriate order. What to do,
Mr. Chatterjee, you proceeded only on the basis of the written statement and the agreement between the parties had failed.
Even my lord, this is a wrong recording. my lord.
One minute. My lord, if the party concerned appeared, suppose before a court of law. Before a court of law, if any allegation has been made against one party, his advocate on instruction says, my lord, this allegation is correct. We are going to pay this amount. Settle this issue. Very well. Court says, very well. Next day you bring the check. If the party does not bring the check, my lord, normally the court used to proceed with the matter on merits, whether he is entitled for the payment or not.
Mr. Chatterjee, here they did not admit in the written statement that the allegation is correct as
No.
they said yes, the money was paid, but they owed an explanation. They had to explain what was the circumstances.
And on 23rd.
But then, Mr. Chatterjee, there were talks of settlement going on, which failed ultimately. If before a court of law talk of settlement fails, I'll give you an opportunity of hearing, definitely.
No, not failed. Maybe I'm not clear. Well,
he did not appear. It failed.
On 23rd, he assured the committee that I shall pay the amount.
Right.
On 23rd June. Accordingly, on 26th, the matter was fixed.
For payment.
For payment. But suppose he cannot pay on 26th. He could have appeared before the committee and said, no, I will not pay. Proceed with the matter finally. He could have. He did not.
Even also he can.
And my lord, for that, the violation of natural justice cannot come. No. Opportunity has been given. If I do not give any opportunity, thing could have been done. When I have given the opportunity, if you are not accepting the opportunity, how would you are alleging that natural justice has been violated? May I put this question to myself? It's not. My lord, your lordship fixed a matter. Not your lordship, any court of law. Any court of law fixed a matter on a particular date in presence of Mr. Dotto, who is representing X. Neither X.
Mr. Dotto is becoming shaky upon hearing.
No, Mr. Dotto did not appear.
Particularly after hearing X.
His junior did not approach before the court of law, asking for any adjournment, for any accommodation, anything. Then, May I put this what the court will do?
Now comes 37 and 30.
And your lordship kindly see, after this, when a person approaches the writ court, avoiding 37, why?
And 38.
Why? Because he is alleging natural justice has been violated. If the natural justice is violated, then the alternative remedy is no bar. That's the original principle that I know. Mr. My learned senior friend Pradipda is not required to say anything more on that. I have heard all these things from them from my childhood.
My only respectful submissions before your lordship is this, my lord. When my lord, this is because it involves my lord civil consequences, my lord. Because my lord, my right to my lord.
Lord, I won't interfere in 226. I'll give you that liberty. I won't seal your fate from here, but your conduct is not good. Mr.
And
Chatterjee has
also,
a point there. as a point.
my lord, only two. My lord, I will demonstrate two documents. my lord.
1 minute. If he is failed in 37,
Supreme Court.
he can file an appeal before the Supreme Court, not before this honorable court.
Yes.
That is the provision of the.
And I'll give him that liberty to prefer
No,
an
my lord,
appeal.
this is
Otherwise, because your conduct is not good.
no, my
You
lord.
agreed to
That
pay on the next day.
yes, my lord. That I will show, my lord. My lord, it has been recorded, my lord, in the order that I have admitted, my lord. So, my lord, I invite your lordship's attention to the written statement, my lord, page 92, my lord. Page 92, my lord.
So I'll give you the liberty to approach in appeal.
Yes.
Learned counsel for the learned senior counsel appearing for the respondent at the outset takes an objection as to maintainability of the writ petition, comma, since an appeal under section 37 of the Advocates Act is available to the petitioner, against which an appeal lies before the Supreme Court, puts up as such, comma, it is submitted that the writ petition may not be entertained by this court. Puts up next para. Learned counsel for the petitioner submits that since there was no occasion for the petitioner to agree to any proposal of the complainant before the Bar Council Disciplinary Committee, comma, the petitioner ought to have been given an opportunity of hearing before deciding against the petitioner. Puts up such opportunity, comma, it is contended, comma, was never given to the petitioner, thereby violating the principles of natural justice. Puts up, even as per the rules, even as per the Bar Council of India rules, comma, a copy was to be circulated among the parties free of charge, which has not been done within the stipulated time in the present case. Puts up next para. Learned senior counsel for the respondents reiterates that the petitioner agreed to a settlement of the claim in finality. Puts up, however, comma, on the date fixed for making such payment, comma, the petitioner was absent despite repeated phone calls. Puts up next para. Since on the said date, comma, the statutory period of 1 year from the complaint was expiring, comma, the Bar Council Disciplinary Committee did not have any option but to close arguments, and subsequently the order was passed. Puts up next para. The scope of interference in the present matter under Article 226 of the Constitution of India is extremely limited. Puts up. It transpires from the order dated June 23, 2023 that both the parties were recorded to have agreed to settle the case, and the respondent therein, that is the present petitioner, had agreed to pay a sum of rupees 1,25,000 in full and final settlement of his claim. Puts up the next date, that is June 26, 2023, was fixed only for making such payment, which the petitioner failed to do. Puts up, prior to the said date, comma, the petitioner had been given ample opportunity to file written statement, which had been filed by the petitioner. Puts up, thus, comma, there is nothing palpable ex facie on the records to indicate that the principles of natural justice were violated in any manner. Puts up, comma, sufficient for this court to interfere under Article 226 of the Constitution of India. Puts up, this court chooses to exercise its self-imposed restriction in not interfering under Article 226, comma, since an equally, comma, if not more, comma, efficacious remedy is available to the petitioner by way of an appeal under Section 37 of the Advocates Act. Pushed up next para. Thus, comma, even without going into the merits of the allegations and counter allegations made by the parties, comma, WPA 24119 of 2023 is disposed of by granting liberty to the petitioner to challenge, to assail the impugned decision of the West Bengal Bar Council Disciplinary Committee dated June 26, 2023 before the appropriate appellate authority. Full stop. If such an appeal is preferred within a fortnight from date, comma, it will be deemed that the same has been filed in time and shall be decided in accordance with law upon opportunity of hearing being given to all concerned. Full stop. No address to cause certain city.
অ্যাপিয়ারেন্স দিয়ে দিয়েছি
এগুলো ওনাকে আর এগুলো
Next.
24.
For the petitioner.
Yes, Mr. Banerjee, 24.
My lord, this, my lord, has been
for the respondent number 1 to 4.
pleased to consider on an earlier occasion this issue.
Yes.
My lord, this relates to my lord coal linkage. My lord, initially we had a fuel supply agreement that was, my lord, on the allegation, I would say, my lord, that my lord, we were diverting coal. That was, my lord, terminated. This is, my lord, on 23rd May 2016. My lord, the original fuel supply agreement, my lord, was on 30th April 2008. That, my lord, has been pending. My lord, the policy now says that, my lord, that 5-year period, my lord, is the maximum, my lord, which is possible. My lord, after that, my lord, I again wanted, my lord, participation for, my lord, in the auction, my lord, which comes up now. The linkage auction, my lord, which comes up, I wanted participation. But naturally, my lord, because of the issue, because, my lord, the FIR, my lord, is pending, my lord, they have said that I'm banned, therefore, my lord, I cannot participate. My lord, earlier judgment on this. Gotcha. My lord, will recall, my lord, that interpretation of, my lord, whether it ceases, because if the ban, even if you're banned, then also it is 5 years, then what is, my lord, will find, my lord. Para 8, the document is question.
When was the ban imposed in your case?
My lord, this is, my lord, on 23rd May 2016 was, my lord, the cancellation. Termination, that's at page 43.
And any ban was there? Debarment?
No, it was, my lord, a cancellation of, my lord, the termination, which, my lord, has to be, my lord, considered. If, my lord, comes to page 43, and this, of course, my lord, we had, my lord, challenged, my lord, the show cause notice and everything, my lord, in a writ petition. That also had said that they will reconsider, my lord, the whole issue.
So what are you challenging now?
My lord, I am challenging, my lord, my refusal, my lord, to not allowing me, my lord, to participate, my lord, in the coal auction.
In the absence of a debarment, they cannot do that in any way.
That's
there is no debarment you are saying here.
My lord, here, my lord, can you look at page 120? There's no debarment. It was terminated, my lord, it's correct. But the FIR, my lord, and all that is pending. But 120, my lord, this is, my lord, what we got, my lord, from MSTC.
The investigation is still pending in connection with that FIR.
Yes, my lord, I'm told.
Investigation, a charge sheet has been filed.
Shit, na jane bol. Charge sheet. Yes, my lord, I correct that. Yes, my lord. Charge sheet, my lord, was filed, my lord, in where's the date? 2021. I'll just check on that, my lord. We had
2021. You are sure you have not been convicted in the meantime?
No, my lord, I don't think, my lord, at least, my lord, that's, my lord.
She's proceeding one by one. I mean,
first, my lord,
FIR,
then, my lord, charge
sheet in 2021. We are in 2023.
FIR, my lord, was in 2016.
2016.
15 February 2016.
So what is the fate of the trial?
When
I mean, if you have been convicted, then it's different.
My lord, I've not been convicted, my lord. That's what, my lord, we have also.
Yes, there is a debarment. This page.
My lord, at page 120.
So there is.
That's what they say, my lord. We also got opinion, my lord. It seems, my lord, now, my lord, CCL and, my lord, Coal India also, my lord, differing. My lord, we have got they have only, my lord, we have got copies of opinion which one says yes you can, one says you cannot. But be that as it may, my lord, the main point is that my lord, on the question. And, my lord, I also must point out the show cause notice was challenged, my lord, the 23rd May the termination. Then, my lord, by the division bench, my lord, it was said saying that you again hear out the issue.
Which is pending.
Which, my lord, after that, my lord, they have again, my lord, at 3rd March 2021, again they have reiterated what they had said earlier. That's, my lord, page 101. And my lord's order, my lord, which I was relying on, which, my lord, was
No, this debarment is of 2021.
this is again, my lord, but my lord,
Which falls within 5 years.
yes, but my lord, 16 is, my lord, when I've been, my lord,
It's the termination.
My lord, that's the debarment, my lord. Otherwise, my lord, there's no debarment.
No, termination and debarment are separate components of action. Termination is one thing, debarment is completely different. Termination is the termination of that contract only.
Yes, but
Debarment
my
is
lord, on the basis of, my lord, the FIR.
Yes, whatever. I mean,
Yes, so, my lord,
your particular contract was terminated on whatever basis.
yes, but, my lord, my participation, my lord, could not happen, my lord, from 2016. So I've been suffering from 2016.
No, but your termination does not preclude you from participating. It cannot. Unless there's a specific debarment which is there only in 2021. 5 years have not elapsed, so this judgment is not applicable.
My lord, we were, my lord, counting, my lord, of course, my lord, from 2016, because that's, my lord, when I stopped
No, Mr.
being, my lord.
Your best case might be that there is no reason to this debarment unless they say so. Because otherwise, this debarment is of 2021. This ratio does not apply here.
My lord, this
is the first debarment, only debarment.
My lord, at page, my lord, is
page 120 is the debarment.
120 is no, it says has been debarred. Doesn't give the date.
There shall be a stay means the stay will operate from.
No, they're not debarring me. This is MSTC. Can you see this? It is to inform that the bidder Swastik Smokeless Company Private Limited has been debarred from participating tranche V CPB linkage action.
Nothing is given. No detail is given.
This is as per the instruction provided by the respective coal subsidiaries.
Can I see that order of that termination, Mr. Banerjee?
Yes, Malo, that's page 43. Page 43.
Yes. Let us see whether there is any indication about debarment there.
No. Lord, any consequent upon lodging?
No, nothing. The show cause was regarding termination. You have been terminated, and caption is also termination.
It is also called upon explanation which should be submitted. And such, page 43, Malad is looked at.
Anyway, Mr. Banerjee, if this is the only communication received by you, page 120, then they have to explain when you were debarred at all, if at all. If you are not debarred,
no, there are other Malad communications. Malad, kindly come to Malad because this was set aside and Malad it came back. Kindly see Malad page 88. And this Malad, the same 4A Malad will recall Malad. This is and this is 15th September 2020. So 2021 Malad has not come yet. Noted the well qualified editions and such and such.
This is a show cause sort of regarding termination.
But what I'm showing, Malad, this fact indicates that Malad I'm banned from before. Then Malad, we gave replies which are Malad also at page.
Debarment is never mentioned anywhere. Debarment or
that is the only communication which came to say coal companies have informed us that MSTC.
You are challenging what? Page 120?
I am challenging Malad page. No, Malad, 120 really Malad because for non-participation, not being allowed to participate. And Malad, there are also other letters Malad which have been.
You have been refused participation by in writing.
Yes, that is Malad page 120. And Malad, there's also Malad if Malad looks at.
Oh, this is the only refusal.
No, there are more refusals.
Other refusals.
Other refusals.
You have
to that.
challenged something regarding scheme published to forthwith give effect to the scheme as a notice dated. Oh, that you want?
Yes, yes. That is one of the scheme Malad, under which Malad, I got that. Yes,
years.
yes, yes. Malad, there are other communications. No, 101.
The writ petition is absolutely vague, Mr. Banerjee. You you have sought declaratory reliefs and all. Declaration that declaratory order to the effect that notification be implemented. What does it mean? Implemented how? It's vague.
It should have been Malad by participation. Malad, I've asked.
Please come to page 35 your prayers. Declaratory order that you are entitled to participate and take supply of coal in the forthcoming auction.
Malad,
but that is dependent on the.
Yes, Malad, E is Malad more specific.
But that has to be consequential upon a challenge to this debarment or whatever. You have not challenged any.
Malad, even if Malad, I'm on the question, if Malad looks at Malad judgment, 5 years passes, then Malad, automatic Malad, I come back. That is Malad, my Lord's judgment.
There is no debarment here at all. Where is the question of 5 years?
Malad, from 2016,
any debarment.
2016, I can't take coal supply. And on the ground, Malad, they've also said FIR is pending. Yes.
43 is not a debarment at all.
But that's Malad, the ground on which Malad, my.
Let us hear them. Where is the debarment? Yes. Where is the debarment? I don't find any debarment at all.
As far as the debarment is concerned, I have to also take instruction as to whether debarment has started from 2016 or 2021.
I don't find any debarment order at all.
So far as the documents as appearing from this writ petition, what I find that they have not pleaded anywhere that they have earlier tried to participate in the tender, and on the ground of pendency of the criminal case, they were not allowed to participate.
No, they're relying on page 120.
So far as 120 is concerned, as your lordship has correctly pointed it out, it is
the only
2020-21. But so far as your lordship's judgment is concerned, your lordship has clearly decided that 5 years being the outer limit, whether criminal case is
provided there is a debarment order in the first place.
Yes, my lord, on that, my lord, I have to take instruction whether.
So there will be an interim order that they will be permitted to participate subject to the outcome.
So right now, the tender in response to which they have come, that tender is already, my lord, over. That auction is, my lord, already over on 30th of October. So far as
filed it earlier.
I have received, my lord.
Work order has been issued.
Yes, my lord, it's my lord completed, my lord. And my lord, kindly come to page 101 of the writ petition. Well, this has, my lord, dealt with the issue as to diversion of the coal as committed by the company, and there is forfeiture of security deposit. In terms of
termination, I found.
Yes. So this is the one of 2021. They have finally.
No, I'll hold that. I don't find anything on record to show that they have actually been debarred by an order upon hearing them. Because for debarment, you have to give a show cause.
My lord, let me, my lord, come back, my lord, tomorrow or my lord, day after to take a specific instruction as to whether they have been debarred from 2016 or 2020.
Even if you come back tomorrow with such an instruction, you have to put it on oath by way of an affidavit in opposition. So in any event, I'll have to direct you to file your affidavit in opposition to show that there is a debarment.
Well, let me come back with the instruction. If they say that yes, they were not able to participate from 2016, then your lordship's judgment will not holds. So that's why you let me
know. Senior counsel appearing for the petitioner contends that the petitioner was terminated long back in the year 2016, by placing reliance on an unreported judgment of this court in Aroma Coke Limited and another versus Coal India Limited and others, reported at unreported reported at 2023 SCC Online Cal 2110, it is submitted that the outer limit for which the said termination stroke debarment can operate to preclude a party from participating in a contract is 5 years, which has long elapsed. It is submitted that as per an email communication dated November 12, annexed at page 120 of the writ petition, the petitioner was informed that the petitioner had been debarred from participating in tranche TRANCHE V CPP linkage auction as per scheme document, full stop. However, comma, apart from the termination in 2016, comma, no debarment has been ever communicated to the petitioner. Full stop. Next para, it is thus submitted that the petitioner ought to be permitted to participate in all upcoming tender processes floated by the Coal India Limited. Full stop. Learned counsel appearing for the petitioner, for the respondent, seeks 2 days adjournment to take instruction as to whether any order of debarment was specifically passed against the petitioner. Full stop. Next para, for such limited purpose and for passing further orders, comma, the matter is adjourned till Friday, till November 24, 2023, when it will be listed at the top of the list. Top of the list. Friday?
Thursday.
Oh, I'm sorry. Monday then.
Monday,
Monday is a holiday, 28th. On November 28, 2023, at the top of the list. Where? Delhi or Bombay or somewhere?
No, I'm here, my lord. My junior is not there, my lord. That's why, my lord.
Tell me a date when should I keep?
Thursday then, my lord, for
Thursday. Very well. তাহলে 28th না করে ওটা 30th হবে।
I'm grateful.
অরিত্র 30th.
I'm extremely.
My lord, I'm so sorry, my lord, taking up the original site. My lord, item number 30.
Sorry because I am taking up.
No, my lord. Sorry, my lord, for my mention, my lord, interrupting my lord's code.
Yes.
My lord, item number 31. My lord, it kept is a updated motion, my lord. The difficulty is that, my lord, I have been blacklisted. Now, my lord, I have not been allowed to take part, my lord, in the upcoming tenders, though I am the lowest tender.
We'll continue tomorrow.
My lord, if my lord kindly, it may get some preference tomorrow because
further
2 p.m.
preference.
Difficulty is that, my lord, 2 p.m. onwards, my lord, we are having some predicament, my lord, which my lord has been already circulated.
What is the compilation of years of practice in the letter?
My lord,
Ask Mr. Bosumollik to meet me in open court. What is compilation of years of practice?
my lord, can
Anyway,
my lord, kindly, my lord, I'll lose all my tenders, my lord. I'll lose all my tenders, my lord. 200 mast, my lord, I have, my lord, rectified, jacketed, my lord. Despite also, my lord, I mean,
let us try your luck tomorrow. No.
That item number.
At least, my lord, give me some.
One other matter was mentioned. I said that if it is not taken up today, I'll 45.
I'm 31, my lord. My lord, kindly grants me that liberty to at least to come back to lordship, my lord, because my lord knows I don't, my lord, bother, my lord, often, my lord.
Inform your other side, 31 and 32 tomorrow upgraded it. The first two matters in the upgraded list.
Okay.
But I have a request which is diametrically
33.
opposite. 25, no, 25. The
Go out
next
of the
matter.
list.
Next, no, not that bad also. But I come back on Tuesday. There are some documents which are not there. I'll have to. The next matter.
I've already, the original set matters. I mean, we are ready with the original. If it is taken up tomorrow, please ask anybody, any of your friends.
I'll only come and take this.
Just tell any of your friends to mention. I'll just take it.
My lord, one indulgence, my lord. This is an appellate side matter, my lord. But the item number is item number 40, my lord. It's a hatchery business, my lord. The electricity connection has been disconnected.
Hatchery of what? Hatching of conspiracy or?
No, my lord. My lord,
I mean,
my lord will kindly give us some precedence, my lord, and hear the matter, my lord. My item number 40.
We'll have to answer which came first. Before I take up the matter.
The egg of the conspiracy.
My lord, kindly.
Egg of the conspiracy. No. Not in all the matters. Yes, call on the original side.
Any mentioning in original side?
May I have your lordship kindly to mention in the original side, number 26. Item number 26. This was appearing as item number 3 on Saturday. We were there. The respondent wasn't there. No, this is West Bengal Power Development Corporation Limited. 32 crores is stuck. Just some precedence on Tuesday, my lord. Tomorrow. I'm sorry. Tomorrow, anyways, that's right. The compilation is there.
Tomorrow we have a 2 p.m.
We have compilation. So, lordship allows us to come back on Tuesday, my lord. Power
on Tuesday, you are allowed.
No, not the mentioning.
No, let us say. Mention it on Tuesday then when the matter is.
My lordship will give it some precedence. If it was appearing as number 3, the respondents took time. Lord, there is a survey report.
I called the matter.
Yes, we were there. We were there on Saturday.
Can be done.
No, they're taking advantage of this. 32 crores is stuck. This is a prime power generation company of the state.
Three থেকে নিচে চলে গেল কি করে? Motions were given that date.
But I'm told your lordship had indicated it will retain its position, primarily in view of the fact
it is
that
retaining its position in the hearing
it's
list.
come, yes.
No, actually,
Oh, because
this
of
was
the
a third
heading.
hearing list.
The
Yes,
heading.
motions have to come first. No, Mr. Banerjee, no, not right now. Let us take up some motion, then after that we pass. I'm not being able to cross the hearing list. That's the difficulty.
But then may I pray for one thing, 30 more seconds. Could it be fixed on any particular day at a time? Please does that for us, my lord, because we've concluded they are on reply and they're avoiding it.
Itself cannot be a sufficient.
No, my lord, because we've concluded our hearing. They have not addressed your lordship on this point and taken adjournment several times. Keeps it on any day, my lord. I don't have to come back on Tuesday. On any day at a
Waiting for the
particular
other
time.
side.
Lord, we'll give him notice if your lordship.
Notice and mention on Tuesday, tomorrow.
Tomorrow again compilation. I'll mention
tomorrow
on.
we cannot take it. Mention it on Tuesday upon a notice to them. We'll fix it.
I'll do that.
Lord, may I have my lord's kind leave to mention a matter upon notice? This
Yes.
Item 20, your lordship. This
Item
is
20.
20 in your lordship. 20 in the list, my lord. This
Respondent.
was that matter, your lordship remembers. This is the second writ petition we were compelled to file because the competent authority had suspended the board of Unitech, my lord, that Uniworld City. My lord, we tried to move it before the vacation, but the business of the court did not permit. My lord granted us leave to move in the vacation bench. The honorable vacation bench thought that we should come back when the court reopens. Now, my lord, kindly, my lord, consider item 20. If it doesn't reach today, it could be taken up on Tuesday, please, man.
You are
I'm
for
not-
the other side.
Yes, man. He's the competent authority, man.
No, I'm not for the complaint.
No,
I'm
you're not.
for the some of the flat.
He's the
private
respondents who have complained, my lord.
The vacation bench has categorically said that there is no urgency.
Mr. Thakkar, just give a notice to competent authority is represented today. Give a notice to the competent authority, like Mr. Banerjee, please mention it on Tuesday when the original side matters.
We have given notice to the competent authority. I'm sorry, my lord.
I'll fix a particular date.
We've given notice to the competent authority. If you lord, I've given notice, my lord. But if your lordship, if it commences to your lordship, otherwise I'll mention. If
Then
you
we'll come back on December 5th, 2 p.m.
December 5th, 2 p.m. Great.
Not 2 p.m., 3 p.m.
December, my lord. I'm told, my lord, they are trying to hold the election, my lord. Otherwise, I wouldn't
When?
have. They are trying to hold the election. The competent authority is trying to hold the election because he suspended the elected board. I had a tenure of 3 years.
28th is the
28th is
next
a
Tuesday.
Tuesday. Your
28th,
lordship was indicating 5th. That's why I said, my lord.
give another notice and come back on Tuesday.
Tuesday,
Mention
I'll
it.
Great.
If they don't appear, just remind me. They are given 2 notices. They're not appearing. Then I'll definitely fix it as soon as possible.
Grateful.
I'm grateful.
There's a joint prayer for adjournment. We are supposed to bring a suggested orders.
Yes, that matter. When should I keep it? Tell me.
Tuesday.
Tuesday.
I have not received a copy of suggested order. Yes.
You're out of the zone.
Yes.
May I be permitted to mention, Mala? This is item.
No, this mention is not yet over. Tuesday. এটা Tuesday তাহলে item 4 টা Tuesday করে দেবেন I have to record an order একটা order record করিন the matter is being taken out of turn out of turn on mentioning learned counsel for you are for petitioner and you are for
Respondent number 1 bank.
no because you have not been informed, that's why I'm saying learned counsel for the petitioner and respondent number 1 bank submit that the matter be adjourned till November 28, 2023, next para accordingly let the matter stand adjourned till the said date. But give your name also, you are appearing, but you are you are not making that prayer. You said you are not given any notice.
I am not talking about that. They were supposed to give me unconditional order in terms of bank.
For that reason they are asking for time. That is the reason why they are asking for time. 28th.
May I be permitted to mention, Mala?
Yes,
This is
sorry.
item 23 in today's list, Mala. I'm mentioning is because the matter is extremely urgent. Because the petitioner's entire business have been closed down, Mala, and bank account, everything has been closed. This is a new motion, but we haven't given notice for the mentioning thing. Mala, kindly fix it in on Tuesday in the top of the list, Mala. We can provide notice to the other side by today. We could
Give a notice mention on Tuesday. Give a notice mention on Tuesday.
Much obliged, Mala.
Item number 1.
Yes.
I can take the list of dates.
Yes.
Millard on item number 19, Millard in the list of dates.
Right.
after, my lord, we had pointed out that, my lord, even after all documents had been given, my lord, they were still, my lord, harassing. My lord, they had, my lord, they issued, my lord, another letter on 26th March 2004. My lord, kindly take page 91, my lord, of, my lord, the affidavit in opposition filed, my lord, by, my lord, the stock exchange in GA1 of 2022.
Opposition.
To GA, my lord.
Yes. Yes, Mr.
My lord, kindly see, my lord, this is their letter. My lord, I'm just going through several of these, my lord. It may or may not be necessary, but I want the full facts, my lord, before your lordships. Because, my lord, I have to also satisfy your lordship's conscience, my lord, at the end of the day, on, my lord, the merits of the matter as well. My lord, inspection of your firm's books of accounts and records under Securities Contract Regulation Act 1957 as per articles and bylaws. Now, my lord, kindly see this as reference to our letter dated 23rd March, wherein we advised you to appear before the inspection team on 26th with all relevant books of accounts and other documents.
These are actually repetitive exercises on their part.
Correct,
I mean,
my lord.
same
This is, my lord,
inspection.
same, and my lord, our responses, my lord, have gone, and they say, no, you have to still do it. And we say all information, my lord, has been, my lord, given.
Mr. Mukherjee, unless there is anything
No,
special,
my lord,
then
my
need
lord,
not,
my lord, I just thought, my lord, because, my lord,
need not, unless
now,
they point out something which is out of the ordinary.
no. Then, my lord, considering, my lord, this attitude, my lord, on part of the stock exchange, my lord, we wrote a letter to them, my lord, which was, my lord, is at page 42 of the writ petition, saying, my lord, kindly deactivate our terminals and we are surrendering our membership of the Calcutta Stock Exchange. That your lordships will find. My lord, I'm not placing the letter. Kindly take, my lord, the list of dates.
Right.
My lord, I'll just, my lord, it paraphrases it, my lord, so I'll move,
Right.
my lord, quicker. And my lord, 30th March 2004, petitioner wrote to the respond number 1 stating that it is being harassed by them despite providing all necessary documents and complying with rules, sought to deactivate the trading terminal and rights, deregistration and refund of capital adequacy deposits. Now, my lord, these are deposits which are kept by, my lord, a broker, my lord, who's, my lord, member and trades on a stock exchange. It's really a security. We are going out, so kindly return. Now, my lord, there's silence. Then, my lord, we write again, my lord, giving a reminder. Then, my lord, we ask for, my lord, a letter requesting for acknowledgement of the letter of 7th April. Then, my lord, we stated, my lord, again, my lord, stating that despite submission of all requisite, as requested for copies of all was again shared. My lord, in 13th April 2004, we again, my lord, shared, my lord, all these documents. Then letter from respond number 1 to petitioner for appearance before the inspection team, in spite of having inspection is, my lord, to see. My lord, it's not, my lord, to interrogate. And my lord, we have given it. No, but you still appear before the inspection team. Then, my lord, again, 6th of May, my lord, we wrote, the respond number 1 wrote to the petitioner stating that the request for termination of trading membership can be processed only upon completion of the inspection. Now, my lord, kindly note, I just, so that, my lord, we are, my lord, clear on this. My lord, there was, my lord, a writ petition, my lord, which we filed. My lord, challenging, my lord, this communication of 6th of May 2004. My lord, your lordship will find it referred to, my lord, at, my lord, item 27. Because there were 3 litigations, I'm just indicating. My lord, the second one, writ petition 1829, filed for setting aside the letter of 6th May 2004. Now, my lord, the first, my lord, writ petition which is referred to under item 27 of, my lord, the list of dates, serial number 27, is, my lord, challenging a letter of 16 July 2003, which your lordships will find, my lord, at, my lord, serial number 11, my lord, where, my lord, they had directed, my lord, HDFC, my banker, my lord, where I had kept the security, from crediting my account, my lord, with the interest. We said this is wholly without jurisdiction, because it's my security, which I've given,
and my lord, into my account, my lord, the security is X. My lord, it's kept with them. Interest which accrues, my lord, cannot go to them. But they directed HDFC, no, you don't credit their account. My lord, which, my lord, we had also challenged. My lord, by way of a writ petition. And
I
my
don't
lord,
understand this, Mr. Mukherjee.
Yes.
These are which fixed deposits? I mean, I am not
my lord, these
clear
are
on this law.
deposits which are provided,
Hmm.
my lord, as security, my lord, for transacting, my lord, on the stock exchange.
You have provided that
Yes,
those
there's a
deposits have been-
capital adequacy,
Right.
my lord, which we
Yes.
had provided.
Yes.
Now, my lord, this amount, my lord, is kept with them,
Hmm.
but interest also accrues on it.
Hmm.
My lord, that is not to their benefit. My lord, it's always, my lord, the, my lord, broker's benefit. Suddenly they instructed that HDFC, you do not, and this happened as far back as 2003.
Right.
My lord, which we, my lord, had, my lord, challenged. And over and above that, my lord, we also filed a title suit, my lord, challenging, my lord, seeking, my lord, an injunction, my lord, with regard to, my lord,
Inspections.
yes, unauthorized of, my lord, of the ongoing inspection. It can't go on. My lord, I must tell your lordships, my lord, I asked for the order. My lord, it's not there. There was a file noting. We can't get it. My lord, so my lord, we have said there's an injunction. It appears, my lord, stock exchange is also saying the same thing, my lord, in the affidavit. But my lord, I have not been able to, my lord, lay my hands on it. If the stock exchange can give us that order, my lord, I'd be most, my lord, grateful. Then, my lord, we, my lord, now, my lord, one date I've missed out, which is very important, apropos the impugned order. My lord, after, my lord, serial number 28, my lord, kindly take 24th May 2008. My lord, I'll tell your lordships, my lord, why this is important. My lord, kindly take the impugned order once. My lord, which is, my lord, and GA page 154, my lord, it was communicated. My lord, I just want to show your lordships, my lord. Lord, kindly see page 168.
Yes.
My lord, the penalty of 6 lakhs, my lord, which is, my lord, imposed. My lord, that's item 3. My lord, kindly see in substance, therefore, the board of CSC towards the bottom half of the order. Orders as follows. Kindly see 3. Penalty of rupees 6 lakhs in line with the decision of the disciplinary action subcommittee. Kindly note the date of the meeting. At its meeting held on 24th May 2008. So, my lord, according to them, a proceeding, my lord, went before the disciplinary committee. There has to be a reference. My lord, I have to be given notice, my lord, of, my lord, that hearing. I'll place, my lord, the bylaws. And, my lord, after, my lord, that is, my lord, heard, my lord, there will be, my lord, penalty, my lord, imposed. My lord, we've categorically stated, my lord, that there was, my lord, no such thing, my lord, which, my lord, happened. My lord, we were never given any, my lord, notice, my lord, for, my lord, appearance before disciplinary committee, nor were we ever informed about this. Because, my lord, when the board decides ultimately on, my lord, the disciplinary, my lord, committee, my lord, decision, my lord, considers it and, my lord, affirms it, my lord, I have to have, my lord, a notice of that and an opportunity to make a representation, my lord, which is, my lord, not there at all. And, my lord, I had missed out this date, my lord, in, my lord, the list of dates, my lord. This is, my lord, very important, my lord. 24th May, to allegedly, my lord, there was a decision taken.
Have you subsequently got a copy of this?
No,
Or it was
no, they filed an affidavit, nothing. They filed an affidavit, point taken, my lord, by us. My lord, there is, my lord, nothing, my lord, on this. Now, my lord, I'll quickly go through the list of dates, my lord. Now, my lord, and, my lord, one significant thing, kindly note. Therefore, according, my lord, this penalty, my lord, which is, my lord, imposed, my lord, decision taken on 24th May 2008, my lord, means, my lord, that they had, my lord, all the information, because penalty is on the basis of off-floor transactions, funded transactions, and all other violations they referred to except one. That's, my lord, paragraph 2 of the impugned order at my lord, page 168. Now, my lord, paragraph 3 and my lord, the preceding paragraphs before, my lord, the my lord 1, 2 and 3. Now, my lord, 3rd April 2013, my lord, we, my lord, submitted all necessary information documents along with processing fees again and requested for surrender of membership. This is, my lord, 2013. So, my lord, there is a 5-year hiatus, my lord, which is, my lord, there is, my lord, nothing, my lord, happening, my lord, during this period. Then, my lord, we, my lord, this letter I've already placed that SEBI, my lord, said nothing is, my lord, due statutorily from them, my lord, for fees. That's item 30. Then, my lord, 31, respondent number 1 responded to the letter issued by the petitioner on 3rd April 2013, stating that the surrender of membership will be processed after legal cases settled. So, my lord, there were 3 legal cases. My lord, 1 suit, 2 writ petitions. And, my lord, we have surrender of membership. My lord, we are being told that this will be settled once, and this is their letters. Now, my lord, we again, my lord, and 17 June, respondent number 1 returned the application for surrender of membership along with documents and the check for processing fees on the ground that legal cases are pending and therefore application for surrender cannot be processed till such cases have been settled. 9 July 2013, my lord, we informed them that the 2 writ petitions filed before the Calcutta High Court have been withdrawn. My lord, this was part of, my lord. Then 18 July 2013, my lord, in the letter, my lord, it's been wrongly mentioned as 18 June. This is 18 July. Respondent number 1 sent another letter regarding application for surrender of membership along with the documents and the check for processing fees on the ground that legal case is pending before learned Alipur court and therefore surrender application cannot. Then, my lord, 19 September, my lord, we, my lord, in the meantime withdrew, informed them. The petitioner informed respondent number 1 that suit filed before had been withdrawn and refiled the application for surrender of membership.
So everything was withdrawn?
Yes. And, my lord, petitioner sent the respondent number 1 a check towards processing fees for surrender of membership. 6 January, the petitioner inquired about minimum requirement of maintenance of fixed deposits toward security deposit. Respondent requested the respondent number 1 to keep 1 fixed deposit towards the same and release balance. Because, my lord, in any view of the matter, whether surrender allowed or not, my lord, what I had with them, because interest was no longer being credited to me, my lord, they had, my lord, in excess of what was required, my lord, by way of security. So we asked for refund. That is the prayer, my lord, in the writ petition, your lordship will find. Petitioner informed the respondent number 1 that they were unable to reconcile interest and TDS amounts of fixed deposits and requested respondent number 1 for fixed deposit by details of interest and TDS. Petitioner then, my lord, 19 January 2016. So, my lord, kindly see, my lord, we have, my lord, a series of correspondence up to 13. Then, my lord, again a 2-year hiatus. Again, my lord, we are asking, my lord, for, my lord, return, my lord, of, my lord, the excess amount. Respondent number 1 requested petitioner, I'm sorry, my lord, 19 January 2000 for release of remaining fixed deposits or release of all fixed deposits by allowing it to deposit a fresh fixed deposit of rupees 4 lakhs being minimum capital requirement to maintain the security deposit with respondent number 1. My lord, again request, my lord, 8 March 2016, 2nd September, again, my lord, request, and we are saying, my lord, what you are entitled to, will, my lord, give a fresh fixed deposit. Whatever you have, you please return. And, my lord, this goes up to, my lord, to 15th May 2000, sorry, my lord, 20th August 2018. My lord, right up to, my lord, item 44. Then, my lord, comes this letter, my lord, of 6th of September 2018, my lord, which I wish to, my lord, place before your lordships, my lord, which is page 71, my lord, of, my lord, the writ petition. My lord, this is, my lord, in response to, my lord, our letter of, my lord, 20th of August 2018. My lord, our allegation has always been, my lord, with regard to, my lord, harassment. My lord, here, my lord, now, my lord, they decide, my lord, to, my lord, take all my 2017 and 18 letters and reply to them, my lord, by this letter, again reiterating, my lord, the same allegations which they had been making. My lord, this is, my lord, in short, my lord, what this letter is. Now, my lord, we responded to it 29th November 2000 by rebutting these allegations, my lord, which are, my lord, in, my lord, the affidavit in reply to GA 1 of 2022. November. My lord, again, my lord, 3-year silence after this. Then, my lord, we again asked for release, 15 July 2021. And, my lord, once that did not happen, my lord, we, my lord, filed the writ petition, where, my lord, I placed, my lord, the orders. Now, my lord, first, my lord, I wish to address your lordship, my lord, on the decision-making process. Because, my lord, we are, my lord, in the writ jurisdiction. So, my lord, first is, my lord, on the decision-making process. Now, I will only show your lordship, my lord, the order once again. My lord, page, my lord, 155.
Yes.
Now, my lord, in, my lord, the order, my lord, first paragraph, my lord, after, my lord, the kind of preamble, my lord, there is, my lord, a reference, my lord, what they relied on. My lord, the last 3 lines of the preamble. Accordingly, the board scrutinized the following documents produced before it, before proceeding with the hearing, and also further communications regarding the same. My lord, 1B, my lord, which is the 5th line of 1, is show cause letter dated 4th March 2004, issued to Dalmia Security. So that's the letter, my lord, which I had placed, my lord, and they call it a show cause notice. And, my lord, now come, my lord, to page 168.
Yes.
My lord, just before para 1, 2, 3 at the bottom, in substance, therefore, the board of CSC orders as follows. My lord, one is, my lord, a compensation of 2.11 crores, interest on that, and, my lord, penalty. This is, my lord, my lord, whatever inspection, investigation, my lord, after show cause, this is what they've come. Now, my lord, first point, my lord, which will. My lord, the first point I'm told, my lord, which was urged before your lordship, my lord, was, my lord, that there was no show cause notice.
Yes.
My lord, which is now, my lord, 4th March 2004. I placed the letter, my lord, I've placed the letter, and, my lord, I pointed out, my lord, that there are certain allegations against me. My lord, I am asked to give documents, I'm asked to respond to it. But, my lord, it is nowhere mentioned that, my lord, what kind of, my lord, penalty or consequence, my lord, will follow if I fail to, my lord, respond, my lord, to those allegations. Now, my lord, my first submission before your lordship is, if that is the case, there is no show cause notice. And that, my lord, vitiates, my lord, the entire order. Because I must know, my lord, not only the allegations against me, but, my lord, also the consequences if those allegations are established. None of this, my lord, has been mentioned. My lord, only one case, my lord, I wish to cite on this. My lord, this is, my lord, a decision reported in 2014, 9 Supreme Court cases, page 105. My lord, kindly come to, my lord, paragraph 21.
Yes.
My lord, contents, my lord, the heading is, my lord, contents of show. The central issue, however, pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind the serving of show cause notice is to make the noticee understand the precise case set up against him, which he has to meet. This would require the statement of imputations detailing out the alleged breaches and defaults he has committed so that he gets an opportunity to rebut the same. Then, my lord, another requirement according to us is the nature of action which is proposed to be taken for such a breach. That should also be stated so that the noticee is able to point out that the proposed action is not warranted in the given case, even if the defaults breaches complained of are not satisfactorily explained. When it comes to blacklisting, this requirement becomes all the more imperative, having regard to the fact that it is harshest possible action. Now, my lord, 22 is even more important. Kindly have a look. The High Court has simply stated that the purpose of show cause notice is primarily to enable the noticee to meet the grounds on which the action is proposed against him. No doubt, the High Court is justified to this extent. However, it is equally important to mention as to what would be the consequence if the noticee does not satisfactorily meet the grounds on which an action is proposed. To put it otherwise, we are of the opinion that in order to fulfill the requirements of principles of natural justice, a show cause notice should meet the following two requirements. Namely, one, the material grounds to be stated, which according to the department necessitates an action. Two, particular penalty stroke action which is proposed to be taken. It is this second requirement which the High Court has failed to omit. We may hasten to add that even if it is not specifically mentioned in the show cause notice, but it can clearly and safely be discerned from the reading thereof, that would be sufficient to meet this end. My lord, I have placed, my lord, the letter, my lord, of, my lord, March 2004, which they say, my lord, is, my lord, the show cause notice. My lord, this cannot be found.
Neither the allegations nor the consequences.
Yes, nothing. And even the allegations, my lord, it's really, my lord, asking for further a response, so to say, my lord, rather than, my lord, imputing, my lord, that there has, my lord.
Apparently pre-allegation.
Yes,
I mean,
yes. But, my lord, I'm taking a worst case scenario that
yes.
even if these were the allegations, my lord, which have these imputations, consequence, my lord, it's completely, my lord, silent. Now, my lord, the second, my lord, aspect, which, my lord, has, my lord, is, my lord, important, my lord, is, my lord, the, my lord, committee, my lord, which, my lord, decided this.
Has no power of penalty to impose penalty. That argument was.
No, my lord, I am, my lord, yes, different argument, my lord, I'll come to that, my lord, on, my lord, whether.
Yes.
My lord, the, my lord, committee, my lord, has to be constituted under Regulation 23 of the Stock Exchange and Clearing Corporation Regulations 2018. Now, my lord, kindly have a look at. What have you done? Full thing, really? That's okay. No, show me the, who were the committee there.
Page 160.
Now, my lord, kindly have a look at, my lord, page 168, my lord. My lord, kindly see, my lord, who are, my lord, the persons here who have signed, my lord, this order.
Yes.
My lord, one is, my lord, Chako Joseph, director. Second is Gautam Ganguly, director. And third is Anindo Mojumdar, chairman. Now, my lord, kindly take at page 173. Kindly see, my lord, their designation. They are all, my lord, public interest directors. My lord, which
shareholder director or
yes, my lord, I want to now show your lordship, my lord, Regulation 23.
Right.
My lord. My lord, composition of the governing board. The governing board of every recognized stock exchange and recognized clearing corporation shall include, well, there's a mandate, shareholder directors, public interest directors, and managing director. Subject to the prior approval of the board, the chairperson shall be elected by the governing board from amongst the public interest directors. The number of public interest directors shall not be less than the number of shareholder directors on the governing board of a recognized stock exchange and recognized clearing corporation. And the managing director shall be included in the category of shareholder. So, my lord, we have a case of, my lord, 3 categories of directors. Public interest director, my lord, is the chairman. Managing director, my lord, is a shareholder director. And, my lord, as far as this committee is concerned, my lord, it didn't even have, my lord, a shareholder director. The stock exchange did not have. They appointed straight after. Straight after. After, my lord, the interim order in this case, my lord, your lordships will find that in the affidavit in reply, my lord, to, my lord, the, my lord, GA at page 43.
Yes.
My lord, kindly see page 43. My lord, others, my lord, who, my lord, come in, my lord, 27th May 2022, Abhiroop Sarkar, my lord, comes in, my lord, as, my lord, a director. He's a shareholder director. We've pleaded that, my lord, in our affidavit. That this person, my lord, was, my lord, the shareholder director, which your lordship can find, my lord, in the affidavit in reply. My lord, I'll just give your lordship, my lord, the paragraph. But the fact of the matter is there was, my lord, there was no shareholder director, my lord, on the date, my lord, that, my lord, the order was passed. Now, my lord, the third point. My lord, in, my lord, the impugned order, my lord, which starts from, my lord, 155, lordship will again kindly turn to, my lord, that paragraph 1 and see item C, which is 7 lines from the start, is an inspection report.
Yes.
Now, my lord, this inspection report, my lord, is, my lord, referred to, my lord, and, my lord, is the basis, my lord, of, my lord, the, my lord, not only, my lord, according to them, the show cause notice, but, my lord, also, my lord, the findings. My lord, kindly see, my lord, page 156, my lord, my lord, third last paragraph, last sentence. The inspection report became the basis on which a show cause was issued to Dalmia on 4th March 2004. No mention of, my lord, that in the show cause though. But, my lord, it's stated here. Then, my lord, kindly come to, my lord, the next para, last sentence. Board has also perused the report of the inspection team in totality. Then, my lord, the next para. The board noted that the report of the inspection team categorically stated that so-and-so had entered into so-and-so with so-and-so. Then, my lord, kindly, my lord, my lord, right through, my lord, I'll give your lordships another example. My lord, page 158. My lord, fourth line from a fourth para from the top. It is revealed from the inspection report. Then, my lord, next para, it was also observed from inspection report. Then, my lord, paragraph following, my lord, it is also revealed from inspection report, etc., etc. Now, my lord, kindly see, my lord, page 160, where we have the decision. My lord, decision with reasons. Kindly come to the second paragraph. Therefore, the board considered the observations and findings made by the inspection team of CSC relating to so and so. Then, my lord, kindly turn over, my lord, page 161. Issue number 1. Kindly see the issue whether Dalmia Securities Private Limited had entered into any off the flow transactions and negotiated deals which are not reported to the exchange, which was contravening SEBI circular dated so and so and circular number so and so and CSC noted. Then, my lord, the details of as received was communicated with a letter of 4th March. This is the show cause. And then, my lord, accordingly, it is apparent from what? The inspection report that an amount of so and so, so and so. Again, my lord, inspection report. Then, my lord, 163, issue 2. Whether Dalmia Securities Private Limited had received and paid huge funds from different defaulting members in violation. It is evident from inspection report, etc. Then, my lord, kindly come to 166. This is that Doge, my lord, John Doe, my lord, Doe. Yes,
Doe Jones.
Doe Jones, my lord, kindly see. My lord, 166, 4th paragraph, my lord, just above the table. Inspection team also observed that transaction so and so. Then, my lord, so, my lord, the entire order, my lord, is based on, my lord, the report, my lord, the inspection report, which was, my lord, not given. Now, my lord, your lordships may note one thing, admitted position. It is not being given, my lord, in their affidavit. Now, before affidavit, give the other documents and we'll deal with which were also not given. Yes, now, my lord, kindly have a look at, my lord, in, my lord, the affidavit in opposition to the GA. My lord, they've come forward, my lord, and disclosed that there were more documents which they relied on. My lord, para 19, page 27.
Yes.
My lord, about 10 lines from the start. My lord, or rather 12, the documents relied upon and perused by respondent number 1 before passing the order dated so and so are annexed here to and collectively marked so and so. Such documents demonstrate, etc., etc. Now, what are the documents, my lord, which they rely on? Kindly take, my lord, annexure R6, my lord, which starts at page 96 of, my lord, that very affidavit. All these documents, my lord, have been relied on.
Yes.
Now, my lord, kindly note one thing. These documents are not even mentioned in the order, not in the show cause, and in the affidavit they say that over and above that, my lord, this is what they relied on. It's not there in the show cause, not there in the order. My lord, order your lordship seen, my lord, at page, my lord, 155. They give a list of what they relied on. My lord, none of this, my lord, is mentioned.
Yes.
So, my lord, in my respectful submission, my lord, the inspection report, my lord, which was available, my lord, even before issuance of the letter of 4th March 2004, was not even disclosed, my lord, in my lord, the letter of 4th of March 2004. Similarly, my lord, these documents, my lord, which my lord were relied upon, my lord, were, my lord, also prior to that, no mention. And my lord, the 96 onwards, my lord, those documents, as well as, my lord, the inspection. We don't have the inspection report even today. But, my lord, it has, my lord, been relied upon. And, my lord, mentioned in the order that it's relied on. And, my lord, the other documents, not mentioned in the order that's relied upon, but on oath, they say we relied on this at the time of. So, my lord, that itself, my lord, on its own, my lord, vitiates, my lord, the, my lord, entire order, because material has been relied upon, which has not been made available to me. And, my lord, when passing an order, which has civil consequences, my lord, insofar as, my lord, the writ petitioner is concerned. My lord, just, my lord, now that's on a different. My lord, just one case. My lord, these I'm just giving the, my lord, this is, my lord, Kavi Arora's case versus SEBI. My lord, this, my lord, 2022 SCC online, SC 1217.
Yes.
My lord, kindly take, my lord, paragraph 24. My lord. Not 24, my lord. I'm sorry, my lord. My lord, we have a better case. Here, my lord, documents were relied on, my lord, in the show cause notice, but were not made available. Here, my lord, is not relied on, and yet, my lord, relied on, my lord, in the order. Mr. Luthra submitted the documents, para 27. Relied upon by respondent, and show cause could not be denied to the petitioner in support. So, Takano, my lord, again, my lord, a SEBI case, my lord, which has, my lord, been cited. Kindly take para 32. My lord, this is on formation of opinion, which I was, my lord, also indicating, my lord, that there is a pre-allegation stage. But, my lord, assuming, my lord, it is also, my lord, allegation. Now, kindly come to, my lord, para 34.
Yes.
In Takano, cited by Mr. Luthra, this court, relying upon its decision in Natwar Singh, held the submission of Mr. C.U. Singh, learned senior counsel, is that only those materials which are relied upon should be disclosed to the first respondent. Regulation 10, as we have noted earlier, stipulates that the satisfaction of the board, whether there has been a violation of regulations, has to be arrived at. After considering the report of investigating authority referred to in Regulation 9, and after giving a reasonable opportunity of hearing to the person concerned. Once the subordinate legislation mandates that investigating authority's report is an essential ingredient for the board to, it requires due disclosure. The above extracts indicate that findings of are relevant for the board to arrive at the satisfaction of, even if it is assumed that report is an interdepartmental communication as held in the, there is a duty to disclose such report if it is relevant for the satisfaction of the enforcement of determination. As held by this court in Takano, it would be fundamentally contrary to the principles of natural justice if the relevant material were not disclosed to the noticee. Takano, the court approved and followed the law laid down in Natwar and directed that adjudicating authority had the duty to disclose the material that had been relied upon during the stage of adjudication. It is also true that adjudicating cannot exercise, authority cannot exercise unfettered discretion to redact documents. Of course, there had been redaction there, my lord. No, para 51. Yes. My lord, kindly take, my lord, para 51. my lord, at my lord page PDF page 10, my lord, if your lordship kindly turn to.
Yes.
In the event petitioner is prejudiced by reason of any adverse order based on any materials not supplied or any prejudice is demonstrated to have been caused to them, be open to approach. My lord, of course, this was, my lord, at the show cause stage when documents were not being given. Said, no, you have to give the document. But if anything is left out, then, my lord, this right, my lord, is there. Not turn আজকে আসবে না চিন্তা করো। Now, my lord, I come to, my lord, the, my lord, 6 lakh penalty, my lord, straight away. My lord, 168. This is again, my lord, procedural, my lord, point. 168. My lord,
Yes.
Yes, my lord, kindly take the second paragraph. The board also decided to impose penalty of 6 lakhs for its off-market deals, fund-based activity, and also for other violations as detailed here and above. This penalty of 6 lakhs will be transferred to the Investors Protection Fund of Calcutta Stock Exchange. The board has decided to pass the aforesaid order against Dalmia Securities in terms of CSC's inherent rights under various acceptable rules, regulations, and bylaws thereof. However, insofar as the dereliction of duties and statutory breach of rules and regulations framed by SEBI by Dalmia, the board of CSC had decided to forward its findings to SEBI for appropriate action to be initiated against so-and-so. In substance, therefore, the board of CSC orders as follows. My lord, 1 and 2, I'm not, my lord, troubling your lordship with now. Penalty of 6 lakhs in line with the decision of the Disciplinary Action Subcommittee at its meeting held on 24th May 2008. So, my lord, Disciplinary Action Subcommittee, my lord, had taken a decision for 6 lakhs. Our specific cases, my lord, no notice of any proceedings before, my lord, the Disciplinary Action Subcommittee. Second, my lord, not made aware, my lord, of this decision. Third, my lord, the decision, my lord, has not been communicated. My lord, to, my lord, the writ petitioners at any point of time. So, my lord, there was no occasion, my lord, to deal with this, my lord, before, my lord, the board, my lord, who was claiming, my lord, to be, my lord, investigating this issue. And, my lord, fourthly, as I said, my lord, the show cause notice doesn't even mention, my lord, the consequences, which would include, my lord, the penalty, my lord, and therefore, my lord, this is, my lord, wholly, my lord, without jurisdiction, number one. Number two, my lord, is on the face of it, my lord, contrary to the principles of natural justice, which warrants, my lord, vitiation, my lord, of, my lord, this order. Then, my lord, yes. Now, my lord, the decision your lordships will find that, my lord, all the material, my lord, which has been relied on is, my lord, prior to 19th April 2004. My lord, for, my lord, this, my lord, the imposition of penalty and, my lord, directing, my lord, a compensation of 2.11 crore. So, my lord, the decision comes, my lord, after, my lord, 18 years. The only interdict, my lord, to the decision, if, my lord, we go by the common case, that, my lord, inspection, my lord, had been, my lord, stopped, my lord, by virtue of an interim order. My lord, your lordships will find that, my lord, in the list of dates again. My lord, in 2004, serial 26, my lord, 2004.
Yes.
My lord, that's why I requested, my lord, if they have a copy of that order, but my lord, it's common ground, my lord, that's how we are proceeding. We've gone on the basis of a noting, but there's no order. My lord, in 2013, at serial, my lord, 35, my lord, the suit itself, my lord, had been, my lord, withdrawn. So, my lord, it's, if, my lord, there was, my lord, an interdict at all, my lord, it was, my lord, 9 years. For, my lord, for them, my lord, to, my lord, pass, my lord, this order. My lord, there was no interdict, my lord, after, my lord, 9 years. In fact, my lord, on the material, according to them, the disciplinary action committee, my lord, had already, my lord, decided, my lord, on 24th of May, 2008. And that is what has been, my lord, accepted, my lord, by, my lord, the board. This is, my lord, the position. Now, my lord, if there is, my lord, such delay, my lord, there are two, my lord, cases, my lord, of our High Court, my lord, which I wish to rely on. My lord, one is, my lord, no. You have two copies. My lord, the first decision, my lord, I wish to rely on, my lord, is 2018 SCC online. Even Origin Banerjee is 2018 SCC online, Calcutta 2937.
Yes.
My lord, kindly take paragraph 17. My lord, Andhra Pradesh, in state of Andhra Pradesh, a registration is challenged on the ground there was delay on health, take into consideration all relevant factors and has to balance and weigh them to determine if it is in the interest of clean and honest administration, the disciplinary proceeding should be allowed to terminate after delay, particularly when delay is abnormal and there is no explanation for the delay. The delinquent employee has a right that disciplinary proceedings against him are concluded expeditiously and he is not made to undergo mental agony and also monetary loss when proceedings are without any fault in considering whether delay, etc. Then, my lord, state of Madhya Pradesh, the next one, my lord, is also disciplinary. Then, my lord, Mahadevan was also, my lord, employee, my lord, case. Then, my lord, 20. The decision in Government of India versus Citadel Fine Pharmaceuticals Madras, in my opinion, is not very relevant for the facts. In that case, Rule 12 fell for consideration. It was held that did not prescribe any period of limitation for recovery of any duty. That by itself did not render the rule unreasonable, etc. Every authority is entitled to exercise power. Then, my lord, 21. In Mehrotra, an enforcement directed show cause notice was issued for alleged violation of certain hearing commenced on so-and-so. Petitioner challenged show cause notice of hearing on the ground of delay in commencing proceeding. High Court allowed writ petition, striking down and quashing, holding there was no explanation for delay in adjudication. It was further held that writ court should exercise jurisdiction and be unfair to relegate the petitioner to remedy available under relevant enactment. Then, my lord, similarly, my lord, these are all, my lord, based on, my lord, speedy trial. Then, my lord, kindly come to para 32. My lord, kindly see how the facts, my lord. coming to the facts of the present case, the show cause notice was issued on 14 January 1991. It was replied to by the petitioner on 15 February 1991. In the reply, my lord, the stand, my lord, which has been taken. My lord, kindly take the last 3 lines on that page. The first notice of hearing was issued on 19 November. That is almost 9 years after issuance of show cause. Petitioner's advocate sought for adjournment on the hearing that learned advocate who was handling the case was out of India and would return. This was followed by a letter of 12th, etc. Now, para 33. It will be seen from the facts noted above that the first notice of hearing was issued almost 9 years after issuance of show cause. Petitioner contended that unless copies of relevant documents relied upon were supplied to him, he would not be able to defend himself meaningfully at adjudication. There is nothing on record to show that authorities supplied copies to petitioner. There is not even such an averment in the affidavit filed by the respondents in this proceeding. Respondents remain completely silent after issuance of notice of hearing. Several letters were written by petitioner or his advocates between so and so. There is nothing on record to show that same was replied to. 16 years after 1999, a notice of hearing was dated 13th February 2015 was issued upon the petitioner expressing his inability to attend such hearing in the absence of copies of relevant conduct. The respondents make clear they were serious about adjudication against. Nonchalance is writ large on the demeanor of the respondent, as on date of filing of writ petition, 24 years had elapsed since issuance of show cause notice. Not a single hearing was held, etc. And here, my lord, the notice said you provide all this. There was not, my lord, that as if an adjudication.
As such or
As,
hearing.
correct. Now, my lord, and then, my lord, they again write for the same documents in 18. Though all documents according to them were available for the disciplinary action committee, my lord, to take a decision in May 2008. And my lord, all the correspondence which has happened, kindly note one thing, my lord, this disciplinary action committee, my lord, having formed an opinion that a penalty should be imposed, my lord, for, my lord, 6 lakhs in 2008, not disclosed. It comes, my lord, in the order. So, my lord, here, my lord, there's no explanation, my lord, as to why, my lord, having had, my lord, the disciplinary action committee, having gone into the matter, my lord, that, my lord, they have, my lord, needed to do anything more, my lord, and my lord, I've shown your lordships, my lord, the gaps, my lord, in my lord correspondence. Yes. And then, my lord, 2018, suddenly, my lord, they surface. And again, my lord, there is a complete, my lord, if I may use the expression, quietus, my lord, till, my lord, 2022. It is also. No, what for? That kind of same. My lord, this has also been, my lord, really, my lord, followed, my lord, by, my lord, another decision of the Calcutta High Court.
Delay or non-service of copies?
Yes, delay.
This is settled.
Then, my lord, now, my lord, kindly take, my lord, the Securities Contract Regulation Act. Section 6(3). Compilation e ki ache daro one by one na diye dekhao ekbar compilation.
Solve the bylaws and
We'll be relying on all of them.
yeah, we've separate copy.
Oh, you have. My lord, would your lordships like, my lord, a compilation of all the, because I've handed up one, my lord, if, because I have, yes, my lord, I have, my lord, on.
You have already handed up copies.
No, that's one. My lord, there are about 7 or 8 which I'm going to rely on to show, my lord, that this falls foul, my lord, of, my lord, statutory provisions as well.
I've taken my notes on these.
Very well,
but
my lord.
from these, the others you can file a
No,
complaint.
I'll give it, my lord, one by one then, my lord.
Compilation also you can file, no difficulty.
Oh, Coroni. My lord, I'll get it done, my lord. I'll get it done because I got one done for myself at home. My lord,
Then
because
please get it done for the others. I mean, except the
yes,
ones
yes,
you have
of
cited.
course.
No, not for them. I mean, the other judgments.
Yes,
3 you have cited already.
yes, my lord, those are judgments. My lord, I am on, my lord, the statute law and my lord, subordinate legislation.
For that I'll be requiring a compilation.
So I'll do that,
That will
my
be
lord.
seen.
I'll do that. My lord, securities contract regulation.
That Mr. Rai will find out his own copies from the internet. He need not give a copy
My
to them.
learned senior wants
These are
to do-
statutes.
And if he wants to help.
He has already done sufficiently gratis, I mean, for the last few years.
My lord, my learned friend would say so is he.
A few more months.
Yes. You're still there.
But my lord, I had the.
My lord,
a few.
my lord, frankly, I gave up. My lord, it was.
Yes, obviously. We saw it on the YouTube.
My lord, just.
No, yeah, we can fully appreciate.
But my lord, kindly don't believe the rumors. My lord, the rumors.
Yes.
Yeah, I'll go by the book. I'll give one. My the book. Securities contract regulation.
The securities contract sex.
Yes, your
on the
lordship.
last occasion.
Oh, very well, very well.
Yes, you are citing.
My lord, kindly keep that, my lord. That's. My lord, kindly come to. My lord, section 6. Subsection 3, my lord.
Yes.
Without prejudice to the provisions contained in subsections 1 and 2, the Securities and Exchange Board of India, if it is satisfied that it is in the interest of the trade or in the public interest so to do, may by order in writing, my lord, kindly come to B, appoint one or more persons to make an inquiry in the prescribed manner in relation to the affairs of the governing body of a stock exchange or the affairs of any of the members of the stock exchange in relation to the stock exchange and submit a report of the result of such inquiry to the Securities and Exchange Board of India within such time as may be specified in the order or in the case of an inquiry in relation to the affairs of any of the members of a stock exchange, direct the governing body to make the inquiry and submit its report to the Securities and Exchange Board of India.
You showed me something regarding the for apart from those few people, apart from those 24.
Yes. So, my lord,
was
that
there.
my lord, that is my lord different. That is my lord another point. My lord, that if the board is deciding, then my lord, it has to have my lord a shareholder director.
Right.
My lord, everybody can't be public.
Maybe apparently for these inspections regarding you and some others.
Correct, correct. That's the letter.
CSC
That's why I'm showing your lordship this.
Yes. All right.
My lord, assuming, my lord, as they say,
Yes.
that was the genesis of the show cause.
Right.
So it started, my lord, under this. This is the
Yes.
power, my lord, which is, my lord, being exercised. Now, my lord, kindly come to, my lord, the rules. Rules here.
Rules are also here. Yes. These are the regulation appeal to security.
No, the Securities Contract Regulation Rules 1957.
No, I'll need a copy. I'm sorry.
My lord, kindly make a note, my lord. It is Rule 11 and, my lord, Rule 16. My lord, kindly take Rule 16 first.
Yes.
The person or persons, I'm sorry, my lord, appointed by the Securities and Exchange Board of India to make an inquiry under Clause B of subsection 3 of Section 6 of the Act shall hereinafter in this rule be referred to as the inquiring authority. Where the inquiry authority consists of two or more persons, one of them shall be appointed as the chairman or senior member thereof. Then C, the inquiring authority shall hand over a statement of issues to be inquired into to the governing body or the member concerned, as the case may be, who will be given a reasonable opportunity to state their or his side of the case. If any witness is called for examination, an opportunity shall be provided to the governing body or the member whose affairs are being inquired into, as the case may be, to cross-examine such witness. Where the inquiring authority consists of more than one person, the views of the majority shall be deemed to so and so. Then, the inquiry authority shall submit its report in writing to the Securities and Exchange Board of India within the period specified in the order of appointment. Then, my lord, 2, where the Securities and Exchange Board of India has directed the governing body of a stock exchange to make an inquiry under clause B of so and so, the governing body, kindly note this, shall appoint one or more members to make the inquiry, and the provisions of sub-rule 1 shall apply mutatis mutandis to such inquiry. So if the letter is to the governing body, you inquire, then, my lord, they have to, my lord, form a committee, my lord, to, my lord, do that. And, my lord, to do that, my lord, governing body itself, my lord, has to be properly constituted. My lord, this constitution of the committee, my lord, is completely absent in this case. Now, my lord, kindly come to 11.
Yes.
After receiving the, I'm sorry.
Got it? Yes.
After receiving the report of the result of an inquiry made under clause B of subsection 3 of section 6 of the Act, the Securities and Exchange Board of India may take such action as they may deem proper, and in particular may direct the governing body of the stock exchange to take such disciplinary action against the offending member, including fine, expulsion, suspension, or any other penalty of a like nature, not involving the payment of money, as may be specified by the Securities and Exchange Board of India, notwithstanding anything to the contrary contained in the rules or bylaws of the stock exchange concerned, the governing body shall give effect to the directions of so and so in this behalf, and shall not in any manner commute, revoke, or modify the action taken in pursuance of such direction without prior approval of so and so. The Securities and Exchange Board of India may, however, either on its own motion or on the representation of the member concerned, modify or withdraw its direction to the governing. Now, my lord, this, my lord, is, my lord, the issue, my lord, of competence. Because if it has come under this, my lord, before any action could be taken, my lord, SEBI, my lord, would have to consider their report.
Yes, SEBI has let you off in a...
My lord, yes, that's another point, my lord, which I will show, my lord. But, my lord, assuming, my lord, that was independent of this,
yes,
then, my lord, the report has to go to SEBI, and SEBI will then say, this is the disciplinary action you initiate against them in respect of these allegations.
Including penalty and all.
Yes. And, my lord, kindly note that this, my lord, this is notwithstanding anything to the contrary contained in the rules or bylaws. My lord, this is, my lord, the procedure, my lord, which, my lord, is required to be followed. There has to be a consideration, my lord, by SEBI that a disciplinary, my lord, proceeding has to be initiated, which, my lord, there it's completely, my lord, silent. My lord, we have nothing to show that has happened. Huh? Yes, I will. Now, my lord, I want to, my lord, go into, my lord, the order itself. The challenge, my lord, is, my lord, that there has been, my lord, on the face of it, which I intend to show, my lord, I will first deal with the finding, my lord, of synchronized trade with, my lord, Dow Jones, which is, my lord, separate to, my lord, off the floor transaction, funded transaction, and other violations, to which, my lord, the penalty relates of 6 lakhs. Now, my lord, kindly have a look, my lord, at, my lord, the so-called notice again. What are you doing? What are you talking? Give me the first show cause, 4th March 2004. Is 174. Yes. Sorry. Now, my lord, kindly take, my lord, page 178. Paragraph 7.
Yes.
So, my lord, I'll just indicate the grounds. My lord has failed to take into account, my lord, relevant considerations, and my lord has, my lord, failed to take into account the relevant, my lord, statutory provisions. And when I say statutory, I mean also, my lord, the subordinate legislation. Now, my lord, kindly take, my lord, 7. This is in the so-called, my lord, show cause notice. Page 178. You have sold 149980 equity shares of HFCL, my lord, that's Himachal Futuristic, to Dow Jones Investment and so, in the CSA system on 9th March 2001. Now, my lord, kindly note this. With an intention to defraud the SGF, that's, my lord, Settlement Guarantee Fund, because, my lord, the stock exchange, my lord, has its own clearinghouse. My lord, being one of the older exchanges, my lord, the function of, my lord, providing an incidental function of providing a market was also to provide a clearinghouse. That's, my lord, what the Supreme Court said in 1960. My lord, after now, my lord, there's a requirement, my lord, under, my lord, SEBI regulations to have, my lord, a clearinghouse and, my lord, market, my lord, separate, the exchange separate, which, my lord, is the subject matter of challenge, my lord, in one of the writ petitions which have been. With an intention to defraud the Settlement Guarantee Fund of the exchange, knowing fully well that the purchasing broker will not be able to fulfill its obligation at the time of paying of such securities, which was executed in the system with a pre-negotiated arrangement. In this process, Dow Jones Investment and so suffered to the tune of 2.11 crore, which was ultimately drained from SGF through this collusive trade, which is non-bona fide in nature as per exchange bylaws. So, my lord, kindly see what, my lord, the allegation is. You knew, you were the seller, you knew that Dow Jones will not be able to make the payment of the purchase price. Number 2, the Dow Jones would therefore suffer to the tune of 2.11 crore, which is the difference, because, my lord, it not being able to meet, the shares were sold. Stock exchange only recovered, my lord, X amount. 2.11 crore remained to, my lord, be recovered. So, my lord, this was a...
suffer? How did Dow Jones suffer?
My lord, that's exactly, my lord. Your lordships, my lord.
I don't know so much about...
No, Dow Jones has not suffered. Because, my lord, there is a settlement guarantee fund.
Yes.
Now, my lord, Dow Jones, my lord, is unable to pay. My lord, then, my lord, the money has to be, my lord, paid out,
Yes.
my lord, from the settlement guarantee fund.
Right.
When it is paid out of the settlement guarantee fund, what was sold to Dow Jones,
yes,
my lord, the stock exchange can then sell.
Right.
And my lord, recover, my lord, for my lord, the stock, my lord, the settlement guarantee fund.
Yes.
My lord, to
It rather reverts back to the
correct,
status
correct.
quo.
Like my lord, a guarantor, my lord.
Yes,
It
yes.
comes, my lord, comes back.
Yes.
My lord, what happened according to them and for which, my lord, there is no mention here. Kindly see the allegation. That, my lord, I would have also known that, my lord, when Dow Jones failed to make payment, the stock market price of these shares of Himachal Futuristic would be on a downward spiral. So, my lord, when stock exchange sold, they would not be able to recover.
Very futuristic of Himachal.
Yes, and futuristic of me, but there's no allegation here that, my lord, I knew. So, my lord, I was privy.
That has to be read in between the lines that the shares would fall, the price of the shares would fall.
Yes, it has to be because, my lord,
Otherwise, there would be no loss on the.
Yes, otherwise nobody would suffer loss.
Very well.
My lord, so, my lord, there and my lord here, my lord, what is important, my lord, is that, my lord, to make this allegation, because what am I meeting here? I knew that Dow Jones would not be able to. So
loss was to the tune of 2.11.
The difference. Difference, my lord, what was
What
recovered?
is being attributed to you is that your previous knowledge about this
Has to be, otherwise, but it's not. Here, my lord, it's saying you knew Dow Jones would not be able to pay.
Yes.
And who suffered loss? Dow Jones suffered the loss.
That is what I was.
Yes. My lord, that's the most important. And, my lord, which was ultimately drained from SGF through this collusive trade. My lord, if someone can't pay, my lord, then he has to suffer, my lord, for not paying if there is a legal obligation. But, my lord, if, my lord, this payment is not made and under the rules and regulations, my lord, it has to come out of the settlement guarantee fund, which then is to be recouped. Because
they are saying that you drained the SGF basically.
This transaction drained the SGF.
Yes. But then it has to be your prior, you have to have prior knowledge.
Correct, absolutely.
This would fall
it will fall. I must know.
Then they have to indicate probably the indicators at that point of time, which you might have had
Correct.
regarding
To
Dow
know.
Jones's
Yes.
purchasing.
Yes. So, my lord, I must have, my lord, price sensitive information.
Right. Right.
Which means, my lord, there has to be an element of insider trading.
Yes.
So, my lord, either, my lord, that can be if I am, my lord, in the management, my lord, of, my lord, Himachal Futuristic. No such case. My lord, this is para 7, my lord, is, my lord, the case, my lord, which has been run. You sold, my lord, I have a right to sell.
Yes.
I have sold. Dow Jones, my lord, let us say, my lord, we had a negotiated deal that we were going to sell. Fine. But, my lord, for me to cause loss to the settlement guarantee fund, I must have had knowledge. And that has to be spelt out, my lord, in the show cause. That you knew the price was going to drop. Not merely that Dow Jones may not have the capacity to pay. I knew the price was going to drop, and therefore settlement guarantee fund, when the payment is made to me, settlement guarantee fund people cannot recover the full value of the payment made to me. Now, if it had gone up.
So Dow Jones not paying, there's a security net for that. The SGF can recover.
Yes.
But the determinant is whether those prices will fall.
Yes.
Which you are
Yes,
talking.
correct. Because otherwise, my lord, all clearing houses
it has to go through.
Has that, my lord, settlement guarantee fund. Yes. My lord, there's a requirement, my lord, in the rules that whoever transacts, my lord, because settlement happens at the end of the day or, my lord, within 2 days. So there's sufficient funds even if there is a, my lord, shortfall, which, my lord, can be resorted to. There was enough funds. There was no problem, my lord, with the funds being there. They are saying no, but we couldn't recoup what we paid out because the prices fell.
Yes.
And this was the difference.
Right.
But, my lord, for, my lord, a wrongdoing on my part, my lord, under the rules and regulations, my lord, I have to know, my lord, that I have to have price sensitive information that this is, my lord, going to fall. Because merely by saying, oh, look, the deal was, you told them, it's known as, my lord, 1, 2, 3. That's the allegation I'll show. 1, 2, 3, I press the button for sale. They do 1, 2, 3 and press the button for buy. So it matches, goes through. When the settlement happens, it's not there. The money on the part of Dow Jones, settlement guarantee fund pays out. Next consequence is when they seek to recover from those shares, catch hold of those shares and seek to recover it, they make, the prices have fallen. So, my lord, to impute, my lord, any wrong.
Say the least, I mean, the allegations were not sufficient. At least
Not at all.
on insiders
Not at
trading
all.
or
Correct.
prices.
Nothing. And then, my lord, so the first submission I made, that's why I started from the show cause notice, is on the face of it, my lord, this allegation does not fall, my lord, within, my lord, any of the, my lord, prohibited acts under, my lord, SEBI regulations or, my lord, any prohibited act under the SEBI Act.
Right.
May I stop here today,
Yes,
my lord?
Tomorrow let it remain in the list tomorrow. Tomorrow it won't be taken up. So whenever it's free.
It's completion, not competition. Completion of 50 years.
Before rising of your lordship, may I be permitted to mention one extremely urgent matter, lordship. Today, lordship is direct to the matter be the top of the list at tomorrow. Item number 32, lordship. Kindly, it is be top of the list tomorrow, lordship.
You just said matter?
No, lordship, it is appellate side, man.
Appellate said I cannot take up the. This will appear in the upgraded list that I have directed. I have directed.
Lordship, much of